filed until plaintiffs rested, obviously.
Understood.
So,
And Your Honor, just do want to note for the record, this is the first time we are seeing the motion. It was not served on us until just now.
All right, understood. That's fine. Go ahead.
so, Your Honor, for Claim 1, there's several grounds. Claim 1 should be dismissed. Probably the easiest one that the court can rule on right now is the state is, in fact, immune from suit under Claim 1. That issue has not been waived. It was raised in our answer, and the state of Idaho is, in fact, immune from suit. In fact, this court ruled on a very similar issue in another case that the state of Idaho, in that case, the Department of Education, was immune from suit on a case seeking statutory interpretation of the statutes at issue in that place. I was just informed that I said closing argument. I'll apologize. This is a motion to dismiss. So
You did say that, but I knew what you meant, which is this is effectively well, you said it's a Rule 41b2 motion.
Correct, yes. Thank you. I apologize for misspeaking. So the state is immune from suit on Claim 1. It has not been waived. We raised it in the answer. We have been arguing from the very beginning of this case that the court lacks authority to rule on Claim 1, and in fact, in the motion for summary judgment, it appeared, from all arguments that have been made in the complaint that Claim 1 was derivative of Claim 3, that it was not, in fact, a separate claim. It was at summary judgment that plaintiffs confirmed that said, no, Claim 1 is standalone. It does not depend upon the constitutional claims in Claim 3. Claim 3 is not subject to sovereign immunity, so it's at that point that we raised the sovereign immunity issue in our opening trial brief in this case. Further, there is clear Idaho Supreme Court case law that the Attorney General lacks the authority to waive sovereign immunity, even if the court were to say that we did something to waive sovereign immunity. According to Idaho Supreme Court case law, the Attorney General lacks that authority to waive the state's sovereign immunity. And then the Attorney General, the court had commented on perhaps the Attorney General should not have been dismissed. The Attorney General is also immune from suit. We cited a case for that proposition. That's Peterson versus Bannock County, a 1940 Idaho Supreme Court case. Claim 1 is also unripe, and they are seeking an improper declaratory judgment claim. It is not ripe simply because there must be an actual or justiciable controversy. And in this case, they have not presented, plaintiffs have failed to present anything other than just simply hypothetical facts. They're saying, we want the court to rule on all of these hypothetical facts, these hypothetical conditions that might happen to somebody in the future. That is the very nature of an unripe claim in this case. And so for that reason, Claim 1 is not even ripe. Plaintiffs lack standing. We made that argument in the motion for summary judgment. Now at trial, the plaintiffs have the burden of proving that they have standing by a preponderance of the evidence. I will not repeat all those arguments, but they have failed to prove that they do in fact have standing. And so for that reason, all claims should be dismissed. For Claim 1 on the merits, the plaintiffs are asking the court to rewrite the law. That's not what a declaratory judgment claim allows. They're asking this court to rewrite that law. We heard that over and over from their questioning, from their witnesses, from their expert witnesses. They're asking the court to put in exceptions in the law that do not exist. That is not the role of a declaratory judgment action, and so therefore the court should dismiss Claim 1, Claim 1 on the merits. Excuse me. For Claim 3, if the court gets to the merits on Claim 3, plaintiff's action is, again, foreclosed by the Planned Parenthood case. There is no right to abortion anywhere in the Idaho Constitution. It doesn't matter how you delineate it, what you call it, how you try to hide it, where you try to throw it in. Planned Parenthood case ruled definitively there is no right to abortion. They explicitly rejected the dissent's argument in that case that there is a right to abortion to protect the health of the pregnant woman. And that is exactly what the plaintiffs are arguing for here, is that there is an explicit right to abortion to protect her health. That claim, that argument is foreclosed by the Planned Parenthood case. As a hybrid at best, facial as-applied challenge in this case, they have to prove that the law is unconstitutional in every circumstance of the claims that they are presenting to this court, and they are simply not unconstitutional. The fact that Idaho's laws allow abortions to prevent the death of the pregnant woman shows exactly that they are not unconstitutional in those circumstances. The fact that abortion is not required in every circumstance that they are required shows that it is not facially unconstitutional, that they cannot show that it is unconstitutional in every circumstance, and it does not infringe on a constitutional right. Dr. Withicombe's testimony about the history and tradition of Idaho is just simply not credible, and it directly contradicts the Idaho Supreme Court case in Planned Parenthood. And then even if the court finds that you have to go to the next level, it passes rational basis scrutiny, it passes strict scrutiny. Planned Parenthood is clear that these pass rational basis is just another standard regulation of a health and safety regulation. For strict scrutiny, you have heard over and over again of the compelling interests that the state of Idaho has. You have heard plaintiffs' own witnesses testify that a doctor has two patients when treating a pregnant woman, the pregnant woman and the fetus, and that medical ethics require that you do no harm to both patients. You've heard that an abortion in every situation results in the death of the unborn life. You have seen text messages from their expert witnesses disparaging disabled babies and showing the need for these laws to prevent discrimination on the basis of disability. You have heard that abortion poses risk to maternal health and safety from their own experts. And you have heard of the barbaric medical procedures that are involved in abortions. Idaho's laws advance and are narrowly tailored to advance those compelling governmental interests. So for all those reasons, the plaintiffs have failed to show that the law and the facts entitle them to relief. So we'd ask that the court dismiss it under Rule 41B2. Thank you.
All right. Thank you, Mr. Craig. Now, I've tipped my hand before hearing from Mr. Craig that my inclination is to let it ride, and that is less a comment on the merits and more a comment on the impracticability of rendering a dispositive ruling here and now based on the fairly complicated issues raised in the Rule 41B2 motion. Were we to, say, be about to hear 2 or 3 weeks of evidence from the state in response to the case presented by the plaintiffs, there may be it may in that setting be worthwhile to recess the trial and try to pour through these issues, have an orderly argument on them, and a ruling on them before the state presents its case. My understanding, though, is that the state's case is expected to be presented in less than an entire trial day, or at least by the end of the day today. And given that, it makes a lot more sense to me to simply permit simply require the state to present whatever evidence it intends to present in opposition to the plaintiff's case and render a ruling on a full record at the end of the trial. Now, whether that amounts to, I guess, denying this motion or just simply not passing on it until the end of the trial, I suppose it could be either of those things, and the distinction is irrelevant. But I'll invite plaintiffs, if you wish, to make some sort of argument in opposition to do so. Mr. Herron, go ahead.
Thank you, Your Honor, and I will try to keep this at a high level, particularly given that we did not see the state's motion until just now. First, I do want to address the sovereign immunity point. The state waived sovereign immunity on Claim 1 in at least 3 different ways. First, it did so expressly. Plaintiffs filed a complaint that included both Claim 1 and Claim 3 as separate causes of action, and you heard today that they didn't realize that Claim 1 was was a separate cause of action and not subsumed within Claim 3, but we were very clear in our opposition to the state's motion to dismiss on page 8 that about what we were seeking in Claim 1. We said that plaintiffs seek a declaration of their rights under the abortion ban's medical exceptions under the statutes themselves. In its motion to dismiss, in order to induce dismissal of the other defendants, the state expressly agreed that, quote, the state of Idaho is a proper defendant in this action, close quote. It made no qualifications as to whether it was a proper defendant for all of plaintiff's claims or only some, and the court relied on that concession in its decision to dismiss the other defendants. Second, the state waived sovereign immunity by taking actions that were fundamentally inconsistent with an intent to preserve it. Although Idaho made a bare assertion of immunity in its answer, it provided no explanation or authority. It didn't raise it at any point during discovery. It didn't raise it in its motion for summary judgment. Instead, it repeatedly took steps that were inconsistent with sovereign immunity, such as responding to discovery and arguing numerous motions before the court prior to summary judgment. Third, the state waived sovereign immunity by failing to raise it sufficiently in advance of trial. Affirmative defenses must be raised before trial, and the opposing party must have time to respond in briefing and oral argument. And here, Idaho did not meaningfully assert its sovereign immunity defense until its trial brief, which was filed just 6 days before trial. Before then, the only reference was a bare sentence in the answer that had no other information, and the state took no other action to pursue it in other briefing. And additionally, under the scheduling order, dispositive motions had to be filed by August 19th, I believe was the date. The state did not raise sovereign immunity, so the court can find the defense waived for failure to comply with the scheduling order. And even if it's not waived, the state does not have sovereign immunity on Claim 1, because to decide whether the statutes are unconstitutional for Claim 3, the court first needs to construe the scope of the exceptions. So in other words, the court necessarily needs to decide Claim 1 in the course of deciding Claim 3, and because everyone agrees there is no sovereign immunity for Claim 3, the court has the authority to issue an interpretation of the exceptions that can be used to resolve Claim 1. On Claim 1 itself, on the ripeness argument, these are not hypotheticals in the future. The physician plaintiffs regularly treat patients with high-risk pregnancies. This is an active part of their practice. The patient plaintiffs demonstrate real-world examples of how these laws are applying in practice. Dr. Harmon's, Dr. Akers, Dr. Colson's testimony did the same. So these physicians need clarity and need to understand their rights for what they can do today. These are issues that are ripe for deciding now. I won't address standing since that was the state relied on its summary judgment arguments. On the merits of Claim 1, I'll just preview for the court, and you'll see more about this in our post-trial briefing, obviously. But in Claim 1, we are seeking a declaratory judgment declaring the rights of physicians to provide abortion care to their patients with high-risk pregnancies. You heard a lot of testimony about the confusion about Claim 1. One way to interpret this provision to provide us the relief that we're requesting is that it permits an abortion if a pregnant patient has a condition that could lead to a risk of death if left untreated, and if abortion is within the standard of care for that condition. And how do we get to that interpretation? You can read both the word necessary and the word death broadly in light of statements in the Planned Parenthood decision. Planned Parenthood said that this phrase does not require objective certainty or any particular level of immediacy. Instead, it uses broad language to allow for physician clinical judgment. And Planned Parenthood also said that there's no certain % chance requirement that death will occur. So the testimony you've heard at trial is that the way that physicians exercise their clinical judgment is by looking to evidence-based recommendations. They look to the national standard of care. What they don't do in exercising their best clinical judgment is to try to determine whether a particular treatment would alleviate a risk to the patient's health versus a risk that they may die. And so, because this is a regulation of the medical profession, this needs to be interpreted in a way that comports with the practice of medicine, and that would involve the standards of care. You've also heard testimony that these conditions pose a risk of organ damage and therefore a risk of shortened lifespan, and that provides another way to interpret the exception as we're arguing. So necessary to prevent death could be interpreted as necessary to prevent the risk of an earlier death. And that, I believe, would encompass all of the conditions that you heard testimony about. On Claim 3, as we addressed this in our motion to dismiss already, so I won't get into too much detail, but the rights we are discussing here are different from the rights being asserted in that were asserted in Planned Parenthood. That was a facial challenge based on implied rights that the parties were trying to imply into the Constitution. We are relying on rights that are explicitly identified in Article 1, Section 1, and this is a narrower as-applied challenge as applied to high-risk pregnancies. When you're relying on those explicit rights, well, let me just turn to the scope of relief. We will provide a lot of information about ways that to interpret Article 1, Section 1 in our post-trial briefing based on the text of the rights themselves, which are not simply the right to not die, but they are the right to enjoy life, to pursue happiness, and to secure safety, which are broader rights that we believe encompass the right to not be forced to risk of death or injury or ill health under a state law. The state, I think, is arguing that if there is any part of our as-applied challenge that the court does not conclude is unconstitutional, then our entire as-applied challenge would fail. And that's just not correct. The standard is really clear. The label about as-applied versus facial is really a question of relief. And the point of all of this is, to the extent that the court finds the laws are unconstitutional, that's the extent to which the court would enjoin the laws. If the court doesn't agree with us on the complete scope, then you don't enjoin the laws to the complete scope. You enjoin them to the extent that you find them unconstitutional. Finally, addressing just briefly the merits of Claim 3 on strict scrutiny. Once the plaintiffs have shown an infringement of the rights, and Your Honor, you heard just a very large amount of testimony about how patients are being delayed or denied abortion care, which is an infringement of those rights we would put forward. Once we've shown an infringement, the burden shifts to the state to establish that the law can survive strict scrutiny, which requires the state to show a compelling state interest and narrow tailoring. And we believe it would be inappropriate to conclude that strict scrutiny is satisfied before the state has even put on any evidence to try to meet its burden. The state argues that it has a compelling interest in protecting fetal life and that these bans are narrowly tailored to further that interest. But you've heard testimony that for many of the conditions at issue, there's little to no chance of fetal survival. That includes pre-viable PPROM. It includes lethal fetal diagnoses. And however strong the state's interest in fetal life may be in other circumstances, its interest in the circumstances presented by this case are at their lowest, and it's not a compelling interest here. The state's interest also has to be balanced against and, in fact, give way to the pregnant patient's interest in protecting their own health, lives, and their ability to have children. These laws are also not narrowly tailored to further any interest in fetal life. They're both under-inclusive and over-inclusive. As I mentioned, for many of these pregnancy complications and lethal fetal conditions, there's little to no chance of fetal survival. And despite the state's asserted interest in life, These laws fail to protect maternal life and expose pregnant patients to the risk that their health will rapidly deteriorate to the point that they die, that their lifespan is shortened due to organ damage, or that their reproductive organs are permanently damaged or must be surgically removed, which would end their fertility. And I'll point to one other specific example of how these laws are not narrowly tailored. The total ban precludes an abortion where the basis for the physician's determination is that the woman may or will take action to harm herself. And if a pregnant patient dies by suicide because of this abortion ban, that ends both the life of the pregnant patient and the potential life of her fetus, and that undermines, not furthers, the state's interest in life. On the rights of the state asserted an interest in maternal health. I don't know how the state can assert that these laws further an interest in maternal health when, as you've heard in numerous, a plethora of testimony, the existence of these laws is damaging maternal health and causing women to be denied or delayed care in receiving necessary abortion care. In terms of the integrity of the medical profession, you heard testimony that these laws are actually harming the medical profession. Doctors are being forced to violate their medical ethics. They're being forced to tell their patients that there is a treatment available to those patients or that would be available to them, but that is no longer available in Idaho. Physicians are being forced to tell their patients that you cannot receive the standard of care in Idaho, that you must actually leave Idaho to a neighboring state to receive the standard care rather than obtain substandard care here. The state also made an argument about discrimination against the disabled. I just want to make clear the fetal conditions for which we are seeking relief are lethal fetal conditions. You heard testimony that this has a medical meaning, and it means that the fetus is unlikely to survive to term. And if it does, it is unlikely to survive childbirth. And in the rare circumstance that it does, the neonate will only be offered palliative or hospice care. So we're not talking about disabilities, we're talking about lethal conditions. The state's interest in protecting fetal life or preventing discrimination is at its lowest in these tragic circumstances. It's the pregnant patient's interest in protecting their health, their lives, and their ability to have children that has to be given precedence. And one other point, even if there is a compelling interest on preventing discrimination against disabilities, it is not narrowly tailored to meet that interest. The total ban does not advance an interest in preventing discrimination, and instead it actually furthers discrimination. The total ban explicitly discriminates against individuals with mental health conditions that could be considered disabilities. I'm happy to address anything else that Your Honor would like. Again, we're going to have a lot more of this in our post-trial briefing, I'll stop there.
Understood. Thank you, Mr. Herron. In other circumstances, a regular motion hearing, I give the movement an opportunity to make a reply argument, but I'm not sure that it's particularly constructive under the circumstances. It's a Rule 41B2 motion, and the rule allows a motion of the type the state has made here, a motion at the conclusion of the plaintiff's case in chief in a court trial, where the movement argues that the evidence has been insufficient to show a legal right to the relief requested. The rule says that the court may then determine the facts and render judgment against the plaintiff, or may decline to render any judgment until the close of all evidence. That's a discretionary decision as to which of those routes to take. And I'm going to exercise my discretion, partly for the reasons I've already articulated, to decline to render any judgment until the close of all the evidence. What I'll add to what I've previously stated on that topic, and what I'm about to say is not intended as any sort of criticism of anyone involved in litigating the case, but the way the case has been presented or defended through the dispositive motions made so far in the case has not really required the plaintiffs to come forward full bore with exactly what the constitutional theory is and to support it in a full-throated way with their best shot as to why the Constitution The provision at issue in the state constitution entitles women to abortion care under the circumstances presented. And so I really do feel like, although we are at trial, and in many cases at trial, I would know, maybe most cases at trial, I would know exactly what the relief sought is and why the plaintiff contends under the law that it is legally available. That has been more clouded in this case than it normally is. And so I do really feel like in many ways the plaintiff's post-trial proposed findings and conclusions are going to be the first time that I see the full measure of the plaintiff's theory. And that is in large part why I think it is improvident for me to try to decide the matter now, rather than wait until after the close of evidence. So motions denied on that theory. I'm declining to render judgment until the close of all the evidence. That's not a rejection of any of the theories that the state has advanced for concluding that the case hasn't been proved. Those theories are certainly still fair game for the state to pursue in its proposed findings and conclusions after the trial. All right, all that said, it's now time for a presentation of the state's case in chief. At least I would think so. Mr. McKay?
Your Honor, right. I'm sorry. Possibly now is an appropriate time to take up the two witnesses that were disclosed by the state Monday night. I don't know, the state has not shared with us their order of proof. I gather we could take it up if the state truly intends to call those witnesses during their case in chief when they call that witness, or we could argue it now. I'll defer to the court.
All right, well, let me ask Mr. Craig, do you intend to call those folks?
I do, Your Honor, and I do intend for them to be my first witnesses. And just a point of clarification, they are not part of the case in chief. They are being called clearly and only to rebut testimony provided by the plaintiffs.
All right, so I suppose there's a discussion to be had, and we may as well have it. It sounds like if they're the first witnesses. Now, my understanding from what has been said so far is that these witnesses were not disclosed in any form prior to sometime between when we recessed on Thursday and when we resumed the trial on yesterday morning.
About 5:15 p.m. on Monday night.
Okay, and that's agreed?
Yes, Your Honor. We served an amended witness list on Monday, approximately 5:15.
All right. So I'm going to, of course, I'll entertain arguments from the parties on the topic. What I'm going to note at the outset in doing so is that Rule 16D of the Idaho Rules of Civil Procedure allows the court to order the parties to file a list of all trial exhibits and the names and addresses of the witnesses who may testify except impeachment exhibits and witnesses. The rule goes on to authorize the court in its discretion to exclude untimely disclosed witnesses or exhibits except for good cause and to prevent injustice. And so Mr. Craig at this point has used the language rebuttal to describe the testimony that would be offered. And I would say that given the rule I've just cited, rebuttal witnesses, too, are required to be disclosed. What's not required to be disclosed is impeachment witnesses. And rebuttal and impeachment are two, I suppose, perhaps partly overlapping concepts, but they're distinct concepts nonetheless. Rebuttal evidence is evidence that is offered to disprove or contradict the opposing party's evidence. Impeachment evidence is evidence that is designed to undermine the credibility of a witness who testified for the other party. So they're different things, and it may be that to the extent these folks are impeachment witnesses, there's not a disclosure obligation and not a bar to calling them despite the non-disclosure. So if impeachment is the point, there's not, I think, grounds to exclude them. At least the grounds to exclude them wouldn't be that they weren't disclosed in a witness list. If they're rebuttal evidence, then we have another conversation to have, because then I'd need a showing of good cause why these witnesses ought to be heard despite not being disclosed on time. So that's the framework. Having said that, Mr. Craig, go ahead.
Thank you, Your Honor, and I appreciate that clarification from the court and pointing out the inartful language that I was using. So first of all, the fact of the matter is that these witnesses were not even identified by the state as witnesses until after the weekend. I met with one of the witnesses on Saturday morning. The other witness I did not identify until Monday during the day. And it was not confirmed that both of them would in fact be able to testify, and subpoenas were sent out on Monday during the day, and then we provided the disclosure. So we provided the disclosure in a timely manner after we identified them as witnesses. Now, in terms of the rebuttal versus impeachment, their testimony will directly impeach the testimony of Dr. Corrigan, Dr. Colson, Dr. Aker, and Dr. Harmon. And I can go through and point out specific places where their testimony will be impeaching the other witnesses if you believe that's important, but it will be directly impeachment or direct impeachment evidence of that testimony.
And I guess there are multiple types of impeachment. The type of impeachment would be an effort to show that the facts are different than the plaintiff's witnesses stated them to be. Is that right?
Yes, Your Honor.
And it's not some other mode of impeachment, such as I guess reputation or opinion evidence as to character for truthfulness or something like that.
Correct. It is not character for truthfulness, other than the fact that their testimony will impeach. And would you like an offer of proof? Would you like me to?
I think that might be helpful as long as it's not substantially the same in length as just hearing the witnesses.
Sure. So we have heard over and over from Dr. Corrigan, Dr. Aker, Dr. Colson, Dr. Harmon, Dr. Lyons, et cetera, that physicians in Idaho are confused. The Idaho Academy of Family Physicians have had 2 representatives testify that their doctors are confused, that they don't know what to do, that they represent the doctors of Idaho. Dr. Corrigan has testified about St. Alphonsus' policies regarding abortion. So both of these doctors will testify that will directly impeach that and say, no, we're not confused by the laws. We understand what the laws mean. They are able to testify to that. Dr. Story will directly impeach the IAFP's testimony that we represent family physicians across Idaho, and that our physicians are confused. And in fact, one of the witnesses will testify that no, the IAFP does not represent the family physicians in Idaho, at least him and physicians he's familiar with, and that they do in fact take positions that do not represent him, and they do not represent the physicians. They will testify, one of the witnesses will testify that St. Alphonsus' policies have not changed, that he practices in the emergency room in St. Alphonsus, and the policies have not changed since these laws went into effect, which directly impeaches Dr. Corrigan's testimony that no, in fact, what they do at St. Al's has changed since the laws have gone into effect. And it will directly impeach the testimony that this is harming the patients of the of doctors in Idaho. They will both testify that no, these laws do not harm their patients. So it will directly impeach all of that evidence.
All right, and this is neither here nor there as far as whether these witnesses should be permitted to testify, but in addition to these witnesses, you'll call Dr. Skop, and are there others?
No, Your Honor.
Okay, understood. Did you have any further argument to present before we hear from plaintiffs' counsel on this topic?
No, Your Honor. Thank you.
Okay, thank you, Mr. Craig. Mr. McKay, go ahead.
Right. Good morning again, Your Honor. So when counsel characterizes them as rebuttal witnesses, like they did in their witness disclosure that, again, we received Monday night, we take them at their word. And in fact, they really are rebuttal witnesses. And I think, with all due respect, I think counsel is now merely responding to possibly the court's invitation that impeachment witnesses are appropriate by recharacterizing witnesses who are truly rebuttal witnesses as impeachment witnesses. And they are not. These witnesses will, to say that they understood the law or they're not confused, that's rebuttal. That's not impeaching anything that our witnesses said with respect to their own confusion, and that the IAFP does not represent the entirety, the full spectrum of family practice doctors within the state. We didn't say otherwise. We said the IAFP consists of family practice doctors throughout the state, and this organization exists to represent the interests of those doctors. And so it's really not impeachment, it's rebuttal. And you know, the court issued a scheduling order, as you point out, and we followed that scheduling order because we believed we had to, and we timely disclosed all of our witnesses. So all of the witnesses that you heard testify during this trial were disclosed at the attorney's conference in early October, and then prior to the pretrial conference, because that's what the scheduling order required, and the plaintiffs have not done that. And yesterday, what I heard counsel say is that he wished to call these new witnesses to address the testimony of Dr. Corrigan, Dr. Akers, and Dr. Harmon. Well, it can't be, he can't claim surprise as to what those witnesses testify to. Dr. Corrigan is a named plaintiff. She's quoted throughout the complaint, and the defendant, the state, took her deposition. Dr. Akers, similarly, is quoted throughout the complaint. And she was disclosed in our discovery responses, and as was Dr. Harmon. The witnesses that were not disclosed, either in response to discovery, which we served back in January of 2024, we asked a couple interrogatories where we asked the state to identify, in response to interrogatory 1, all persons who are likely to have discoverable information that the state may use to defend against claims and identify the issues upon which the state believes they have knowledge. And interrogatory number 2, which required the state to identify all persons whom the state intends to rely upon as fact witnesses during discovery or at trial, and summarize the testimony which the state expects each such person to provide. Those names never came up. And they provided, they answered those interrogatories. They provided some names, but they had a duty to supplement. And even as I stand here today, they haven't supplemented, even though I raised that issue yesterday. So we're basically flying blind here. We don't know what these witnesses will say beyond what we just now heard counsel say in his offer of proof. And so I think there's cases that are instructive here. I mean, we recognize it's a matter of discretion, but in City of McCall versus Subert, the City of McCall disclosed their witnesses, what they call their rebuttal witnesses, 1 week prior to trial, not 1 week into trial, but 1 week prior to trial, and after the court had established a scheduling deadline for disclosing witnesses, just like the court did here. And the Supreme Court held that the trial court properly excluded those witnesses, that the plaintiff was well aware of the type of rebuttal testimony it might need and clearly could have disclosed the witnesses at that time. And I think Edmonds versus Craner, a citation on that Subert case, City of McCall-Subert, is 142 Idaho 580. Edmonds versus Craner, 142 Idaho 867, addresses that this is a discretionary matter, but that the Supreme Court does not look favorably upon discretionary decisions by district judges that encourage last-minute witness disclosure. And that's really what this is. I mean, this is not the 11th hour. This is where we're maybe at the 27th or 28th hour now. And they're not, I have not heard any offer of proof that would render these individuals to be true impeachment witnesses. They're rebutting exactly what the state knew we were going to present during our case. And what he also said yesterday, not today, but he said this yesterday, that there were certain relevance objections that they had made that were overruled by this court. So they knew the scope of testimony. They just maybe bet that the court would sustain its relevancy objections. And when it didn't, now they're claiming they need to call these witnesses. And that can't be the law. The rules of discovery, the scheduling order, I think all require timely disclosure of witnesses, so we're not faced with a situation like we have here today where we are conceivably going to have to meet and cross-examine witnesses for the first time, not knowing what they're going to say, not having any prior disclosure, not doing what our rules contemplate. And we will be unfairly prejudiced, and we ask that the state not be permitted to call these two witnesses today.
All right. Thank you, Mr. McKay. If you'd like a brief reply, Mr. Craig, before I rule, you may.
Thank you, Your Honor. So throughout this case, plaintiffs have played fast and loose with the court's scheduling order, including disclosing and discovery orders and all those, including disclosing hundreds and hundreds of pages of medical records to us, on the Sunday evening before trial starts. And because of that, the court specifically ruled that they weren't allowed to use some of that evidence. But to then turn around and argue that the state is not compliant with this discovery order when they are, or scheduling orders, when they're doing the exact same thing and even worse by just, again, directly refusing to provide hundreds of pages of medical records to us that we had discussed, that we had pointed out the missing pages, and then on the eve of trial, they provide those to us. So the City of McCall case, that case made note that the expert that was not being allowed to testify was an expert witness, and that gave the reason, an additional reason to not allow it, and is special importance to this. These witnesses are not being called as expert witnesses. These witnesses are being called as fact witnesses. The state has been prejudiced by plaintiffs, their 500 pages of exhibits, and then they go down to, they withdraw hundreds of pages, and then they throw in more pages of exhibits, all that. And so again, the state has been prejudiced by their tactics that they have been taking in this case. These witnesses were not discovered by the state until after trial closed on Thursday, and as we started finding witnesses that were willing to testify. One of the things about this case is that it's high profile, and witnesses are, quite frankly, fearful for professional repercussions to come forward in this case. And it was not until Friday that we were, Friday, Saturday, and Monday, that we were able to find a couple witnesses who were able to and willing to testify despite the risk of professional repercussions for coming forward in this case. So I think that, one, these are in fact impeachment witnesses. Even if they are considered rebuttal witnesses, there's good cause. We did not identify these witnesses. We were not able to find their names until after the close of evidence on Thursday, and in fact Monday was when we were able to get one of the names. They have been allowed to, the plaintiffs have been allowed to present evidence that is irrelevant. They've been able to present and offer proof of what the court has ruled is irrelevant of a witness for an hour, hour and a half, something to that effect. We are entitled to present evidence to impeach that evidence and to go forward with it. So I'd ask the court allow us to present those two witnesses.
All right, I'm going to make a ruling on the topic now, and the starting point, I think, is just to reiterate what I said earlier about the operative rule, Rule 16D of the Idaho Rules of Civil Procedure. It imposes no disclosure requirement as to impeachment witnesses. There is a disclosure requirement for other witnesses, and that would include rebuttal witnesses. So the scheduling order required witnesses to be disclosed in a witness list to be filed 1 day before the pretrial conference. The pretrial conference was last month. So that disclosure obligation encompassed witnesses who fall into the category of rebuttal witnesses. Again, doesn't encompass witnesses who fall into the category of impeachment witnesses. The Rule 16D, does allow a court to exercise its discretion to hear from witnesses who are not disclosed on time as necessary to present injustice if good cause is shown for not making a timely disclosure. Now, here, these witnesses, it would appear from Mr. Craig's description, will testify on some level in a way that may be impeachment type testimony, and in some ways the proffered testimony, it would seem to me, would not be impeachment testimony, but would rather fall into the category of rebuttal testimony. And to reiterate the distinction between those things, I'm going to indicate, and there could be any number of sources for this, but just as an easy reference, Black's Law Dictionary defines the terms impeachment evidence and rebuttal evidence. It defines impeachment evidence as evidence used to undermine a witness's credibility. It defines rebuttal evidence as evidence offered to disprove or contradict the evidence presented by an opposing party. Now, to use an example from the testimony that Mr. Craig indicated would be presented, these folks would testify, or at least one of them, I gather, to the idea that that person does not find the medical exceptions in the abortion statutes confusing. That would be, in my mind, rebuttal evidence. The state has presented evidence, or either the plaintiffs have presented evidence that certain physicians find the medical exceptions confusing and unclear. The evidence that some other physician personally doesn't find the medical exceptions to be confusing or unclear is rebuttal evidence. It's offered to disprove or contradict the plaintiff's evidence that the medical exceptions are confusing and unclear. One of these witnesses' personal views on whether these statutes are clear or unclear is not impeaching because the plaintiffs did not present any evidence concerning the particular opinions of these folks, the folks that the defendant intends to call. Now, were these witnesses to testify general observations that the medical community is not confused or does not find these exceptions unclear? Now, that may be impeaching of testimony that the plaintiffs presented as to observations about the medical community and its perception that these are confusing or unclear exceptions. So I think that would roughly be in bounds, as one of these one of these prospective witnesses' perceptions as to whether the medical community is or isn't confused. I think that's impeaching. It would impeach by contradiction. It would impeach evidence that has been presented that the medical community is confused. But personal views. I'm personally not confused. I personally find the statutes to be clear. That's not impeaching. It's just rebuttal, and that is excluded because there isn't good cause for the untimely disclosure. Further, I'm going to indicate a couple of things in general. As to any of the proffer that Mr. Craig has made, in my discretion, I do not find that there is good cause for the late disclosure, nor do I find that allowing the witnesses to present testimony that goes beyond impeachment testimony is necessary to prevent any injustice. The evidence at issue that is being rebutted or impeached is within the categories of evidence that I think was pretty plainly on the table. So I don't think there's a surprise issue, and I don't think that anything has happened that would justify a sort of last-minute effort to find folks to testify on these topics. All right. And now, the other thing I'm going to note categorically is because I've found that there isn't good cause for late disclosure, that any testimony these witnesses offer would be considered only for impeachment and not for its own, I guess, substantive truth. It'll bear only on the credibility of the state's witnesses. That's the only purpose it'll be considered for. I'm going to permit the defense to call the witnesses, and I've tried to lay down a marker as to at least one area in which I think the evidence would be rebuttal evidence and not impeachment evidence, and I'll direct Mr. Craig to avoid that particular topic. I'll note that counsel are certainly free to object as the evidence comes in on the grounds that what's being offered is rebuttal and not impeachment. I'll consider those objections on a case-by-case basis, but ultimately, whatever comes in through these witnesses would be considered only for impeachment purposes, which again is only evidence that bears on the credibility of the plaintiff's witnesses, and not as separate substantive evidence. All right.
Right, Your Honor. I understand the court's ruling, and I'm not asking to re-argue what you just said. I just want to say that I don't believe that there was testimony from any of our witnesses that every physician in Idaho was confused by these laws. And I'm afraid that if these witnesses are allowed to testify to folks maybe that they've talked to who say they're not confused, we're potentially straying into hearsay. Hearsay, of course, that we have not had a chance to vet or to test. They haven't been disclosed as experts, so I think that's an area that needs to be certainly walled off. There's been no disclosures here that would allow them to opine as a matter of expert opinion.
I agree that your case hasn't consisted of evidence that all physicians are confused, but it would have been my perception that the evidence has extended beyond the individual witnesses' perceptions that the exceptions are unclear and confusing, and has extended to, I guess, general observations about a confusion in the medical community.
Agree with that.
All right, and so that is, I guess, the reason why I think there's a potential impeachment effect if these folks that the state intends to call today essentially testify, well, I'm part of the medical community too, and as I look around, it hasn't appeared to me that people are confused or don't know how to respond to this environment. And that would, I guess, tend to impeach by contradiction the plaintiff's evidence that the medical community is confused. That's my thought.
So they'll be allowed to testify to the conversations they had with a couple physicians in their community?
It would be the same mode through which the plaintiffs offered that sort of evidence over sometimes hearsay objections that I overruled, which were not, the plaintiffs didn't present evidence. I talked with physician A, and physician A told me he's confused. The evidence was, I've been to meetings, I've been to this, I've been to that, and having been to these things, my perception is people don't understand the law and don't know what to do. And if the state can offer similar evidence that would lay some foundation for exposure to other physicians having to navigate these laws, and these folks say they've come away with the impression that physicians aren't confused, I think that's in bounds for impeachment and not for its truth, effectively.
Okay.
Credibility effect only.
Okay. I will also say the court entered granted the state's motion to exclude witnesses and forbid witnesses who are not experts from observing the other witnesses' testimony. I know Mr. Craig apparently ran into one of them this weekend and is calling that person as a witness. I don't know if that person has viewed the live stream during the course of this case, and that what prompted him to come forward. That would be, another basis to exclude that witness. That would be contrary to this court's order in that regard.
All right. Well, you're welcome to inquire when it's your turn, or Mr. Craig can try to head it off, I suppose. I guess I don't intend to have an inquisition on that in advance. The court conducted inquisition on that point, but it is conceivable that there could be some sort of further restrictions or exclusion if that turns out to be the case.
Would we be permitted to inquire in aid of an objection on that point?
So as sort of a threshold issue, he calls the witness, and then you try to make a categorical objection. I suppose I'd allow that.
Thank you.
All right. Okay. Mr. Craig, if you're ready, you're welcome to call a witness.
Yes, Your Honor. I'll call Dr. Dustin Hughes.
Good morning, Dr. Hughes. Go ahead, Mr. Craig.
Thank you, Your Honor. Dr. Hughes, could you please state your name, spell your name for the record?
Dustin Hughes, DUSTANHUGHES.
How are you currently employed?
I'm as an obstetrician gynecologist with Life Stages.
And what city is that located in?
Yeah,
And how long have you been doing that for?
Since 2005,
Where did you go to medical school?
University of South Florida, Tampa,
What year did you graduate?
1995.
Where did you go to your residency training after you graduated from medical school?
At the Wright State University, it's combined Wright State University, Wright-Patterson Air Force Base residency program in Dayton, Ohio.
And what was your residency training in?
Obstetrics and gynecology.
And after you graduated from residency, where did you go?
I spent 2 years at Mount Home Air Force Base from 1999 to 2001, and then 2 years at Elmendorf Air Force Base from 2001 to 2003.
And were you in the Air Force?
Yes.
Were you practicing obstetrics during your time with the Air Force?
Yes.
And after your time with the Air Force, where did you go?
Once I left the Air Force in Alaska, I came back down to Nampa and joined a group practice in 2003 and worked with that group for 2 years, and then we started our own independent practice.
Could you briefly describe your practice?
It is general obstetrics and gynecology. So we do prenatal care and gynecology care, routine examinations in the office. We do deliveries and C-sections at the local hospitals and GYN surgeries at the local hospitals.
You work in the emergency rooms at the local hospitals as well?
I don't work in the emergency room. I do call in the emergency rooms as part of medical staff privileges at the hospitals.
And please describe what that entails.
It's being at home, being on call for the emergency room physicians to call if they have any questions about obstetric patients less than 20 weeks in the emergency room or any gynecology patients that show up.
And how often do you do that?
I'm on call generally once a week during the weekdays, and then about every 5th or 6th weekend from Friday through Sunday.
Which hospital is that?
I do call at St. Alphonsus in Nampa and St. Luke's in Nampa.
And let's talk specifically about St. Alphonsus. How long have you been doing that for?
I've been at St. Alphonsus since 2003. It was originally called Mercy Medical Center, and St. Alphonsus took it over, but it's the same facility. And that was from 2003 until present.
And when you handle those emergency calls, does that involve you sometimes going into the emergency room to examine the patients?
Yeah, frequently. Examining them and deciding whether they can be admitted for observation, go home, or whether they need surgery.
And does that involve you treating the patients in the emergency room as well?
Yes.
And what type of treatments might that be?
Objection, Your Honor. I think this is beginning to get outside the scope of what you allowed.
Go into his background, Your Honor.
That was my perception. We're still just giving some background about the witness in order to help me assess the credibility of whatever his testimony turns out to be as a substantive matter. So I'll overrule the objection on that theory.
What was the question again?
Can you briefly describe some of the procedures? I believe that was a question I asked, some of the procedures that you would be treating patients at St. Alphonsus.
So the ones who require procedures would be some type of surgery in the operating room. We don't do the procedures in the emergency room. So they would come in with possible ectopic pregnancy that has to be treated, ruptured cysts of the ovaries, bleeding cysts from the ovaries, pelvic abscess, incomplete miscarriages, or just heavy bleeding for any reason.
And as part of that, do you work closely with other medical staff at St. Alphonsus?
We work with the emergency room physicians in consultation with the patient in the emergency room. After that, not as much. If they have to be admitted, then we just individually do the surgeries.
But you'd also be working with nurses and
Right.
anesthesiologists, operating staff to the extent you need to do
Yeah,
those.
for any surgeries that if they're not already in the hospital, then the anesthesiologist comes in, the nurse, the OR tech, they would all come in to assist with the surgeries.
And as part of your work with St. Alphonsus in the emergency room, do you also treat patients who have had medication abortions?
Yes.
Describe that.
They have received through their primary care provider or elsewhere, they started a medication abortion. They present to the emergency room, generally with severe pain, cramping, bleeding, and they either chose not to continue that at home or they're concerned about their current condition, so they came in to be evaluated.
So you would treat them in the emergency room along with the other staff?
Right. So we do an ultrasound to see what's going on inside the uterus. If there's no longer a fetus, heartbeat, there's just retained products of conception, which is usually the placenta. Then we admit them to the hospital, do a D&C to evacuate the rest of the contents of the uterus, and then they're able to go home shortly after that.
Are you familiar with Idaho's Defense of Life Act and Fetal Heartbeat Preborn Child Protection Act?
Yes.
And in your practice at St. Alphonsus, work in the emergency room, how have these laws affected yours and the other physicians' ability to treat patients?
Objection, Your Honor. I'm now going to object on that categorical basis that Mr. McKay mentioned at the end. May I have a few questions in aid of that objection?
You may.
Good morning. Are you aware that this trial has been live streamed and broadcast on YouTube?
I didn't even know this trial was going on until a couple days ago.
How did you learn that this trial was occurring?
When I was contacted by his office to see if I'd be available to answer questions initially and then possibly testify.
When you say his office, are you referring to Mr. Craig's?
Yes.
What day were you contacted?
Monday. I was out of town last week, so I got back in town Sunday. So I think Monday.
Have you had any discussions with anyone outside of the Attorney General's office about what has happened in this trial?
No.
Have you watched any part of the live stream of this trial?
No.
Right, that's all you want.
All right, thank you. So you may continue. But there was a question pending when the objection was made, but I gather that you're satisfied for the moment, Mr. Herron. So if you want to restate the question, you're welcome to.
Yes, Your Honor. I believe the question was, in working at the emergency room doing your shifts with the St. Alphonsus emergency room, how have the Defense of Life Act and Fetal Heartbeat Preborn Child Protection Act affected the ability of the medical staff, including you, to treat pregnant women with pregnancy complications?
Objection, Your Honor. I think this is getting to the scope of rebuttal.
All right. Well, I'm gonna permit the answer. That said, I am going to limit consideration of the answer for the impeachment purposes I noted previously, and I'm going to, I suppose, judge from the answer ultimately whether it has any impeaching effect or not. You can answer the question if you still remember what it is.
So I work with the emergency room physicians, and part of that work has been alleviating their concerns about treating some of the patients they see in the emergency room. They're concerned about whether they can give medications to help a lady continue to finish off a miscarriage, or whether I would come in and do a D&C on these ladies. So I've worked with the emergency room physicians, just kind of educating them and reassuring them that they're not in trouble for treating these patients. There's no risk for them for treating these patients. It does not qualify for what would be concerned about with the new laws. It has not affected their ability to treat them at all. They continue to treat them. They continue to provide the routine care that they require. And I've been able to provide the routine care. So it hasn't affected my ability to treat these ladies at all.
Have the policies for St. Alphonsus regarding abortions, to your knowledge, working in the emergency room, changed at all from before these laws went into effect until after they went into effect?
Objection, Your Honor. Dr. Corrigan did not testify that St. Al's policies have changed, so this is not impeachment testimony.
I don't remember testimony to that effect either. Mr. Craig, what is the testimony that you think is being impeached here?
My recollection is Dr. Corrigan testified that when they are allowed to provide abortions has changed from before the laws went into effect until compared to now after the laws have gone into effect. And that that St. Alphonsus, my recollection, I apologize, I don't have that right in front of me. My recollection is that they were abortions that they were allowed to conduct prior to the laws. They are no longer allowed to conduct because of these laws.
To be clear, Your Honor, her testimony was about, she works at St. Alphonsus in Boise. She did not give any testimony about St. Alphonsus and Nampa.
All right. And are you talking about, I mean, there would be a difference, I guess, in the availability of abortions that is a consequence of the law's direct prescriptions, irrespective of any policy change. But I think the point Mr. Herron has made, or a point he has made, is that the testimony pertains to a different hospital, a different locale, and so I think there would need to be some sort of foundation for the same sort of policies being in effect at both locales before it would potentially have any impeaching effect. So I'll sustain the objection for now. You can ask further questions on the topic if you like.
Dr. Hughes, you work in the emergency room at St. Alphonsus in Nampa, or you provide on-call services, correct? And is St. Alphonsus and Nampa part of the same corporate entity as St. Alphonsus in Boise?
Yes, they're all part of Trinity Healthcare.
And do the same policies, to your knowledge, that apply in Boise also apply to the hospital in Nampa?
As far as I know.
So in your experience, when you are allowed to perform abortions, or when hospital staff are allowed to perform abortions, changed prior to these laws going into effect versus now?
So St. Alphonsus is part of the Catholic Health Network. So within that faith, within the hospitals, under that faith, we're not allowed to perform abortions in the hospital. So we have never, that I'm aware of, performed any elective termination of pregnancies, either medical or surgical, in our hospital.
That was the same before these laws went into effect as it is now?
Yes.
All right, thank you. I don't have any other questions.
All right. Thank you, Mr. Craig. Any cross-examination, Mr. Herron?
Yes, Your Honor, I wonder if we could take our morning break now to prepare a cross.
That's fine. It's as good a time as any, I suppose. We'll take 15 minutes and resume with cross-examination of Dr. Hughes. We'll be in recess.
All right.
seated. All right, Mr. Herron, you may proceed with your cross-examination of Dr. Hughes.
Thank you, Your Honor. Dr. Hughes, are you a member of Idaho ACOG?
I'm a member of ACOG. I'm not sure about Idaho ACOG.
When is the last meeting of Idaho ACOG that you might have attended?
I haven't attended the meetings.
Are you a member of IAFP?
I don't know what IFP is.
Are you a member of the Coalition for Safe Healthcare?
Nope.
Are you a member of the Post Row think tank?
No.
Do you know how the Attorney General's office came to be aware of you?
I think it was through an organization called Lifeline Pregnancy Care Center.
What is that organization?
It is a group that provides pregnancy care, supplies for pregnant ladies, ladies who had babies, provides pregnancy tests, ultrasounds for pregnancy, some STD screening, and some housing for pregnant ladies.
Is that a crisis pregnancy center?
I believe so.
And that's an organization that tries to convince women not to have abortions, correct?
Rejection, relevance beyond scope of direct.
Overruled. You can answer.
I think they provide the care. I'm not sure they're counseling ladies not to have abortions, but I think they're providing care and providing ladies with options for their pregnancy.
Is one of the options that they provide abortion?
I don't believe they do abortions.
Well, I didn't ask if they do abortions. I asked, is one of the options that they provide an abortion?
I don't know. I haven't been involved in those sessions.
Have you previously talked to Dr. Ingrid Skop?
Who?
Dr. Ingrid Skop?
No.
Are you a member of the American Association of Pro-Life Obstetricians and Gynecologists?
No.
Okay. You're not employed by St. Alphonsus, are you?
No, I'm an independent practitioner.
Are you a member of the OBGYN hospitalist group at St. Alphonsus in Boise?
No.
Are you a member of the OBGYN hospitalist group at St. Alphonsus in Nampa?
Nampa doesn't have a hospitalist group.
Have you been involved in any discussions with St. Alphonsus Chief Medical Officer about how the laws may or may not impact the provision of care at St. Alphonsus?
I haven't talked to him about it.
You've been involved in any discussions with St. Alphonsus legal team?
No.
Have you discussed with the St. Alphonsus MFM group how these laws impact patient care?
No.
I just want to make clear, I believe you testified in your direct about miscarriage management, correct?
Yes.
And you testified about ectopic pregnancies?
Yes.
And you testified about completing medication abortions or incomplete medication abortions. And you said that St. Alphonsus does not permit elective abortions, correct?
Correct.
In your opening or in your direct, you were not asked about management of any pregnancy complications such as previable PPROM, correct?
I was not asked about that, correct.
You were not asked about care for any patients with pre-existing conditions like cancer, were you?
No.
Are you aware of an injunction that we've been referring to as the EMTALA injunction, an injunction that is in place in the United States versus Idaho case?
No, I'm familiar with EMTALA, but I'm not familiar with any injunction.
Since these abortion bans took effect, have you induced labor for any pregnant patient before viability where the fetus still had cardiac activity, knowing that the fetus was unlikely to survive?
I've not had that opportunity, no.
Have you performed a D&E on a fetus with cardiac activity?
No.
Nothing further, Your Honor.
Thank you, Mr. Herron. Any redirect, Mr. Craig?
Yes, Your Honor. Dr. Hughes, you were asked about whether you have talked to Dr. Ingrid Skop. We being my office and you had a video meeting last night to discuss your possible testimony this morning. Is that correct?
Yes.
Are you aware that Dr. Skop was part of that meeting?
Yeah, she was present.
Okay. But you have not had any conversations with her other than her being part of that meeting?
No.
You were asked about PPROM. Do you know what PPROM is?
I do, yes.
And have you treated women with PPROM in the emergency room?
Objection outside the scope.
They opened the door, Your Honor. They asked him about PPROM.
My question, Your Honor, was were you asked about PPROM in your direct, and the answer was no.
Sustained.
You were asked about miscarriage management and whether you have, in the emergency room, induced labor in certain circumstances. Have you ever had to do that, induce labor?
We induce labor for ladies who are term or preterm past the level of viability for different medical reasons. We've had to induce labor in ladies who have not had heartbeats in the baby up to 16, 20 weeks over recently. I've never had to induce labor in someone who still had a heartbeat present for the baby.
And why is that?
Just has not come up yet. It's not a common occurrence where we see ladies with ruptured membranes or some medical condition where we need to induce labor for the mother's health in order to, even when the baby still got a heartbeat.
Thank you. I don't have any other questions.
All right. Anything else?
No, Your Honor, although we'll renew our request to exclude the testimony. There was nothing impeaching in this testimony at all.
All right. Well, I'll simply address that topic to whatever extent it's necessary in rendering a ruling at the conclusion of the matter. The limitation still applies. The testimony will be considered only for any impeaching effect it has. All right. Thank you for being here, Dr. Hughes. You may step down. Greg, you may call your next witness.
Thank you, Your Honor. Call Dr. Rodney Story.
Good morning, Dr. Hughes.
Morning.
I'm sorry, Dr. Story.
Yes, Story, sir.
I used the last witness's name instead of yours. Go ahead, Mr. Craig.
Thank you, Your Honor. Could you please state your name and spell your name for the record?
You bet. My name is Dr. Rod Story, S-T-O-R-Y.
How are you currently employed?
I am an independent family physician. I own my own clinic in Moscow, Idaho, where I employ several other physicians, physician assistants, nurse practitioners.
Where did you go to medical school?
I went to the University of Washington, the WWAMI program in Seattle.
What year did you graduate?
I graduated in 2002.
And where did you do your residency training after that?
I did my residency training through La Crosse Mayo Clinic residency in La Crosse, Wisconsin.
And what was your residency training in?
It was in family medicine.
And what did that encompass?
Well, I chose the program because of excellence in two areas, particularly, well, actually three. Inpatient internal medicine. We took care of our patients and all the way from the emergency room, which we staffed, all the way through to the intensive care unit, which we managed as primary. The program was known for its excellence in obstetrics and in pediatrics, and so we were the only residency that was managing that care, and it was a very high volume.
And did your residency also include training in obstetrics?
Yes.
Please describe that.
So we did the standard, I think 12 weeks that is required. I went on and did additional because I wanted to be well prepared. I anticipated doing obstetrics as a family physician. My goal was always to be a rural family physician, and so I expected to need to practice that way.
Where did you go after your residency?
After residency, I needed to pay off my loans, so I went to work for a critical access area that offered loan repayment. Happened to be my hometown in northern Wisconsin. I practiced there for almost 4 years.
And that was, you said, with a local hospital there?
Yes, I was a clinic that was based in a small town of 5,000. I was the only doctor in that town. I was part of a larger group that was taking care of patients and rounding on our own patients in the nursery and helping care for patients who were delivering at the local hospital and managing that care as part of a larger group. Obstetricians were few and far between, so we did a fair amount of prenatal care along with them and co-management of that care.
And where did you go after that employment?
Well, once I finished that job in loan repayment and my family was looking for a longer-term plan, I wanted to try something different. So I made a segue into hospital medicine. I moved my family to Pullman, Washington, although we live in Moscow, Idaho. I practice hospital-based hospitalist medicine, full-time, and ER medicine part-time as part of that job.
And where was your ER medicine?
My hospital medicine and ER medicine were at several of similar locations. So I did hospital medicine and ER medicine at Pullman Hospital, at Gritman Hospital, and at Tri-State Hospital in Clarkston, Washington.
Where is Gritman Hospital located?
Gritman Hospital is in Moscow, Idaho.
And how long did you do that for?
9 years, so from 2008 to 2017.
And then after your work as a hospitalist at the Pullman Hospital, you then started your own practice?
I did. My work as a hospitalist was really interesting. We co-managed patients along with particularly with high-risk medical conditions in the obstetrical ward. I really enjoyed that. The emergency room, similar. The care that I provided and enjoyed doing at the hospital kind of came to an end when there were some ethical issues that I was concerned had occurred at the hospital. And so I made a decision to leave and become independent.
And just for clarification, did those ethical issues involve any allegations against you or your concerns with ethical issues of what the hospital was doing?
No, they were not involved me. The hospital unanimously decided to sponsor a transgender surgery program.
Objection, relevance.
Sustained.
So without going into those details, it was your concern of ethical issues at the Pullman Hospital that led you to leave then?
Correct.
And that's when you opened up your own practice?
Yes, sir.
And please describe the nature of your practice.
Sure. So coming full circle after years of working as a palliative physician, hospital physician, ER physician, enjoyed going back to being a small town family physician. So I own my own practice, independent. We've grown tremendously. We have a good portion of the city that we now care for. I'm basically take care of patients right from the time they're born to the end of life. That can vary all the way from caring for families that are struggling with miscarriage or loss of children to caring for those newborns in the hospital.
And in your family practice that you operate right now, have you ever done obstetrics?
We do prenatal care alongside obstetricians. So because we're a rural area, many of our patients need to go on to deliver at other places. We've met that need. We also have a fair number of midwives in our area who need medical management of patients who have complicated issues during pregnancy, and we provide that alongside those midwives.
So up to what point do you provide that prenatal care?
We provide care all the way through pregnancy. We are not directly managing their week-to-week checks because that's managed well by others in our community.
You serve as a preceptor for University of Washington WWAMI Medical School program, is that correct?
That's correct.
And could you briefly describe that?
Sure. The University of Washington has a preceptor program for first and second year medical students. So we actively have students that spend an afternoon with us every week learning family medicine at its best. We take them on our hospital rounds and do home visits. We also do third and fourth year clerkship rotations in family medicine.
And you serve on the Obstetrics Pediatrics Committee at Gritman Medical Center there in Moscow?
That's correct.
Can you describe that committee?
Sure. As part of my active care in the hospital, I see half a dozen babies every month through nursery care. I'm part of that committee. That committee meets quarterly. It is made up of obstetricians in our community. There's 4 of them. Family physicians who are actively delivering. There's about a half dozen. As well as pediatricians. There's 2. And so we're part of that group as a discussion of good policy, standard of care, excellence in safety monitoring. So I'm active on that committee.
Are you familiar with an organization called the Idaho?
Your Honor, we object to the relevance of this witness testimony because, as he testified, he does not care for pregnant patients with emergent conditions. He sends them to OBs and does not provide that care. So, we would represent that he doesn't have relevant testimony to this case.
All right. Well, that might be the case, but I'm not exactly sure what is coming. So I'll permit Mr. Craig to ask his questions. You can object to any individual question on relevance grounds if you wish. Go ahead.
Thank you. Are you familiar with an organization called the Idaho Academy of Family Physicians?
I am.
Have you ever been a member of that organization?
I have.
Are you currently a member?
I am not.
Why not?
That organization, I've been part of the federal organization, American Academy of Family Practice, since I started medical school, because I'm a family physician and I've always been interested in family medicine. When I moved to Idaho, my membership was moved from Wisconsin to Idaho, and I appreciated that. As I became aware through emails and publications from the IFP of the local influence and interest that the IFP had, along with changes at the AAFP level, I was concerned that it was shifting away from what I thought was good medicine.
And because of that shift away from good medicine, you dropped your membership?
Yes, sir, as a matter of principle.
Can you please describe your interactions with other physicians in the area, including the obstetricians and family physicians, through your work at Gritman and in the community?
Sure. Because I sit on the OB-PEDS committee at Gritman Hospital, I get to be in a roundtable discussion of active issues. This law, the abortion ban, essentially, in Idaho was an issue of discussion at our table, and so I was part of that conversation. The conversation initially was around concern expressed as to how will this impact us. It did not seem to be around the issue of whether it was clear.
Objection, Your Honor, this is hearsay.
I don't know that it's hearsay, but I'm not sure how we're going to get to the point of whether it's impeaching, because the doctor is speaking about a very localized context, as I understood his testimony, in which this discussion was had, which it does not overlap with the context in which plaintiffs evidence on this subject was offered. And so whether there is, I guess, confusion or non-confusion in this particular local context, I'm not sure it tends to impeach the testimony given as to alleged confusion. In any event, if you can, let's just ask whatever your next question is, and we'll see where it goes.
Based on your...
Your Honor, we also object because this witness is not an expert witness. He's not disclosed an expert, and he's giving expert testimony here.
Ask your question.
Based on your work in the community, observations, interactions with physicians, are the practicing physicians confused about how the Defense of Life Act and fetal heartbeat
Objection, Your
preborn
Honor.
child... Appreciate it if I could get my question.
So I can be clear, we're talking about the Moscow community?
Yes, Your Honor.
All right. Why don't you just go ahead and finish restart the question, and you can go ahead and finish it.
Will I be able to finish it without garnering an objection?
The question is to be completed, and then any objection can be made at the end.
So based on your interactions with other physicians, based on your observations of the work, based on your experience in the community, do the Defense of Life Act and the Heartbeat Preborn Child Protection Act, are physicians confused about how to provide care to pregnant women under these laws?
Objection, Your Honor. Relevance, hearsay, foundation, lack of personal knowledge, and outside scope.
All right. So I understand the question to be focused on a localized medical community in Moscow, where Dr. Story practices, and we've discussed at length the idea that under the circumstances that have arisen here, these witnesses' testimony would be limited. But it does not appear to me that there would be any tendency to impeach, even by contradiction, the plaintiff's testimony on this subject, which wasn't at all any assertion, I think, about what the Moscow medical community perceives, or how the Moscow medical community is, whether it is or isn't confused. So ultimately, this would, I think, fall into the category of rebuttal more so, or just independent evidence on the topic of confusion than it would into impeachment. So I'm going to sustain the objection on that ground.
Your Honor, if I may address that, there was significant testimony about the impact on from Dr. Lyons, specifically about rural medicine and confusion of rural doctors and inability of rural doctors to provide care. She emphasized rural over and over and over again. Moscow is a rural area, and so I think this does directly impeach Dr. Lyons' testimony.
Your Honor, Dr. Lyons was testifying as an expert in this case.
All right. Well, this is not expert testimony because it's observational. That is what I understand this testimony to be. Now, the doctor is here. I've made a provisional ruling. I've made a ruling on my perception of things. That said, I don't mind you asking the question and getting the answer on an offer of proof type basis, and we can reevaluate if necessary in the context of rendering a ruling ultimately at a ruling on the merits. So you can ask your question, or if you recall the question, you can answer it. Otherwise, you can re-ask it, and I'll continue with the ruling I've made, but it'll be presented as an offer of proof.
Thank you, Your Honor. Do you remember the question, or should I restate it?
I believe the question was to the effect of, is there confusion among those that are practicing obstetrics in a community?
That's correct. Please answer.
And this is based on my observation as a community physician in my area. The context is that our communities were not actively performing abortion prior to this ruling, and so the question was, is this going to change it? There was concern that the law might be used beyond what is plainly written. But we continue to be a very active obstetrical center, and among my colleagues, it doesn't appear to be an active concern.
And based on your observations, working in the community and working with the other physicians, do these laws impact the ability of physicians to provide care to pregnant women with pregnancy complications?
Your Honor, same objections. Is this all part of the offer of proof?
All right. It seems to me that well, I'm just going to permit. I'll overrule the objection. You can answer.
My training is in ALS through my residency, and I continue that. I reviewed those updated documents and guidelines in anticipation of this. The reality of practice in obstetrics, which is the way I see my colleagues practicing, is supporting the life of the woman and the child until it becomes untenable, and then delivering that child if need be in an emergency circumstance. That is not an abortion. Abortion is made as a proper exemption for threat to the life of the mother, which I think is clearly stated and doesn't seem to be a change with practice or a concern for the physicians I work with.
Your Honor, I object to that testimony. It's lack of personal knowledge, improper expert.
All right. I think we're really. I'm not sure how I could be, I guess, any clearer on the topic that this will be considered only for any impeaching effect it has. And if it has any or not, I'm not really concerned about that right now. When this all comes out in the wash, it will only be considered for that purpose. So if no impeachment effect can be articulated, then it will effectively not have any function in the deciding of the case. It appears to me that it's just better off to complete the testimony and limit its consideration in that way. So, all right, Mr. Craig, you may continue.
Your Honor, I ask that we have a standing objection to this.
That's fine. Go ahead.
Thank you, Your Honor. Dr. Story, there's been some testimony in this case about fetal diagnosis, specifically as it relates to trisomy 18 and some related to Turner syndrome. Have you ever treated patients with trisomy 18 and Turner syndrome?
I have.
Can you please describe your experience treating those patients?
In a prior practice, when I was first in family medicine, I had a living patient with trisomy 18 that was 11 years of age. He was well cared for by his family. He had extensive medical needs, but not beyond what was able to be provided. I have two patients in my current panel who both have Turner syndrome. One of them is planning to be an adopted mother. Both are well and without health concerns.
Thank you. I don't have any other questions.
Your Honor, I object to that last answer. Our case is about non-viable fetuses, not viable fetuses, so it's not relevant.
Understood. It, in all likelihood, doesn't have any materially impeaching effect anyway. You may cross-examine the witness.
Good morning, Dr. Story.
Good morning.
How did you first learn about this case?
I read one article on last Friday, not the whole article, but I saw it on the front page of the Idaho Statesman.
And are you aware that this trial has been live streaming on YouTube?
I am aware. I've not seen it.
Besides that one article you saw on the front page of the Idaho Statesman, have you read anything else in the news media about this trial?
I have. But again, just the headline or the front page with a brief tagline was in the Seattle Times. So I regularly peruse the internet and just to see what is out there. I don't subscribe to the Seattle Times nor the Idaho Statesman.
And when did you see this tagline on the Seattle?
Same day, the Friday, I think.
Have you read anything about this case on social media?
I have not.
Have you watched any TV programs about this case?
I have not.
When did you decide to be a witness in this case?
I was contacted on Friday and asked if I would be open to doing that by a lawyer not involved in the case. No details were presented. I said, sure. He was aware that I had raised concerns about abortion in Idaho and generally thought the law was a good one.
And do you know how that attorney became aware of your views?
He is a friend of my community.
And besides this friend in your community and Mr. Craig, have you communicated with anyone else about this trial?
I have not.
Do you know Dr. Skop?
Only having just met her.
Are you a member of any anti-abortion organizations?
I'm a member of the Christian Medical Association, which would oppose abortion in most cases.
And have you communicated with anyone in the Christian Medical Association about this case?
I have not.
And what is the name of the lawyer that contacted you about this case?
Lincoln Wilson, excuse me.
Dr. Story, you testified that you moved your practice to Idaho in 2017. Is that right?
Correct.
And when you moved your practice to Idaho, you started practicing as a family medicine physician again, right?
So I've always been a family medicine physician, board certified and active as an AAFP member up until the time that I mentioned that I decided to end my membership out of principle.
Okay, but before moving your practice to Idaho, you practiced as an internal medicine doctor, as a hospitalist, right?
That is only partially correct. Family medicine practices in all different avenues, including emergency room and hospitalists. About a quarter of hospitalists are family physicians.
And in that role, you did not treat pregnant patients with emergent medical conditions related to their pregnancy, right?
No, that's not correct.
So you did treat those patients?
I did. Both through the emergency room, because I was the first point of contact, and also as a medical management for women who had threatened pregnancies and who were hospitalized and needed medical management.
You're not board certified in obstetrics and gynecology, right?
I'm not.
Okay. And you personally identify as a member of the Christian faith, is that right?
Objection, it's not allowed under Rule of Evidence 610. Evidence of a witness's religious beliefs or opinions not admissible to attack or support witnesses' credibility.
Sustained.
Dr. Story, how do you define abortion?
Abortion is the ending of a life. It is the purposeful use of medical technology to do so. It can go all the way from elective, meaning someone who chooses to say that they don't want a child any longer, all the way to a medical concern.
You believe that birth control is abortion, right?
Some forms, so the birth control, well, let me answer that more directly. Any medical technology that ends a fertilized egg, which is a zygote, which is a human being, uniquely made, unique genetic DNA all of its own and wholly separate from its mother. Any technology that ends that life is something that should be considered abortion under that same definition that I gave earlier.
So that would include hormonal birth control?
Hormonal birth control has a long and documented evidence of causing fertilized eggs, a zygote, to not implant.
So it would include hormonal birth control? And that would include IUDs as well?
Some IUDs function in that way, others do not.
Okay, so it would include those that function in that way, fair to say? Okay. Does the total abortion ban align with your moral views?
I'm going to object. Again, this gets under Rule 610 and is beyond the scope of direct examination.
I think it's objectionable under Rule 610. It's designed to get at the credibility of Dr. Story's testimony, which again is only relevant to the credibility of testimony given by plaintiff's witnesses. I don't think the game is worth the candle. So I'm going to make that one observation, then I'm going to overrule the objection and permit you an answer.
Would you please ask that question again?
Of course. Does the total abortion ban align with your moral views?
As I read the law, the abortion ban does not include exemption, or it includes an exemption for race or for rape or incest. In my moral understanding, those are living, unique individuals. To end their life is morally wrong.
Okay. Focusing on the medical exceptions to the total abortion ban, do those align with your moral views?
They do.
Okay. And then for the 6-week ban, do the medical exceptions for the 6-week ban align with your moral views?
They do not.
And in fact, you wish there weren't any exceptions to the 6-week ban, is that right?
No, I think that the medical exemption is carefully considered. And an unfortunate challenge is that we do have an imperfect world where we run into patients who are women who are carrying children for whom you may arrive at a between a rock and a hard spot circumstance, and they're tragic.
So you would say, are you morally opposed to the medical exceptions in the 6-week ban as they are stated in the law?
Would you please read them to me?
Sure. Medical emergency under the 6-week ban means a condition that, in reasonable medical judgment, so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create serious risk of substantial and irreversible impairment of a major bodily function.
I do not. I'm not opposed to those.
You're not opposed to those. Dr. Story, you have spoken on podcasts about abortion, is that right?
I have.
And do you recall a podcast that you spoke on October 7th, 2024, with the title Abortion for Dr. Story, It's Personal?
Yes.
And I'm going to show you a copy of that,
Okay.
of that podcast.
Your Honor, I'll object. This goes way beyond the scope of direct.
All right, I'm going to call a halt to this at this point. This is just not material. I understand what it goes to. We have covered that ground enough.
It directly impeaches what he just testified to.
The testimony, no offense to Dr. Story, is not consequential. And it's not because of anything, it's not because of the substance of the testimony, it's because of the limited effect the testimony may have by rule, as already discussed. It's just not consequential. So we're wasting time at this point.
Okay. Dr. Story, you do not provide obstetrics care to your patients, right?
We see patients for their initial evaluation. We help them arrange for the management of that pregnancy. We co-manage medical conditions during that pregnancy, and then we deal with threatened miscarriages and stillborn circumstances, which we're active in helping care for those women and children.
But you refer your pregnant patients to OBGYNs for their prenatal care generally, is that right?
That's correct.
To which OBs do you refer your patients?
We primarily refer to our local obstetricians who are part of Moscow Pullman OB. They're excellent. We also refer to obstetricians that are based out of St. Joseph Hospital in Lewiston, Idaho.
Have you spoken to those OBs about whether they're confused by the bans?
I have been part of the roundtable discussions about the law. The discussion was not regarding confusion about the ban, but concern that the ban might be used beyond what the ban explicitly spoke.
Thank you, Your Honor. No further questions.
All right, thank you, Ms. Dunham. Any redirect?
Quick, Your Honor, yes. So Dr. Story, just want to clarify a couple things. You were asked whether you have met with anybody about this case other than myself and I believe Dr. Skop. So I just want to clarify. You and I met on Saturday morning, and you had one of your partners present at that meeting. Is that correct?
That is correct.
Okay. And we met last night to talk about your potential testimony this morning as well, correct?
Right.
And during that meeting, there were other attorneys in my office present at that meeting, correct?
Right.
And Dr. Skop was also present at that meeting?
Right.
Okay, thank you. I just wanted to clarify that. No other questions.
All right, thank you. Thank you for being here, Dr. Story. You may step down. Greg, you may call your next witness.
Call Dr. Ingrid Skop. And Your Honor, we will have a PowerPoint presentation during her testimony. If we could have that set up, I would appreciate it.
Understood? Good morning, Dr. Skop.
Good morning.
Morning, Dr. Skop. How are you doing this morning?
I'm doing great, thank you.
Could you please state your name and spell your name for the record?
My name is Ingrid Skop, INGRIDSKOP.
How are you currently employed?
I am the Vice President and Director of Medical Affairs of the Charlotte Lozier Institute. I am also working part-time as an obstetric hospitalist in San Antonio, Texas.
And in your role at the Charlotte Lozier Institute, what are your duties?
Charlotte Lozier is a think tank dedicated to science and statistics on life issues. In that capacity, I do research. I publish peer-reviewed studies. I write also papers directed toward laymen to understand the issue of abortion and the harms of abortion that have been documented to women. I have participated in testimony such as this and other types of testimony. I also frequently give interviews and sometimes talks at conferences, et cetera.
And in your role as a hospitalist, what do you do in that position?
In that situation, I'm employed by the hospital for a 24-hour shift. I will cover for private practitioners who may be unable to care for their patients. I will cover for patients who come into the hospital with obstetric needs who either have not had prenatal care and don't have a doctor, or if they have a doctor who goes to another hospital. And also I cover emergencies for gynecology and obstetrics in the emergency room, things like ectopic pregnancy, miscarriage, other gynecologic problems.
And what's the name of the hospital you currently work at?
Mission Trail Baptist.
And where is that located?
It's in South San Antonio.
State of Texas.
Yes, sir.
Are you licensed to practice medicine in the state of Texas?
I am.
Are you licensed in any other state?
No, I'm not.
Where did you go to medical school?
Washington University School of Medicine in St. Louis.
What year did you graduate?
1992.
Where did you go after your medical school?
I moved to San Antonio, where I did my obstetrics and gynecology residency at the University of Texas Health Science Center, San Antonio.
And what type of training do you receive, or did you receive during that residency?
In a general OBGYN residency, we receive training in managing women through their pregnancy, including in complicated pregnancies, training in delivery of babies. We learn to deal with gynecologic issues that may involve surgery, hysterectomy, bladder suspension, ovarian surgery, etc. We deal with pregnancies that have resulted in a natural loss or a miscarriage. And we also learn office practice in managing the needs of women throughout their reproductive lifespan.
And where did you go after that residency?
I joined a obstetric and gynecology practice in San Antonio where I became a partner, and I practiced for 25 years.
And then after that is when you went to the Charlotte Lozier Institute and opened up your own practice, or I'm sorry, and then worked as a hospitalist?
Yes, in 2022.
Have you ever provided expert testimony in any other cases?
I have.
And have you provided expert testimony before state legislatures?
I have.
And with state legislatures, can you just briefly describe what that testimony has entailed?
Sure. I've provided oral testimony beginning in Texas, but I also have provided testimony as legislatures were considering legislation on abortion in Nebraska and in Montana. I've also provided written testimony in probably a dozen states related to that.
And have you testified before Congress?
Yes, I have.
When was the first time you testified before Congress?
It was in September of 2021.
And you were invited to by a congressperson to testify?
Yes, that was invited testimony to the U.S. House Oversight Committee.
And have you testified before Congress at any other time?
I have since then testified to the U.S. Senate Judiciary Committee on 2 occasions.
And was that also at the invitation of members of Congress or members of the Senate Judiciary Committee?
Yes, it was on invitation.
And have you published any peer-reviewed articles in your areas of expertise?
Yes, I have probably 12 to 15 articles.
You also served as a peer reviewer?
Yes, I do.
And what is a peer reviewer and what is a peer-reviewed article?
So a peer-reviewed article is research that has been reviewed by someone who's an expert in the field to determine if it is high-quality research, if it adds to the fund of knowledge, and once a reviewer looks at a paper, they may recommend that the paper not be published. They may recommend that the paper be published with modifications, or they may say publish this as is. So I have been on both sides of that process.
In your experience as an obstetrician, approximately how many babies have you delivered?
I believe I've delivered over 5,000 babies.
And approximately how many pregnant women have you treated in your time as a physician?
Well, that would be in the tens of thousands.
And have you treated women with high-risk pregnancies
Many times,
and with pregnancy complications?
yes.
I want to go back a little bit, talk about your testimony before Congress in a little more detail. What was the nature of your testimony?
In each of those situations, there was a hearing called because of concern about Texas abortion legislation. And so I was able to give knowledge on what the laws actually said, on what the practice of obstetrics looks like and how we do deal with complications. More generally, I was able to talk about the women that I've cared for in my practice over 30 years who have chosen abortion and the subsequent complications that I have treated them for, which can include immediate and long-term physical complications, many mental health complications, and just was able to convey the research that I've done about those issues.
Were there any repercussions that you faced in your professional career as a result of your testimony before Congress?
Yes.
Could you please describe that?
I have been subjected to misrepresentation in social media and in mainstream media. In fact, my group was also subjected to aggressive attacks in the wake of that initial testimony. It was uncomfortable for my partners, and as a result, I decided to retire to do this work full time. There's a need for that because many obstetricians who want to speak about this issue do receive similar attacks. In fact, in 2022, the American Board of Obstetrics and Gynecology, which is the organization that maintains our board certification that allows us to practice, published a letter saying that any obstetrician disseminating misinformation or disinformation about abortion could lose their medical board certification.
And do you have that board certification?
I still do have that board certification. I think it's a bullying move, but it did happen, and it is out there, and it does influence many doctors from speaking about this issue.
And have people used that to threaten you?
Yes, they have.
You serve on the Texas Maternal Morbidity and Mortality Review Committee, is that correct?
Yes, I do.
And describe your work on the Texas MMRC.
So this is a 23-member multidisciplinary committee. We have obstetricians, we have maternal fetal medicine high-risk obstetric specialists, as well as psychiatrists, medical examiners, other professionals who are interested and knowledgeable about the issue of maternal mortality. Our job is to review the deaths that have occurred temporally related to pregnancy. That means either during pregnancy, at the time of delivery, or within a year of the end of the pregnancy, because that is the CDC's definition. We review those records thoroughly, and then we determine if they were actually pregnancy-related, that is caused by the pregnancy, and we give recommendations on how to avoid these type of deaths in the future.
And how long have you served on the Texas MMRC?
I began serving in June of this year.
So Dr. Skop, when does life begin?
Science demonstrates that at the time of fertilization, a new human being comes into existence. He begins rapidly dividing, metabolizing, growing, differentiating, and he has a human genetic code that is different from his mother. So there's no doubt that is when human life begins.
And how is that put into practice when you treat pregnant women?
Well, I have the privilege and sometimes the burden of having two patients whose needs I must constantly be considering. So from the time a woman comes to me with a positive pregnancy test, I am considering what is best for her and what is best for her unborn child.
And is it commonly accepted that an obstetrician or any physician treating a pregnant woman has two patients?
In reality, that is commonly accepted, despite some of the vocal voices that you'll hear. Surveys demonstrate that 86 to 93% of practicing OBGYNs will not perform an elective abortion.
And how does medical ethics affect the fact that there are two patients?
Right, so we have a two-patient paradigm. The pillars of medical ethics.
Your Honor, I don't think there's been a foundation laid for Dr. Skop as an expert in medical ethics.
I'm an ethical obstetrician.
So, if you would rephrase the question, I had trouble understanding exactly what the question was getting at.
Sure, Your Honor, and maybe I'll back up and lay a little bit more foundation if that's okay.
All right, go ahead.
Thank you. Dr. Skop, when you treat patients, are there medical ethics that you try to abide by?
Yes, every medical student learns the principles of medical ethics.
Why is that?
Because it's critical, lays the foundation for how we should treat our patients.
And is that something that you implement in your practice as a physician?
Yes, I do.
Is that something that you consider when you treat patients?
Yes, I do.
Why is that?
Because my job as a physician is to look out for the needs of my patients, to practice beneficence, non-maleficence, allow patient autonomy, and to have justice for my patients, which are the 4 pillars.
And so how do those pillars apply to your treatment of a pregnant woman?
Well, in that situation, I have 2 patients, and I need to practice with ethical considerations toward each of those patients. I think we can readily recognize that the fetal patient who is targeted by abortion is not being treated in a beneficent way. That is not a non-maleficent action. My pregnant mother does have autonomy, but there are limits to autonomy.
Your Honor, again, I don't think there's a foundation for Dr. Skop to be giving her opinions on medical ethics. And I'm happy, if I could ask even a single question, inquire to lay a basis for my objection.
Go ahead.
Dr. Skop, you do not hold yourself out professionally as a medical ethics expert, correct?
No. But this is what doctors learn as part of their training.
And when you say no, you mean that's correct, right? You do not hold yourself out professionally as a medical ethics expert?
I am not a medical ethicist, that's correct. I'm a physician who's been trained in ethics.
Thank you.
Right. Well, the objection is not that this was not part of the expert disclosure, but rather that the witness is not qualified to opine on issues related to medical ethics.
That's right, Your Honor. This is a unique area of expertise. And Dr. Skop has admitted that she does not hold herself out professionally as a medical ethics expert.
Your Honor, if I may, the question was related to her and her practice and how she implements these medical ethics in her own practice.
Your Honor, Dr. Skop is not here as a percipient witness. She's here as an expert.
I'm going to overrule the objection.
Dr. Skop, how do you implement those medical ethics when you treat a pregnant woman?
Well, I consider whether any action that I might be considering would be beneficial to each of my patients. The flip side is that it would not harm them. It would be non-maleficent. That it would respect patient autonomy, but autonomy ends when we're talking about another individual's body. And of course, I should seek justice for both of my patients.
We're here to talk about Idaho's abortion laws, but before we do that, I want to talk a little bit about abortion. How does an abortion affect the unborn child?
Every successful abortion ends the unborn child's life.
Can you please tell me, and I just want the names, I don't want descriptions at this point, but if you could just tell me, what are the different types of abortions commonly used today?
The most common form is a medication abortion up to 10 weeks. In the first trimester, we can also can be performed a suction aspiration procedural abortion. Later, abortions can be done by dilation and evacuation procedural abortion, or very late abortions are sometimes done by labor induction.
So could you please describe what is a medication abortion and when is it used?
The 2 medications that are approved by the FDA are mifepristone, which blocks the critical hormone progesterone that keeps the pregnancy going, causes the unborn human to die. It's followed generally about 24 hours later by misoprostol that induces contractions. Essentially, it causes the woman to go into labor to deliver her dead baby and the associated placental and pregnancy tissue.
And what is an induction abortion? Can you please describe that?
So an induction abortion done later is usually with also mifepristone and misoprostol, or sometimes misoprostol alone, or other agents like Pitocin, and it induces labor, but the intent is that the baby does not survive. Sometimes feticide, which is an injection to cause the baby to have a heart attack, will be given beforehand. Or if that's not done, the hope of the abortionist is that somehow the baby will die during labor so that he won't be born alive and then need to be killed by passive or active infanticide.
And then you talked about a suction and aspiration abortion sometimes used early on. What is that?
Yeah, so this is a minor surgical procedure, and it is the same procedure that we would use for a miscarriage to remove the tissue. So the cervix is dilated. We introduce a suction curette and apply vacuum suction, and it removes the tissue. In the case of an abortion, it kills the baby, removes the tissue. In the case of a miscarriage, it removes the tissue that has already passed away.
I want to talk about dilation and evacuation abortion, but before we go into the details, do you have a PowerPoint presentation to use as a pedagogical aid for you to show what the dilation evacuation procedure is?
I do.
And did you work with the person preparing the PowerPoint slides?
I did.
And will it help you as you describe this or as you describe the dilation evacuation procedure?
Yes, it will.
And did you have final authority over the contents of the PowerPoint slides?
I did.
So, Your Honor, at this point, I'd ask permission to be able to use this slide deck and to publish it during her testimony. I've provided copies to counsel in the court.
Your Honor, we do object to the slides. Any marginal relevance that they may have to defendants' positions in this case are far outweighed by the prejudicial and inflammatory nature of these graphic slides, which are not medical slides, but intended to inflame the audience, and it's just not necessary for the presentation of their defense.
All right. Is there, I didn't hear in the objection a concern about the perceived accuracy of the slideshow. That's not part of the basis for objecting?
I do have that. That was embedded in my comment that this is not a medical presentation, right? This is what I understand to be, these were taken from a website, Live Action, which is an anti-abortion ideological group. And this is, the best word I can come up with is propaganda that's placed on their website in furtherance of their anti-abortion ideology, not medical depictions of how a D&E is provided.
If you want to inquire of Dr. Skop before before an opportunity to show the slides is extended concerning any respects in which the slides are not an accurate depiction of a dilation and evacuation procedure, you're welcome to do that. Now, the point about the lack of necessity and/or inflaming or prejudicial effect, the validity of that point depends heavily on the audience, and the audience nominally is me and not a jury, and I can assure you that there will not be any prejudicial or inflaming effect on me in terms of how I decide the case from what I see in the slideshow. I'll consider the evidence for whatever it's worth, but there will not be some sort of undue effect. If you would like to examine the doctor on the topic I've permitted, you may. If you don't want to, that's fine.
Your Honor, I'll just ask one question.
Right.
Dr. Skop, in selecting the slides that are in your PowerPoint presentation, did you endeavor to review them all and ensure that they are medically accurate graphic depictions of this procedure, including with regard to things like scale?
I believe these are medically accurate. Obviously, they're a cartoon version. I suspect the reality might be even more difficult for the audience to see.
Thank you, Your Honor. I have no further questions right now.
All right. I'll permit it. Go ahead.
Thank you, Your Honor. We could have the. So, Dr. Skop, could you give a high-level overview of what a dilation and evacuation procedure is in terms of when it is used and why it is used before we go into the details of it?
So a dilation and evacuation is generally used when the fetus has calcified bones. He cannot be as easily removed through suction as he can with a suction aspiration. Generally, that occurs about 14 to 15 weeks gestation. These do account for about 95% of later abortions.
So let's talk about the dilation part of the dilation evacuation. What does the dilation part mean?
Yeah, and if I could back up for just a minute, the very first step on any medical procedure is informed consent, which in this case should include risk, benefits, and alternatives, with the alternatives being continuing the pregnancy to give birth to a child. And as we discussed, the other alternative at this gestational age is a later medication abortion. Even prior to dilation, some doctors will offer feticide. That means that they will intentionally end the baby's life so that that baby, as we'll see in a minute, does not have to go through the complete procedure, potentially still alive. A recent survey of later abortion providers documented that 7 out of 10 do not routinely end the baby's life before the procedure. If it is chosen, it's an amniocentesis, which is an injection through the woman's abdomen, through the uterus, into the amniotic fluid, or into the child's heart, injecting potassium chloride or digoxin to induce a heart attack. Dilation, the cervix is not ready to have a baby yet because, again, generally these occur in the mid-trimester. So to ripen and prepare the cervix, one of several things may be done. This picture on the left demonstrates laminaria, which is a hydroponic seaweed that is placed in the cervix, absorbs fluid, and begins the dilation process. Mifepristone and misoprostol that I mentioned earlier can also be used. Sometimes a combination of methods will be used. When the cervix has softened enough, then mechanical dilators will be used to progressively open the cervix, and that's the picture that you see here on the right, that allows instruments to be introduced into the uterus.
So then let's go to the next slide. What is the next step after the dilation part?
The next step is suction, which you see here, and that will remove most of the amniotic fluid. It also serves to bring the child closer to the cervix to facilitate the next step.
And what is the next step after that?
The next step is that an instrument called a Sofer clamp will be introduced, and the fetal part that it encounters, it will grasp, and with traction will avulse or disarticulate that fetal part. In this particular case, we have a baby in a breech presentation, so his legs are removed first. And then the abortionist will continue in the process, grasping abdomen, grasping thorax, upper extremities, ultimately leaving just the head.
So we'll get to the head in just a minute, but how many passes might it take to remove the rest of the baby other than the head?
It can depend on the gestational age. It can also depend on the skill of the abortionist because this is quite a complicated procedure. I would say probably 6, 8, 10 passes. Ideally, this should be done under ultrasound visualization to decrease the rate of complications and to help the abortionist to ensure that he is removing all of the fetal parts.
So then what happens, you mentioned removing the head, so let's talk about that.
Right, so that's going to be bigger, and so it does require using the clamp to crush the skull in order to remove it through the incompletely dilated cervix. Following that, also the placenta needs to be removed, and this can be done with suction or with the grasping clamp. At the conclusion of that, an instrument will be used to verify that the cavity is empty and that all of the fetal parts and the placental parts have been removed.
So then let's talk about verification. Describe that.
Yeah, so the abortionist does need to take all of the parts that he's disarticulated and removed and reassemble them to verify that he's not left any parts behind.
And why must the abortionist do that?
Leaving fetal parts behind, either placenta or parts of the baby, can have devastating complications for a woman. Likely can lead to infection. It can lead to continued bleeding. One particularly devastating complication that can occur with this procedure is perforation of the uterus. This can result in either extrusion of these parts into the abdominal cavity, or conversely, bowel and surrounding organs of the woman can be drawn into the cavity or into the uterine cavity. Additionally, further in gestation, the uterus has quite a large blood supply, and damage to uterine vessels can occur, even leading sometimes into debris entering a woman's bloodstream that can lead to amniotic fluid embolus, which can be fatal.
That concludes the PowerPoint presentation. Dr. Skop, are unborn babies able to feel pain?
Objection, Your Honor. No foundation for expertise in the area of fetal pain.
Doctor, I can ask some questions and lay a foundation.
Go ahead.
Dr. Skop, have you reviewed research and studies on when babies are able to feel pain?
I have.
And in your own experience as an obstetrician, have you made observations about when babies are able to feel pain?
I have seen babies, unborn babies, who look like they're feeling pain, yes.
And when are unborn babies able to feel pain?
Well, pain perception, not surprisingly, is a continuum. Sensory receptors are present at 7 weeks gestation. The pain receptors attach to the midbrain around 15 weeks gestation. At that time, when I have done a procedure like an amniocentesis, where perhaps if the needle inadvertently hit the baby, I've seen the baby respond in exactly the same way I would anticipate that you or I would. They withdraw that limb. They have vigorous movements to get away from that source of pain. It has been documented in studies that their heart rate increases, blood flow to their brain increases. If you measure what's going on in their bloodstream, you discover that adrenaline increases, as well as what we call endogenous opioids. These are substances that the body produces to try to tamper down the experience of pain. So all of those things can be measured at about 15 to 16 weeks gestation.
Your Honor, we move to strike that testimony as unsupported, and if I may, I would just like to inquire to lay a few foundational questions to my objection.
Your Honor, that's appropriate for cross-examination, or it's appropriate for rebuttal if they want to call their own expert witnesses. It's not appropriate for them to interrupt the testimony at this point.
All right. We can get at the matter on cross. Go ahead.
Understood. Thank you.
Your Honor, now may actually be a good time to take the lunch break. I'm getting into another area that might take me a little while to get through, so.
Okay. I'm fine with that. It's about 11:50. We'll take our lunch break now and reconvene at 1 o'clock. We'll be in recess.
All rise.
All right. Mr. Craig, you may resume your direct examination of Dr. Skop.
Thank you, Your Honor. Dr. Skop, I want to talk about the risks of abortion. So what risks does having an abortion entail for the pregnant woman?
Any abortion can result in bleeding, infection, retained fetal or pregnancy tissue. Some more serious concerns that can happen can be uterine perforation, damage to the lining of the uterus that can result in future pregnancy complication. Very serious complications can include significant damage to blood vessels that can lead to amniotic fluid embolus or other embolic phenomenon from material entering the bloodstream. Additionally, it has been reported that perforation of the uterus can lead to damage of bowel, bladder, surrounding organs, including kidney. Short of the physical complications, abortions may lead to mental health complications in some women, anxiety,
Objection, Your
substance and
Honor.
alcohol abuse.
Plaintiffs have an objection to Dr. Skop testifying about mental health issues, and our position is that she's not an expert on mental health. I am heeding the court's guidance from earlier this morning, and so if your preference is for us to address that in cross, we will. I just want to make sure that's preserved on the record.
All right, understood. The objection is made, and if let's just deal with it on cross. All right, you may continue.
Thank you.
You may continue your answer.
Okay. Anxiety, sometimes depression, self-harm, potentially leading to deaths of despair, like suicide, accidental deaths, opioid overdoses.
So let's talk about, I want to go back to the physical risk, but let's talk about the mental health risk a little bit. Have you treated women who have had mental health issues?
Yes, I have.
And women specifically who are pregnant who have had mental health issues?
Yes, about approximately a quarter of the reproductive age population of women in this country does have a mental health diagnosis. It's very common.
And you've reviewed the literature, the academic literature on mental health issues in pregnant women as it relates to abortion?
I have.
Does having an abortion reduce the risk of suicide among women who have mental health?
There is no evidence that that is the case. In fact, high-quality studies from Europe document that a woman is 6 times as likely to commit suicide in the year following abortion compared to if she had given birth.
Let's go back to the physical risk again. Can abortion be fatal for the woman who undergoes an abortion?
Yes, it can.
And what circumstances might lead to the death of a woman who have had an abortion?
I mentioned bleeding. A woman could experience a hemorrhage that could result in her death. Infection can occur, and again, if not promptly treated, could result in death. And this was demonstrated recently when a woman named Amber Thurman died in Georgia from complications of a mifepristone misoprostol drug-induced abortion.
There's been significant testimony from plaintiffs' experts during this trial, and have you been following that testimony and reviewed that testimony?
I have been, yes.
And have you heard them testify that women are 14 times more likely to die from childbirth than from having an abortion?
Yes, I've heard that.
Do you agree with that statistic?
No, I don't. And it's important to understand that there is nothing in the United States that is mandatory about abortion data collection. We don't know the numbers of abortions, we don't know the complications, and we certainly do not know the deaths that follow abortion, particularly because deaths are counted to a year after the end of the pregnancy. Most deaths that are detected are found on death certificates by the CDC, and many of these women who die subsequent to an abortion, their death is never known on a death certificate, or their abortion is never known on a death certificate.
So if it's not reported as an abortion-related death on a death certificate, how does one determine whether a death is abortion-related?
Well, we can't even start the process because what maternal mortality review committees do is they look at the death certificates and then they do a deep dive into the medical records or the social history. So without that information, we don't even know to look. However, again, those better quality European studies document that after if a woman dies within a year of an abortion, only 1 out of 20 have that abortion notated on their death certificate. So it tells us that our data that we detect is only the tip of the iceberg related to abortion deaths.
Are you familiar with the term linkage study?
Yes.
What is that?
Yeah, so to back up for just a minute on our data deficiencies, the abortion industry publishes studies. They know how many abortions they sold, but in general, between 15 and as many as 50% of the women are lost to follow-up. They don't know all the complications or deaths that occur. Conversely, if we know complications and we ask women if they've had an abortion, many times they don't want to tell us. And so on both ends of that, we cannot get good data. Records linkage is looking when an insurance company buys an abortion and then looking at all the subsequent medical events that that insurance company pays for. That's a very accurate way to detect the abortions and the subsequent medical events. Again, those studies that I mentioned in European countries that document far more deaths in the year following an abortion than following childbirth use that more high-quality records linkage data.
And what do those studies from Europe show regarding the risk of dying from childbirth versus the risk of dying from an abortion?
Well, what we see at the end, at the year following that pregnancy outcome, is that a woman is 2 to 4 times as likely to have died if she obtained an abortion. And as I mentioned, 6 times as likely to have committed suicide, 5 times as likely to have died of an accidental death like an overdose, and 10 times as likely to have died from homicide, usually a domestic partner. Obviously, that doesn't tell us that all of those were related to the pregnancy event, but if we really cared to know, we would start there and then we would go backwards and look at the corresponding data, medical records, to determine how many of those deaths were actually related to that abortion. That would be the best way to find the answer to that question.
So it's your testimony that 14 times more likely to die from childbirth is not accurate simply because the statistics behind it are not accurate.
Yeah, absolutely. So that compared 4 disparate numbers. It compared abortion-related deaths, which we don't know accurately. It compared all maternal deaths, which we also don't know accurately. We don't even pick up all of the deaths related to women who go to term. It compared the numbers of abortions. As I mentioned, we don't know the numbers of abortions. The CDC reports about 30% less abortions than the Guttmacher Institute does, so we don't know. And the only one of those statistics that we know accurately, they actually compare it to the number of live births because we do give birth certificates. But you can also see intuitively the problem there. The denominator should be all the at-risk individuals. It should be all the pregnancies so that we can compare apples and apples. But we don't know the number of pregnancies in the United States, so we end up going with the only denominator that we can accurately determine. And again, we're looking at different denominators. We look at 100,000 abortions versus 100,000 live births. So again, we're not really comparing accurately. And so this study, the authors should have known. They both worked for the CDC, but I think this study was published for reasons of ideology.
You yourself have done some records linkage studies, correct?
Yes, I have.
And can you describe those studies that you've done?
So in the United States, again, most abortions are not paid for with insurance, and so One way to find the number of, accurately, abortions that have been paid for is to look at the 17 U.S. states that use their state Medicaid money to pay for elective abortions. So we did obtain that data, 15 years worth of data, over 420,000 abortions. We were then subsequently able to link those known abortions with subsequent medical events.
And what did your records linkage studies show?
It showed some very surprising findings. Regarding the early medication abortions that I mentioned earlier, mifepristone and misoprostol, we discovered that 1 out of 20 women went to an emergency room with complications in a month following that abortion. And when we looked deeper, we discovered that 60% of those women were miscoded as having a complication due to a miscarriage rather than abortion drugs. Women are being told not to tell the doctors that it won't make a difference, but a follow-up study documented that the women who were miscoded, it took them 3 emergency room visits before they got the treatment they needed, which was generally a suction aspiration to remove the retained tissue that their body had not been able to expel.
So based on the studies that you've done, what are you able to conclude regarding the risks of abortion based on your studies?
Well, regarding the risk of medication abortion specifically, it is not safer than Tylenol as promoted to women. It is quite dangerous. In the meantime, the FDA has removed many important safeguards, so it's becoming even more dangerous. And I've seen many women in the emergency room suffering complications. So it's been borne out with my clinical experience as well.
Suffering complications of a medication abortion, you mean?
Yes.
And you've published some peer-reviewed articles on those studies, is that correct?
Yes, we have.
And where were those articles published?
We've published a number of articles related to this data bank on different issues. The ones that I specifically just mentioned were published in Health Researchers Epidemiology.
And some of those studies, the journals have retracted those articles, is that correct?
That is correct.
And what is the reason that they gave you for retracting those articles?
They didn't really give a good reason. These studies were used in a lawsuit that went to the Supreme Court earlier this year. So I think there was likely some political motivation because this was very difficult data when you want to maintain that abortion drugs are safe. The Committee on Publication Ethics, which tells us what should warrant retraction, says that a study should be retracted if it is fabricated, or if it is misleading or misrepresenting the data. And no one has proven that any of our data was misrepresented or fabricated or falsified. So there were no reasons for the retractions, and it is being litigated. I have no doubt that these studies will be published again in the future.
The studies that you have done, that you've personally been involved in, show that these medication abortions are not safer than Tylenol and actually have significant risks. Is that correct?
That is correct.
In this case, plaintiffs are asking the court for a declaratory judgment that abortions should be allowed any time an emergent medical condition threatens the life or health, including her fertility, of the mother. Have you seen that?
I've seen what they're requesting, yes.
And they define emergent medical condition in their complaint as a condition in which the, quote, patient presents with symptoms of an illness or injury that may progress in severity or result in complications with a high probability for morbidity if treatment is not begun quickly. Have you seen that before?
Yes.
I want to talk about that definition and how it might apply in some specific scenarios. First of all, what is morbidity?
Morbidity is a complication related to pregnancy that does not result in death, but results in significant impairment to a woman.
So let's talk about some specific scenarios. There's been some discussion throughout this trial about rusty nail scenario, a woman stepping on a rusty nail. When you treat a woman who steps on a rusty nail, what do you have to be concerned about?
Well, we're concerned about infection, so we will evaluate the wound, disinfect, stitch the wound if we need to, and we will offer a tetanus booster if she's not had one recently to prevent the risk of tetanus.
So if there's a puncture wound from the rusty nail, would that be considered an injury?
Yes.
And would that, is there potential for that to progress in severity or result in complications with a high probability for morbidity if treatment is not begun quickly?
Yes.
And why is that?
Because we know that the outcome of that disease process, if an infection occurs, if it's allowed to progress without treatment, can be significant morbidity or even death.
And would you treat a pregnant woman who steps on a rusty nail with abortion?
No, of course not.
Why not?
Because that's not the treatment that she needs. We need to target our treatment to the need, and in her case, I just discussed the treatment that would be best for her.
That would be a tetanus booster shot.
Yes.
Let's talk about some other situations that have come up during the trial. You familiar with the term PPROM?
Yes.
What is that?
Well, it's an acronym, and it's important to explain what the P's all stand for because it can be confusing. Regarding what we're discussing here, the first P is pre-viable. So this means that the rupture of membranes has occurred before the baby has reached a gestational age where he can survive separated from his mother. The second P is premature, which indicates that the rupture of membranes has occurred before labor has started. If a woman presented with ruptured membranes, but she was in labor, there's no decision to be made. She will deliver. But in this situation, the question is what to do next.
And have you treated in your practice women who have had PPROM?
Yes, I have.
And what is the treatment? And again, let's talk about pre-viability. What is the treatment for a woman with pre-viability with PROM?
So the obstetric literature is uniform on this. ACOG, the Society for Maternal Fetal Medicine, both say that there are three options. One is expectant management. If a woman, in many cases, a woman may develop an infection, but if she does not have an obvious infection, there is not a requirement to do anything at that moment. Close observation is appropriate, probably giving some antibiotics to avoid infection, and monitoring to see the most common outcomes is that she will either progress into labor and deliver, or that we will see clinical signs of an infection. If she develops an infection, we cannot adequately treat the infection without delivery, without removing the fetus from the uterus. This can be done in one of two ways. This can be done by, usually it's done by induction. So we induce labor, the child delivers. If it's truly pre-viable, very likely the child does not survive delivery. Another option, which is allowed by the law, is a dilation and evacuation abortion. I described that procedure earlier. In my experience, when women are in this situation, they usually do not want a D&E. Even though they may recognize that their child is likely to die, they would prefer induction. They would prefer to be able to hold that baby, show that baby love, and say goodbye to the child.
So is an abortion necessary to treat PPROM in most circumstances?
Abortion as defined with the intent to end the unborn child's life by a D&E is not necessarily the procedure that should be done. An induction will accomplish that purpose just as well, and it does fulfill Idaho law's recommendation that this be done in the way that can best allow the child a chance at survival, if possible.
Many of those situations can be treated with expectant management. Is that correct?
Yes, there can be nuances, but I've found that many women are willing to take a risk to their own health in order to give their baby a chance at life. And again, it may depend on the gestational age and the clinical scenario, but many women are willing to try to remain pregnant in hopes that their child can survive.
You familiar with the term preeclampsia?
Yes.
What is that?
Preeclampsia is hypertension caused by pregnancy, often associated with protein in the urine, which is a sign of damage to the kidneys, and often swelling.
And when is it typically diagnosed in pregnancy?
Generally, we diagnose preeclampsia much later in pregnancy. Almost all of the time, preeclampsia is diagnosed after the baby has the ability to survive delivery. And
what is the treatment for preeclampsia?
Preeclampsia can be on a continuum, and it depends on the gestational age. It also depends on the associated features. If we have preeclampsia with severe features, which is an indication that we have neurologic damage, severe kidney damage, liver damage, intravascular damage, the severe or blood pressures that cannot be controlled with medications, then in that situation, we will usually move toward delivery. If it is at term, we will move toward delivery. But if it does not have severe features and we're dealing with a preterm child, then often we will try to expectant management to gain some more time so the child could do better when he's delivered.
You're familiar with the term placenta abruption?
Yes.
What is that?
Placenta abruption describes the placenta separating in part or completely from the uterine wall.
How do you treat a pregnant woman with placenta abruption?
It can depend on the degree of abruption. Sometimes you have a very minor or a marginal abruption where you notice some bleeding, and yet the child is doing well and the mother's doing well. That situation can be managed expectantly, perhaps in the hospital where we watch to see if things progress. If we have a catastrophic or a large-scale abruption, for one thing, it does pose a risk to the baby's life. So again, if this is a baby that is of a gestational age where he can survive delivery, the treatment may be delivery. This can be very life-threatening for a woman, particularly if it's associated with a lot of bleeding. It can also lead to what we call disseminated intravascular coagulation, which is an abnormal activation of the clotting system. So it can be quite dangerous. But again, if it's of that degree, the solution is delivery and caring for both mom and baby.
And the solution for delivery, is that because it'd be necessary to prevent the death of the woman?
The death of the woman and potentially the death of the child.
Familiar with the term subchorionic hemorrhage?
Yes.
What is that?
It's describing a similar situation. We usually use the term earlier in pregnancy. A woman may present with bleeding in the first trimester, and on ultrasound, we may see evidence that there's blood behind the placenta. So the placenta has had a minor separation, and there's some blood accumulating there.
And what's the treatment for that?
Well, if the baby's still alive, the treatment is expectant management as well. If it is a significant subchorionic hemorrhage, then generally it will disrupt the blood flow and cause the baby to die. And in that situation, we would pursue standard miscarriage management.
Are you familiar with the term placenta accreta syndrome?
Yes.
What is that?
This is a very serious condition where the placenta has invaded generally into the muscle of the uterus, sometimes through the wall of the uterus, and occasionally into adjacent tissue like the bladder. The concern is at the time of delivery, there can be catastrophic bleeding because it's very difficult to separate the placenta from the uterus.
And how is that treated?
Generally, that is treated with very close management, continuing the pregnancy, bringing in a multidisciplinary team, because sometimes at the time of delivery, a cesarean hysterectomy needs to be done. So often we will bring in oncologists, general surgeons, interventional radiologists. It's a very serious situation for a mother. But if the woman is not bleeding, there is no indication for ending the pregnancy at that time. We just prepare for delivery, and when she does require delivery, we have a team assembled to take care of her needs.
And will an abortion be necessary to protect the woman in the placenta accreta syndrome?
It's important in this situation to recognize that the problem is already there when we diagnose it. So even if, for example, she's 16 weeks and we discover the problem, whenever that pregnancy ends, the potential for catastrophic hemorrhage occurs. So doing an abortion at that time, ACOG has reported that there's no evidence that an abortion is going to do any better than going to term and taking care at the time of delivery. But of course, the abortion would end the child's life, potentially for no benefit for his mother.
You familiar with the term hyperemesis gravidarum?
Yes.
What is that?
Hyperemesis is severe nausea and vomiting related to pregnancy, which can be difficult to control and in rare situations can lead to electrolyte abnormalities that can threaten a woman.
How is that treated?
Well, fortunately, we do have very good anti-nausea medications available that we can use in pregnancy. So generally, this can be managed with medications. On rare occasions, I've had patients so severely affected that I've needed to arrange home health and IV fluid as well as intravenous Zofran or other medications. But fortunately, these days we do have the medications where we can usually manage this condition.
And is an abortion ever necessary to treat hyperemesis gravidarum?
I have never seen that to be necessary.
And all these scenarios that we just talked about, would you consider those to be emergent medical conditions?
Yes, they could all be emergent medical conditions.
We could go on probably for days and days and days asking about various scenarios. I'm not going to do that. So I'll ask one other question related to this. Well, maybe more than one. How often are abortions necessary to protect the woman's life?
It's very rare to need to perform an abortion to protect a woman's life. I would note that since the Dobbs decision overturned Roe v. Wade and many states did implement abortion limitations, every state has an exception for an abortion to save a woman's life, and to date, 300 abortions in our country have been reported for that reason. In Texas, we've had 118 abortions performed for that reason. By comparison, we have about 400,000 deliveries every year in Texas.
Are abortions ever necessary to protect a woman's fertility?
The situations where I can think that a woman's fertility was at significant risk are also situations where I think her life is at risk. For example, we talked about pre-viable rupture of membranes. If a woman developed an infection in her uterus, that could damage her reproductive tract, but it also could progress to sepsis that could kill her. So in that situation, Idaho law already allows the intervention. Similarly, the abruptio placenta that we discussed, if the bleeding is such that we worry that this is going to damage the uterus, the bleeding is also such that it could kill the woman, and intervention is allowed.
Let's talk about women with pre-existing or underlying medical conditions. Are there situations in which a pregnant woman might have a medical situation unrelated to the pregnancy but might be exacerbated by the pregnancy?
Yes.
And how do you handle those situations?
Well, sadly, the United States does have a problem with chronic illness in reproductive age women. So there are many women who have pre-existing obesity, hypertension, diabetes, perhaps autoimmune disease, sometimes pre-existing cardiac disorders. But the beauty of American medicine is that we also have very, very effective ways to help these women through a pregnancy, to treat her if she does develop complications that don't require sacrificing her baby. So I've cared for many, many women with complicated pregnancies in San Antonio because all of those conditions I just mentioned are very, very common, perhaps as much as a third of the pregnant population, and yet we are able to get these women through the pregnancy safely, often in consultation with maternal fetal medicine specialist whose job it is to help women make it safe, women and their children make it safely through a pregnancy.
Let's talk about women with mental health issues. We've talked a little bit about it in relation to risk of abortion, but now I want to talk about it in relation to emergent medical conditions. I believe you testified that approximately 1 in 4 pregnant women have mental health issues. Is that correct?
That's correct.
Is an abortion ever necessary to treat a woman with mental health issues?
I have never seen a situation where that could be justified. As I mentioned earlier, knowing what we know about the increased suicide rate following abortion, I think we might actually be placing a woman at higher risk for an adverse mental health outcome if we offered her an abortion in that situation. It's been pointed out I'm not a psychiatrist, but I do frequently care for women who have mental illness. Additionally, I am married to a psychiatrist, so I have an at-home consultant, and I've discussed this issue with him and with other consultants. And I do know that if a woman has refractory depression that is not responding to medications, of course we have many medications, but if nothing is working, electroconvulsive therapy is considered to be the next best option for her, and that can be done safely in pregnancy. Additionally, if a woman is really felt to be at risk of harming herself, inpatient psychiatric hospitalization is a common situation to prevent her from harming herself. None of those require ending the child's life in order to protect the mother.
Let's talk about lethal fetal diagnosis. Are you familiar with that term or similar type terms?
I'm familiar with the term. The current preference is to call those life-limiting fetal diagnoses because we recognize that there is no diagnosis that is uniformly fatal at the time of delivery.
What do you mean by that, that there's no diagnosis that's uniformly fatal?
Well, even the most severe abnormalities, we may think something like anencephaly, or I think we've talked today about trisomy 13 and 18. Those were commonly called lethal diagnoses. But current studies document that about 70 to 80% of those children survive birth. And of those who survive birth and are given active management, because unfortunately I think there is a self-fulfilling prophecy that comes about sometimes that doctors aren't willing to intervene for these children when they have medical needs because of their diagnosis. But if we take care of their needs, with trisomy 13, about 20% will survive to be a year old, about 13% survive to 10 years old. Similarly, trisomy 18, around 13% survive to be a year old, and 10% survive to be 10 years of age or more. So these children, certainly they have disabilities, but they are not uniformly fatal diagnoses.
So did you review Dr. Winstrom's testimony about a research study she conducted 30 years ago on how to diagnose trisomy 21, trisomy 18, and trisomy 13?
Yes, I did.
You heard her testimony where she testified about the survival rates for babies with those conditions in her study.
Right, that was based on old data, but more recent data is more favorable for these children.
So let me ask you that. Are you familiar with more recent studies that talk about the survival rates of babies with trisomy 18 and 13, for example?
Objection, Your Honor. I don't think this was disclosed in Dr. Skop's expert report.
Was it? Can you point to it?
This goes directly to impeach Dr. Winstrom's testimony about how she was not familiar, not sure whether the survival rates in that study that she cited were still accurate. So this goes directly to that.
All right, but
Your Honor, Dr. Skop devoted a section of her report to rebutting Dr. Winstrom. She disclosed how she would be responding to and rebutting Dr. Winstrom. It did not include this testimony, and so we didn't have an opportunity to probe and explore it.
all right. Well, it sounds to me like it's a topic for rebuttal of plaintiff disclosed expert testimony. Defendants need to come forward with, if they're going to attempt to rebut it through expert testimony, with a disclosure. What I hear you saying is, I think you're acknowledging that you didn't in this instance.
There was certainly discussion about babies with lethal fetal diagnosis in general in that discussion. I don't think there was discussion specifically about the survival rates of trisomy 21, 18, and 13. But again, this directly impeaches Dr. Winstrom's testimony.
All right. Well, I'm going to sustain the objection in this instance. If it's not disclosed, it's not in bounds.
Are you familiar with the testing that is used for to determine if a baby might have a lethal fetal diagnosis?
Yes, I am.
Are you familiar with how accurate some of those studies are, or some of those tests are?
Yes, I am.
And what do you know about the accuracy of those tests?
Well, unfortunately, particularly in young women, the false positive rates of those tests are extraordinarily high. In fact, within the past year, there was a recent large New York Times article documenting that these tests, again, in a low-risk women, much more likely to be falsely positive than to actually correctly diagnose a problem with a baby. So it is absolutely imperative to do follow-up testing to see if you really do have an affected child. And of course, as doctors, we don't have the ability to know for sure how severe abnormalities are going to be. We cannot predict in many cases what a child's life is going to look like and be like, but we do know from studies of parents who've had children that they've raised with trisomy 21, trisomy 13, trisomy 18.
Objection, Your Honor. None of this was disclosed.
Was it disclosed?
I don't believe so, Your Honor.
Sustain the objection then.
That's not for the entire answer, just the most recent portion. Is that correct?
Just the portions that relate to trisomy 21, 13, and 18, that was what was objected to, correct?
That's correct.
That portion of the answer will be disregarded. The rest will be considered.
Thank you, Your Honor. What is perinatal palliative care?
Perinatal palliative care is, I think we all are familiar with the concept of palliative care for end-of-life issues. When you have a family member with a terminal diagnosis, this is a way of walking alongside a family to talk about options that are available, to determine what the family's values are, what options that they would like their beloved family member to have, and it's a method of honoring those values at the same time giving pain control and comfort care to the person in a terminal illness. Perinatal, as the name implies, is taking this concept that has been part of our medical community for years and bringing it to these children who receive these devastating prenatal diagnoses so that their family can honor their lives for as long as that natural life may be. And this does appear to improve the grief process, to give the family opportunities to have meaningful experiences with the child who may have a shortened life.
So how does perinatal palliative care affect the overall well-being of the pregnant woman with that tragic diagnosis for her baby?
Well, I think it's important when we think about these situations. Of course, they are so tragic, and it's heartbreaking to think of any mother of any family. Those of us that have had children, we know as soon as you know you're pregnant, you have plans for that child. And so these are situations where these families, full of optimistic plans, come to a halt when they're given a tragic diagnosis. And unfortunately, for so many years, and this has been documented in so many studies, doctors have leaned toward recommending abortion. They have often not engaged with the topic of perinatal palliative care. Sometimes these families feel pressured into making a decision. They're abruptly truncating their relationship with that child. So surprisingly, there have not been very many studies that have looked to see how do families do better. We should all be curious about that. The one study I found was at Duke University, and it did document that the families who continued to carry, even though their child eventually died, the mental health complications were less, their overall well-being was better because they were able to support their child to a natural death, and the mother was not forced to become the instrument of the decision that ended that child's life.
So I want to talk about Idaho's laws specifically. Are you familiar with Idaho's Defense of Life Act?
Yes.
Are you familiar with Idaho's Fetal Heartbeat Preborn Child Protection Act?
Yes.
And you reviewed those laws as part of your preparation of your expert report in this case and testimony here today?
Yes.
So based on your 30 years of experience as a practicing obstetrician and your expert opinion, are these laws confusing?
Objection, Your Honor, to the extent that counsel is eliciting testimony about what has been characterized as the heartbeat ban. All of Dr. Skop's disclosed opinions relate to the complete abortion ban.
Is that right, counsel? I mean, I suppose the case law says that the quote total abortion ban, not the case law, but the statute itself says that that's the one that has primacy. Perhaps that's the one that
it is. And I'm trying to think. If I remember right, at the time her report was provided, I believe that the fetal heartbeat ban was preempted in its entirety by the Defense of Life Act, and then it wasn't until after her report was provided that the injunction went back into effect for a very small period or a very small portion of the law.
And so that means you agree that the disclosed opinions pertained to the quote total abortion ban rather than to the other statute?
The Defense of Life Act, yes, Your Honor.
Yes. All right. I'm not meaning to adopt one party's lingo over the other. Just I don't recall the statute number. I'd use that instead. But all right. So it sounds like the disclosure of Dr. Skop's opinions on this subject was limited to the as Mr. Craig called it, I think, in accordance with its title, the Defense of Life Act, and so her testimony will be limited accordingly.
Based on your 30 years of experience as a practicing obstetrician and your opinion as an expert, is the Defense of Life Act confusing?
No.
Should a physician be able to understand language that an abortion is allowed when the physician determines in his good faith medical judgment that an abortion is allowed when necessary to prevent the death of the pregnant woman?
Yes.
And what is your opinion based upon?
Well, I practice under similar laws, and I know that the good faith medical judgment means a doctor may use his expertise, his clinical skills, his training, looking at the obstetric literature, all the things that we do in our practice to determine what is the right recourse. We may use that based on the facts known to him at the time. So what does the clinical picture look like? What does the patient look like? So this is how we practice medicine. So based on those factors, if he feels that she has a pregnancy complication and requires an abortion to prevent her death, then he is allowed to do that. And again, there's been additional clarification from the Idaho Supreme Court that make it even clearer.
Well, let's talk about that. You're familiar with the Idaho Supreme Court's 2023 decision in Planned Parenthood Great Northwest versus State?
Yes, I am.
And did that help solve any confusion that might have existed before that case?
If there was confusion, this surely should have cleared it up. We've all read, and I think we saw in the plaintiffs' reports and in some media reports, things like doctors saying she wasn't sick enough for an abortion. We couldn't intervene until she was dying. This is absolutely incorrect. This is not how medicine works. When we make a diagnosis, we don't know if it's going to kill the woman, but we are empowered to intervene by Idaho law. The Supreme Court clarified that. They said imminency is not required. You don't have to wait till a woman is dying. They said certainty is not required. You don't have to know for sure that she's going to die. You need to know that she has a diagnosis that can lead to her death. And additionally, they said that there does not need to be consensus. This action that doctor, using his good faith medical judgment, takes does not need to be 10 out of 10 obstetricians would perform that action. It just needs to be reasonable. Would another doctor in a similar situation do this action? Then that is good faith medical judgment. So all of those things should have empowered doctors to bravely follow this law, to provide quality medical care. And it's very concerning to me that I've read so often, this decision was in January of 2023, but have read so often since then that I don't want to be the test case. I, don't know what this means. They should know what this means. Doctors are smart enough to figure out legal terms like this.
For Dr. Corrigan's testimony here that, she's not trained to determine when it's absolutely certain that death will occur.
Well, she doesn't need to, according to the Idaho Supreme Court. She does not have to be certain. None of us can be 100% certain.
And is your opinion that Idaho's Defense of Life Act is not confusing, also based upon your conversations with Idaho's doctors, with some Idaho doctors?
Yes, I've spoken to doctors who do not find this confusing.
Objection to the extent that they're now eliciting testimony based on conversations with the two physicians who testified this morning.
Experts are allowed to rely upon hearsay and conversations with other people in the field.
All right, well, I suppose, consider that strictly as it might relate to the grounds for any disclosed opinion on the topic of whether the statute is confusing, and not for the hearsay effect of backdooring into evidence any individual doctor's assertion to Dr. Skop that she doesn't understand, that they understand how the statute works.
Your Honor, I just want to be clear. My objection was not on hearsay grounds. My objection is based on the fact that Dr. Skop apparently spoke to these physicians a couple days ago. And so we got no supplemental disclosure of opinions that would be based on information that she learned from her conversations with them. At the time she served a report, she had discussed nothing with any Idaho physicians.
All right, so it's the idea is that that the grounds for holding an opinion couldn't, I guess, grow over time after the disclosure, unless, at least not without a supplemental disclosure. All right, you're welcome to respond to that if you like, Mr. Craig.
Experts are always gathering information to form their opinion. And of course, as they gather more information, that's going to inform their opinion. And so I think an argument that they can't gather more information is frivolous.
All right, so this would seem to be within the realm of some sort of supplementation obligation under Rule 26E, I suppose. It seems to me that, well, I'm just going to overrule the objection. I don't think that the particular increment to the testimony and the support for it is consequential to whatever persuasive force the opinion has in and of itself. You can continue.
Dr. Skop, do you have an opinion on whether doctors in Idaho are able to provide necessary care to pregnant women with pregnancy complications under the Idaho's Defense of Life Act?
Yes, I believe they are.
You heard Dr. Corrigan, Dr. Lyons, and other doctors testify about their fear of being sent to prison for violating Idaho's Defense of Life Act, correct?
Yes.
In your opinion, is that fear reasonable?
No, I think that is an irrational fear.
Why is that?
Well, two attorneys recently published an article that looked at all the case reports throughout the United States.
Objection, undisclosed reliance material.
Your Honor, she's impeaching the testimony of the plaintiff's expert witnesses and their fact witnesses as well.
Your Honor, this is rebuttal. Dr. Skop served a report that painstakingly responded to our plaintiffs, our plaintiff patients, our plaintiff physicians, and at no time did she cite this research study.
You talked about this research study during the deposition that plaintiffs conducted just a few weeks ago.
All right. Came out in the deposition?
I believe the testimony was that she was starting to work on this project, and I have, that's my recollection.
All right. So, and you're asserting, Mr. Craig, that Dr. Skop expressed during the deposition whatever opinion you're trying to elicit from her on this article that two attorneys recently published.
So the deposition was being conducted by plaintiff's counsel, and so they asked her, I can't remember the question, but the study came up in response, and she talked specifically about this study that she was starting to talk about during the deposition.
And did she state during the deposition, I guess an opinion to the same effect about the whatever this study has to do with that you're about to try to elicit? What I'm getting at is the information you're trying to elicit right now something that came out during the deposition?
My best recollection is it did, yes. To be 100% certain, I'd have to review the deposition, but.
All right. Well, I'll permit the answer. I'll overrule the objection. The disclosure document is one thing. That is part of what frames the basis for expert testimony at trial. That's the driver. When a party deposes another party's expert and learns additional opinions, those, I think, are generally speaking within the bounds of what the expert may testify to at trial. Now, parties have different perceptions of whether this information was or wasn't testified to at trial. I'll permit the answer to be given, and I'll permit as part of the post-trial process, or perhaps later today, if someone can point me to chapter and verse where this was disclosed or wasn't disclosed, I can make a final ruling on the topic.
This was discussed page 391 of her most recent expert. I can review the answer or I can read it to the court if the court would like me to.
Go ahead.
So I have to back up to get to the question. And what's the question, what's the basis for you saying with confidence if a physician terminates a pregnancy after diagnosing a condition listed in ACOG guidance as something that can result in death, they'll be okay under the statute, right? Where are you getting the confidence in referring to the ACOG literature? Answer, well, I do know that no doctor has been prosecuted for performing an abortion for the life of the mother since the Dobbs decision. It has not happened. I know also, based on Paul Linton's review that will be published, that it has only happened twice in the last 100 years in our country, and both of those were a long, long time ago, and both of those were overturned on appeal. So I do know there is not a precedent for doctors. What I think we discussed last time, Monday morning quarterbacking, and for the legal agencies to second-guess a doctor's judgment, particularly when the doctor has been able to document his good faith medical judgment by referencing the peer-reviewed literature and the obstetric guidelines. So it just has not happened. Answer goes on a little bit longer, but.
The Paul Lind portion of it, that is the article she's about to testify to today.
That is correct.
And I suppose you can tell me.
Your Honor, the testimony was this will be published, right? So we don't have access to this material. If plaintiffs if the defendant is allowed to probe this, then I would say we should be given a copy of the pending, the piece of literature pending publication that Dr. Skop has seen and is going to be testifying about so that it can be probed on cross.
All right, I'm going to sustain the objection on this ground at this point. It would appear that the matter was treated glancingly in the deposition, but not in a way that enabled evaluation by plaintiff's counsel. And I guess further, I'm not sure that prosecutions prior to Dobbs are particularly consequential to evaluating the risk of prosecution in the wake of Dobbs.
It was after Dobbs.
I guess I understood from what you read the article to, I guess, speak to, the answer given in the deposition to speak to the idea that doctors weren't prosecuted in the 100 years before Dobbs. And I thought that was what you were getting at as far as...
So there are two parts.
Okay.
First part was, I do know that no doctor has been prosecuted for performing an abortion for the life of the mother since the Dobbs decision. And then later she says, in the last 100 years, there have been only, it has only happened twice in the last 100 years in our country, and both of those were a long, long time ago, and both of those were overturned on appeal. So she says there's been none since the Dobbs decision.
All right, understood. I'll just continue to sustain the objection. You may ask your next question.
Thank you, Your Honor. So, Dr. Skop, setting aside the prosecution part of it, do you think that their fear of being prosecuted or their fear of violating the laws is reasonable?
No, it's not.
Why is that?
They have been made to fear these laws, but most OB-GYNs, as I mentioned earlier, 90% of us do not perform elective abortions. We are practicing the same way we always have. We have never been punished for doing what is necessary to save a mother's life. It has not started since the overturn of Roe v. Wade, and it is tragic and heartbreaking to see doctors say that they know they are violating the standard of care by not intervening, but they are justifying their inaction because of fear of these laws. That is moral injury to allow doctors to fear these laws that they do not need to fear.
Does Idaho law allow Idaho doctors to effectively treat their pregnant women under Idaho's Defense of Life Act?
Yes, it does.
Thank you. I don't have any other questions.
All right. Thank you, Mr. Craig. Cross-examination, counsel.
Good afternoon, Dr. Skop.
Hi.
My name is Leah Godesky, and I'm with the law firm O'Melveny and Myers. We have met before, right?
Yes, good to see you again, Leah.
Good to see you. I see you got the memo and we're wearing green. And you understand that I represent the plaintiffs in this case, right?
Yes, I do.
You have written a report in this case and you've sat twice for a deposition, right?
Yes.
And the first time you sat for a deposition under oath was in July of this year?
Yes.
After that deposition, you reviewed your transcript and you sent plaintiffs an errata sheet with little corrections, right?
Yes.
And you made some changes to the words and the spelling, but you didn't make anything that you would call a substantive change, right?
I don't believe so.
And then you sat for another deposition last month in October, right?
That's correct.
Between your July deposition and your October deposition, you communicated with counsel for the state of Idaho about a dozen times, right?
Probably.
And after your October deposition, you reviewed your testimony and again did an errata sheet where you made some changes, but no major substantive changes, right?
That's correct.
And there's a binder in front of you with a copy of your expert report and your deposition transcripts and the errata sheets in case we need to reference them, okay?
Okay.
And I think you told Mr. Craig that you have been watching the trial or reading the transcripts of the trial as the trial days have passed. Is that right?
That's correct.
Have you been watching or have you been reading?
I have been reading and I have listened to some of it, but not all of it.
Okay. Have you read all of the trial transcripts that have become available?
I believe so, not in depth, but I've reviewed them.
Okay. Now, it sounds like you participated in a Zoom meeting with Mr. Craig and Dr. Hughes at the beginning of the week. Is that right?
Objection beyond the scope of direct.
Overruled. You can answer.
Yes, we have a Zoom meeting on Tuesday evening.
And was there anyone other than Mr. Craig and members of the Attorney General's office and Dr. Hughes participating in that session?
No.
Did you say anything during that Zoom session?
I think I introduced myself to Dr. Hughes.
And did Mr. Craig relay to Dr. Hughes any summaries or overviews of what's happened in the trial so far?
I don't think so.
And what did Mr. Craig say during that session about what testimony might be helpful for Dr. Hughes to give here at the trial?
Objection beyond the scope of direct.
It's beyond the scope of this witness's direct, but as I've indicated generally during the trial, these scope limitations will not be enforced if the party would have the right to call the witness at a later point in the trial when it is the party charged with presenting evidence to address the topic at issue. And it would seem to be the case that would be permissible in this circumstance for the plaintiff to have an opportunity to present this evidence. I'll without more of a speech, I'll overrule the objection. You can answer.
Can you repeat the question?
What did Mr. Craig say during that Zoom meeting about what testimony might be helpful to hear from Dr. Hughes?
As I recall, I don't think he gave Dr. Hughes a recommendation. I think he just asked Dr. Hughes some questions about what his practice and those surrounding him were like under this law.
Okay, now I want to start by talking about some of your general views on abortion care. In your view, Dr. Skop, abortion does not qualify as women's health care, correct?
That is correct.
And I represented to you when we last met at deposition that the San Antonio Express News was describing you last year as a quote-unquote vocal anti-abortion advocate, and you agreed that's a reasonable thing to say,
Objection,
right?
hearsay. She's, and will object to counsel testifying as to what other people are saying.
All right. Well, it's a recitation, I guess, of something how about you just ask the question about whether that's a fair characterization of her?
Dr. Skop, would it be reasonable to characterize you as a quote-unquote vocal anti-abortion advocate?
I have been vocal and I am opposed to elective abortion, so yes.
In your opinion, there are no benefits to what you would characterize as an elective abortion, right?
Not just my opinion. Review of the literature demonstrates no benefit to women from elective abortion.
That is your view, right?
That is my view based on the literature, yes.
And your view is that a pregnancy should never be terminated unless a patient has a life-threatening diagnosis, right?
The unborn human is living, and I believe, as probably many people do, that we should not end human life for elective, non-urgent reasons.
Dr. Skop, your view is that a pregnancy should never be terminated unless a patient has a life-threatening diagnosis. Is that fair?
That's fair.
You do not disclose that view to your obstetrics patients, correct?
No, when they come to me seeking care for their child, I think that they would like an obstetrician who considers their child a patient.
So that's not something you disclose?
Objection, relevance
correct.
beyond the scope of direct.
Your Honor, all of this goes to Dr. Skop's qualifications and credibility as an expert.
Overruled. I'll consider the answer. You may continue.
Now, as you said, Dr. Skop, in your direct examination, your personal view is that life begins with fertilization, right?
My personal and scientific view, yes.
And you have staked out an opinion that all medical doctors consider an embryo to be a living human being within 1 week of fertilization, right?
I can't say, I don't know what I previously said, but specifically regarding that, ACOG considers a pregnancy to begin at the time of implantation. They have remained quiet on the moral status of that individual prior to implantation.
So I'm not asking about ACOG. My question is whether it's true that you have taken the position that all medical doctors consider an embryo to be a living human being within 1 week of fertilization.
Based on the science, that is true.
And you, Dr. Skop, are associated with several anti-abortion or pro-life organizations, right?
That is correct.
For example, you are a lifetime member of the American Association of Pro-Life Obstetricians and Gynecologists, also known as AAPLOG, right?
Yes.
And you served as a member of AAPLOG's board from 2018 to 2022.
2020, I believe. 2018 to 2020.
Thank you. And AAPLOG is an organization that has a bias against abortion, right?
They're pro-life obstetricians, yes.
AAPLOG has a bias against abortion, right?
Objection, asked and answered.
It's sustained. It's the answer given covers the subject.
AAPLOG has about 4,000 members, is that right?
That's what they say, yes.
Okay, and you're also a member of the Christian Medical and Dental Association, or CMDA, right?
Yes.
And we learned from Dr. Hughes this morning, or maybe it was Dr. Story, I apologize, that that's an organization that generally opposes abortion, right?
Yeah, it has Christian values.
And you are the medical director of an organization called Any Woman Can,
Yes.
and you used to be on the board of that organization, right?
Yes.
Some people would describe it as a crisis pregnancy center.
Yes.
You are also a member of the Save the Storks Advisory Board, right?
Yes.
And sort of the mission statement of Save the Storks is that the reality of abortion is that it is harmful and long-lasting, right?
I believe that is their mission statement.
And you generally agree with that mission statement.
Yes.
Now, as you explained on direct examination, you are currently working full-time at the Charlotte Lozier Institute, right?
That's correct.
And Charlotte Lozier is a think tank that has a pro-life ideology, right?
That is true.
And one of your titles at Charlotte Lozier is Director of Medical Affairs.
That's correct.
And in your role as Director of Medical Affairs at Charlotte Lozier, you make approximately $150,000 a year.
That is correct.
And that salary covers things like the time you're spending working on this litigation for the state of Idaho, right?
Yes.
The way it generally works is Idaho is paying Charlotte Lozier a stipend for your time, and you consider that time paid for but within your $150,000 salary, right?
Correct.
And your association with Charlotte Lozier goes back to before you were a full-time employee of the think tank, right?
Yes.
You were an associate scholar at Charlotte Lozier for many years while you were a practicing obstetrician.
Yes.
And Charlotte Lozier hosts training sessions for you and your colleagues at Charlotte Lozier on how to be expert witnesses in litigations like this one.
Just general media training, yes.
And those can be multi-day sessions, right?
I suppose they could be, but I seem to recall that it was just one day. But
Okay. You've participated in witness training sessions also hosted by the American Association of Pro-Life Obstetricians and Gynecologists, right?
yes,
And during those sessions, you get some general advice about how to answer questions in situations like this or when you're talking to the media.
yes,
And you have been very active when it comes to providing testimony in different states around the country in support of restrictions on abortion access, right?
yes,
In 2013, you testified in support of Texas House Bill 2 before a subcommittee of the state legislature.
that's correct.
And House Bill 2 was a law that, along with some other restrictions, banned abortion care after a certain point in pregnancy, right?
Yes,
And you were invited to testify in support of Texas House Bill 2 by an organization called Texas Right to Life.
yes,
That's a pro-life organization, right?
yes,
And then in 2019, you wrote a report on behalf of the state of Georgia in support of a law that prohibited abortions after a fetal heartbeat could be detected, correct?
with certain exceptions, yes,
And fetal heartbeats can generally be detected 6 or 7 weeks into a pregnancy.
that's correct.
In 2020, you testified in support of an abortion restriction in Utah.
Yes,
And in 2021, you were an expert for the state of Montana in a litigation challenging abortion restrictions, right?
yes,
In 2022, you testified for Florida in an abortion restriction case.
yes,
And then in 2023, that was a relatively busy year because in addition to providing testimony in your home state of Texas, you provided testimony in Wyoming, West Virginia, Louisiana, and Nebraska. Does that sound right?
I think some of those might have been written. I don't recall
testimony.
traveling. Yeah. I don't
Okay, so no travel, but you would provide written statements?
that if that came from, did that come from my CV?
I'm going off of the conversations we had at your deposition, Dr. Skop.
Okay. I don't recall doing work for Wyoming, but
The other states sound right?
perhaps, can you say the other states again?
Sure. Wyoming, Texas, West Virginia, Louisiana, and Nebraska.
I don't recall West Virginia either, but anyway, I've done some work.
You've never provided testimony supporting a party in a litigation that was opposing a restriction on abortion access, right?
No, I have not.
And you can't think of any public statements you've ever made opposing or objecting to a restriction on abortion access, right?
Not that I recall.
Now, you spoke on your direct examination with Mr. Craig about your own publications on things like abortion safety. Do you remember that?
Yes.
And publishing on abortion issues is something that you've been more focused on in the last 6 years as you've increased your work through Charlotte Lozier.
Yes, it's corresponded with my work with Charlotte Lozier.
So between the 1990s, when you became an OBGYN, and 2018, you published just one paper in one medical journal. Does that sound right?
Yes, shortly after residency on a surgical technique.
And that paper that you published shortly after residency, that would have been in the 90s, right?
Yes,
And that would have been about a gynecological procedure, not abortion safety, right?
that's correct.
And then in 2018, about 6 years ago, you started writing pieces about the safety, or in your mind, the lack of safety of abortion care and other abortion-related issues, right?
That's correct.
As of 2020, about 2 years into your role as an abortion expert, you described your drafting methodology as, quote, "Sometimes I take down a sentence or two word for word if I think it's well written. And then when I've put papers together, I've probably forgotten that I'm not the original author." Does that sound familiar?
Yes, I recall that statement.
In 2020, just a few years ago, you didn't realize that copying words from a paper you agreed with could count as plagiarism, right?
Yeah, I didn't think that small amount would be a problem.
But then the problems with your drafting methodology were brought to your attention when you testified in that abortion restriction case brought by Planned Parenthood of Utah, right?
Yeah, as I recall, the conversation was that I had co-written as a member of APLOG's board a practice bulletin, and I had used what I had written in the practice bulletin in my testimony.
It was pointed out to you at your deposition that the majority of the language in your report was identical to this AAPLOG fact sheet, right?
Which I had written. Yeah, I didn't realize that repeating what I had written was considered plagiarism. I now know the nuance of that.
And you've been working with folks at Charlotte Lozier to sort of improve your citation work, right?
Absolutely. I'm always learning.
Now, in approximately 2021 or so, you started publishing on abortion as part of what you call the Studnicki Research Group, right?
Yes, I may have published with, around that time I think I joined that group.
And you say the Studnicki Research Group because the group is led by a man named James Studnicki, right?
That's correct.
Mr. Studnicki is not a medical doctor.
No, he's a Johns Hopkins epidemiologist.
And he is a Charlotte Lozier employee just like you, right?
That's correct.
And this research group that he runs is sponsored by Charlotte Lozier.
That is correct.
And you describe Mr. Studnicki as the brains of your research organization. The way it kind of works is he comes up with the ideas or the concepts, and then you and other co-authors collaborate.
Right. So he's the leader of the group, and this is related to the Medicaid data that I mentioned earlier, that we have published a number of studies looking at specific questions related to that data.
Okay. Now, you provided a copy of your CV to plaintiffs when you turned over your original May 2024 expert report in this case, right?
That's correct.
And then you provided an updated or corrected version of your CV to the plaintiffs last month, right?
Yes.
Okay. And in your binder, Dr. Skop, there is Exhibit PX 575. Maybe we can also put it on the screen. And my question is whether this is the corrected copy of your CV that you served on plaintiffs last month. I'm not seeking to introduce it into evidence. I'm just marking it for identification.
Yes, this is the corrected copy.
And as you highlighted in your direct examination with Mr. Craig, the CV that you prepared for this case shows that you've published 12 to 15 articles about abortion between 2018 and the present, right?
That's correct.
And many of these were with the Studnicki Research Group.
Yes.
Now, in the world of academic literature, a meta-analysis is an effort to answer a scientific question by looking at all of the available high-quality literature, right? Things like randomized controlled trials.
That is correct.
And none of your publications qualify as a meta-review, right?
We have not performed a meta-analysis. Most of this is original research based on this original cohort.
Okay. Now, maybe we can make it a little bigger on the screen, but I want to start at the top of your corrected CV, which is page 2, and there's several articles from this year, 2024, right?
Yes.
And the first 5 articles, in fact, are publications from this year, correct?
That is correct.
And 3 of the 5 are from a journal called Issues in Law and Medicine, right?
Yes.
Okay, I want to talk about who publishes that journal. A woman named Donna Harrison is one of the 2 associate editors at the Issues in Law and Medicine journal, right?
That is correct.
And she is an associate scholar at Charlotte Lozier, right?
Yes.
And Donna Harrison used to be the executive director of AAPLOG, the American Association of Pro-Life Obstetricians and Gynecologists, correct?
That is correct.
And Donna Harrison would have attended some of those witness training sessions we were talking about earlier that are hosted through Charlotte Lozier and AAPLOG, right?
Yes.
The other associate editor of Issues in Law and Medicine is a man named David Prentice, right?
Yes.
And you know him.
Yes, I do.
He used to be the director of research at Charlotte Lozier.
That's correct.
You are aware that the editor-in-chief of Issues in Law and Medicine is a gentleman named Barry Bostrom, right?
Yes.
You've communicated with him?
Yes, I have.
And you're not sure one way or another whether or not he has any medical or scientific training, right?
I'm not aware.
But you do know that this journal, Issues in Law and Medicine, is a journal run by folks who are anti-abortion advocates, right?
Yeah, as you described it, yes.
Okay, so then let's talk about some of the articles that you and these other folks have been publishing in this journal. One of them is titled Misleading Statements About Life of the Mother Exceptions and Pro-Life Laws Require Correction. Do you see that?
Yes, I do.
That's the 5th bullet down on your CV, right?
That's correct.
You authored this piece with a woman named Mary Harned,
Yes.
and she's an associate scholar at Charlotte Lozier.
An attorney, yes.
And then you also wrote an article for Issues in Law and Medicine this year called United Kingdom Data Deficiencies Influencing U.S. FDA Decisions, right?
That's correct.
And that's the 4th bullet down on your CV.
Yes.
And in that article, you focus on medication abortions, right?
Yeah, we looked at the data that the FDA pointed to say that it was safe to use medication abortions without any medical supervision, and in fact documented that the system in the UK was faulty and in fact only detected a complication if it occurred before the woman left the clinic, which would have been before she even took the medications. So,
Your Honor, I move to strike everything after yes.
Sustained.
You published this piece with a Dr. Callum Miller, right?
that's correct.
And you've met him in person a couple of times, right?
Yes.
And I want to, if you can look in your binder, Dr. Skop, I don't know that we need to put this up on the screen, but I have a document marked for identification as PX 598. All of the exhibits are sort of in numerical order from lowest to highest, if that helps find the document.
Okay.
And you can see at the bottom of the left-hand corner of that document that this is a printout from calebmiller.org, right?
That's correct.
And this has a picture of Dr. Miller, right?
Yes, it does.
And Dr. Miller's website describes him as a sought-after speaker and international leader in the life movement,
Objection, hearsay.
working to stop abortion colonialism.
Objection, hearsay. I'm not sure what's relevant of people who are unrelated to Dr. Skop.
I'm not sure either, but it would appear to be hearsay. So either there's an exception or you're offering it for some purpose other than the truth.
I'm not offering for its truth. I'm just asking, this is Dr. Skop's co-author, the people that she's authoring all of the literature that she has touted during her direct examination, and I am just simply asking if she agrees with the way that Dr. Miller describes himself on his website. I'm not offering it for its truth.
That's not the question. She asked if this is what the website says. That's absolutely truth. Hearsay offered for the truth of the matter asserted.
You can rephrase. I think that the objection is technically valid. There's another way to get at it, of course.
Okay. Dr. Skop, would you agree that Dr. Miller is a sought-after speaker and international leader in the life movement working to stop abortion colonialism? Does that generally sound right in terms of your understanding of the work he does?
I think that is correct. He is a brilliant Oxford-trained physician. And as you pointed out, the pro-life community that does research is fairly small. We do all know each other. That doesn't mean we don't produce high-quality research.
Again, I'm going to move to strike everything after. Does this sound like an accurate description of Dr. Miller?
Your Honor, she's asking the question. The witness is allowed to answer the questions and provide explanation.
The witness answered the question fully after saying that is correct. The balance of the answer will be struck. It may or may not be proper follow-up on redirect, but the additional information given was not a part of the question, was not sought by the question. The questioner has the right to constrain the answer to the confines of the question. Go ahead and continue.
Dr. Skop, in addition to publishing pieces for this journal yourself and with folks like Dr. Miller, you serve as a peer reviewer for other pieces published in the journal, right?
That is correct.
That means you have a role in reviewing and approving what gets published.
On occasion, it's maybe 2-3 articles a year. It's not a lot.
Okay. Now, when we go back to your CV, which is still up on the screen, but if you want it in your binder, that's PX 575. I'm on page 2. At the top of the page, there's a recent publication in the International Journal of Epidemiology and Public Health Research, right?
Yes.
And I think you mentioned this during your direct examination with Mr. Craig, correct?
We discussed this during the deposition. I don't think that Jim and I discussed it today.
Okay, so this is this article, and I'm just marking it for identification so you have it in front of you. It's in your binder as PX 580 if you need to reference it. The lead author on this piece is Mr. Studnicki,
Yes,
and this research was funded by the Charlotte Lozier Institute, right?
yes, it was.
And all of your co-authors for this piece are associated with either Charlotte Lozier, AA-PLOG, or the Elliott Institute, correct?
Yes.
And we talked about Charlotte Lozier and the American Association of Pro-Life Obstetricians and Gynecologists. We haven't talked about Elliott Institute. The Elliott Institute is a nonprofit run by David Reardon, right?
Yes.
Relevance. All right, overruled. You've said yes. You can move on.
And Mr. Reardon is one of your repeat co-authors on your peer-reviewed literature, correct?
Yeah, again, a small community.
And you visited Mr. Reardon's Elliott Institute website in the past, right?
I have.
And you understand that the Elliott Institute's mission is educating others about abortion, injustice, and trauma, right?
That's correct.
And Mr. Reardon is not a physician and he has no medical training, correct?
He's a brilliant researcher, but I don't think he's a physician.
Now, if we go back to your CV, another article that you highlighted as published this year is called "Is Induction Abortion Evidence-Based Medical Practice?" Right?
I believe it's elective abortion. I'm trying to, what number did you say that was?
It's on your CV, PX 575. I believe it's the third bullet down. And I misspoke. It's not induction abortion, it's induced abortion.
Yes, that's correct.
And Mr. Studnicki is your co-author again, right?
That's correct.
And you would characterize this piece as a literature review and some out-of-box thinking, right? That's how you described it at your deposition?
That's fair.
And included in part of this literature review, you and Mr. Studnicki reviewed Charlotte Lozier fact sheets, right? Those were some of your sources.
We referenced those. Those were drawn from state-level data and CDC data, but just as a shortcut, we referenced our fact sheet that then referenced, an additional 20 sources or whatever.
Right. Your footnotes in the piece are to the Charlotte Lozier Institute fact sheet.
That's correct.
Okay, now we've been talking about your CV in 2024. I want to go back a year and look at 2023. The first entry from 2023 is another piece you authored with Mr. Studnicki's research group, right?
Yes, that's correct.
And this was a study of Medicaid-eligible women in certain states, and the work was again funded by Charlotte Lozier, right?
That's correct.
Like the second author of this piece is Ms. Teresa Longbond. She's at Charlotte Lozier, and we see David Reardon as another co-author, right?
Yes.
Donna Harrison and others from the Studnicki research group were all involved, correct?
That is correct.
And then the next 2023 piece on your list was published in Health Services Research and Managerial Epidemiology, right?
Yes.
That work was also funded by Charlotte Lozier
Yes, it was.
and conducted through the Studnicki research group.
Yes.
Now, in between your first and second depositions in this case, when you served this corrected CV, you made notations in 3 different spots to note that certain of your publications from 2019, 2021, and 2022 were retracted, and you dispute the retraction, right?
That is correct.
And you addressed that a little bit with Mr. Craig, right?
Yes.
And if we're looking at your corrected CV, we're talking about entries in the 9th, the 10th, and the 16th bullet, and it looks like they've been highlighted on the screen, right?
That's correct.
And the reason you served a corrected CV in this litigation is because at your first deposition in this case back in July, we talked about how 3 of these articles had been retracted, but it wasn't noted on your CV, right?
Yeah, my CV had not been updated.
And you told me when I asked you about it that you figured I'd find out about the retractions on my own because if I didn't, I wouldn't be doing my job, right?
Yes, you're a good researcher.
And the journal that retracted your publications is called Sage Publications, right?
The Sage is the publisher. The journal specifically was the Health Services Research and Managerial Epidemiology, which actually no longer exists. They've stopped publishing it.
So Sage Publications is the entity that makes the decision about the retraction.
That's what they said, and they destroyed the journal in order to justify the retractions, it appears.
I'm going to move to strike everything after yes.
Granted.
Now, all three of these retracted but disputed articles have Mr. Studnicki as the lead author, right?
Correct.
And they were all published through the Studnicki Research Group.
They were, in general, they were the same subset of authors. There may be a couple of differences, but yes,
And this work would have been funded by Charlotte Lozier.
that's correct.
And you note on this corrected CV that the reader can obtain more information at a website called assaultonscience.org, right?
Right, that's, yeah.
And that website's hosted by Charlotte Lozier.
Just demonstrating what happened with the retractions, including all of the letters back and forth with the publisher and the lack of any reasons to justify retraction.
Now, you and Mr. Studnicki and your co-authors on these pieces have initiated litigation about this, right? You mentioned that on direct.
Yes,
And you are a named party in this litigation.
that's correct.
You've been following some developments in the litigation? It sounds like you're posting them on the website, right?
Someone is updating the website. I'm not particularly following it, but
So you said that there were no reasons for the retractions given, but you do understand that SAGE stands by its retraction decisions, right?
that's what they say, but we'll see what the mediator says.
And SAGE has taken the position in the litigation you've initiated that there was a quote-unquote blatant conflict of interest in your articles because one of your manuscript peer reviewers was from the Charlotte Lozier Institute, right?
That's an interesting thing.
He's made an objection. I need to make a ruling. Do you understand that? All right, overruled. You can answer.
That's an interesting thing because it is a double-blinded peer-reviewed process, which means that the authors did not know who was reviewing their article.
Dr. Skop, I'm gonna interrupt
I'd like to explain it.
I'm going to interrupt you, though, because I'm going to say Mr. Craig is going to get another opportunity to come up and elicit any explanation.
Okay.
To keep this moving, I just need to get answers to my questions in this period of your examination, okay?
That's fair. Mr. Craig may follow up without, I guess, promising categorically that all follow-up would be permissible. Answer the question in a fair way, and if follow-up is desired, your counsel, not your counsel, but the state's counsel may conduct follow-up. All right.
Thank you. So SAGE has taken the position in this litigation you've initiated that there was a blatant conflict of interest because one of your peer reviewers for these pieces was associated with the Charlotte Lozier Institute, right? That's their position?
I'll object to counsel testifying as to what somebody else is saying and object as it's calling for hearsay.
All right. Well, counsel is, I guess, suggesting facts to the witness and seeking confirmation, which I think, generally speaking, can be done on cross. You can answer.
Can you repeat the question?
You generally understand, you're a party to this litigation, right, Dr. Scott?
That's correct.
Okay. And you understand that SAGE has taken the position that there was a blatant conflict of interest when you had someone associated with the Charlotte Lozier Institute serve as a peer reviewer for your pieces. That's their position, right?
But we didn't make that decision, they did.
But that's their position, that there was a conflict of interest, correct?
I don't understand how they could take that position when they were the one who assigned the reviewer and we did not know who the reviewer was, nor did they know whose work they were reviewing. So,
do you have a general understanding, Dr. Scott, from your role in this litigation that SAGE is taking the position that as each time you submitted a manuscript for publication, you falsely declared no in response to their question about whether you had any perceived conflicts of interest?
I'm going to object to counsel's question accusing the witness of lying.
All right. And the objection is, I guess, in terms of evidence speak, what would it be?
Correct. I mean, she's asking these questions without giving the witness an opportunity to explain the witnesses, and the questions assume facts, not in evidence. The questions are eliciting hearsay, and she's not letting the witness answer the questions.
Your Honor, she's a party to this litigation. They talked about this on direct examination. Dr. Skop staked out the position that Sage has given no justification for the retractions. I am entitled to explore Dr. Skop's knowledge of what's happening in the litigation and the position Sage is taking. And if she tells me I'm wrong, we'll see what I do next. But this is...
All right, understood. The objection's overruled.
So Dr. Skop, do you have a general understanding that Sage's position in this litigation is that you and your co-authors' conflicts of interest went unnoticed because you and your co-authors falsely declared no in response to their questions about whether you had any conflicts of interest?
I don't think the statement that you just made is correct.
But is that Sage's position in your litigation?
Objection asked and answered.
I'm not sure that it has been. You can answer that question.
Specifically, the Committee on Publication Ethics says that you do not declare a conflict of interest if the work is paid for by your
I
employer.
have to interrupt you again.
You're not answering the question. You're providing extraneous information that is designed to support your overall view of what's right and wrong in the circumstances, and that's understandable. But just answer the concrete question you're being asked. You can go ahead and ask it again.
Is that Sage's position in your litigation?
Is the question, did Sage withdraw our papers because we falsely and deceptively declared that we had no conflict of interest when we should have? Is that the question you're asking?
That's Sage's position on why they retracted your articles.
Sage gave three not very appropriate excuses for retracting the paper, and that was one of them.
Thank you. And Sage's view is that because the Charlotte Lozier Institute's research is not outcome neutral and is instead mission driven, when you have authors and peer reviewers that are both associated with this institution, it's a textbook conflict of interest. Is that their position?
I don't really understand their position because on the other side, they don't require the Guttmacher Institute to report a conflict of interest, and they are clearly outcome-driven as well. So I do have to confess, I apologize, Leah, that I'm not able to answer your questions well, but it is really a mystery to me why these papers were retracted.
So let me, and again, you're a party to the litigation, so let me see if I can refresh your recollection. In your binder, there's an exhibit PX 582. Take a look. And exhibit PX 582 is a pleading from this litigation you're a party to, right?
That's correct.
And this is a pleading that was filed by Sage in response to positions that you and your co-authors took in the litigation, right?
So this is a response by Sage. Yes, you're correct, in response to our response.
Okay. So let's take a look at page 6, paragraph 16. Sage's position in the litigation was that your leadership role at AAPLOG, the American Association of Pro-Life Obstetricians and Gynecologists, represents a textbook example of a conflict of interest, which she was obligated to but did not declare. Do you see that?
Objection, hearsay.
Yes, I do.
It's not authored for its truth, Your Honor. It's just Sage's position in the litigation.
What else, what other reason is there for it to be offered is for the truth to try to impugn her credibility?
That seems to be fair on its face, so I guess I'm wondering what the value of what Sage's position is. What is the value of that information if it is not truthful information?
So the value, Your Honor, is this is impeachment because Dr. Skop testified during her direct examination that Sage, quote, gave no reasons for the retraction. I am now entitled to challenge that.
All right, understood. So it won't be considered then for its truth. It'll be considered as impeaching the testimony you just cited for whatever it's worth for that purpose.
Thank you. So, Dr. Skop, did I read paragraph 16 in Sage's pleading correctly?
Yes, you did.
Now, after the journal realized that one of your manuscript reviewers was associated with Charlotte Lozier, they had what they characterized as an independent peer reviewer look at your 3 articles from the Studnicki Research Group, right?
They said that, but it was a researcher from the Guttmacher Institute, not independent.
I'm going to move to strike everything after they said that.
Well, I guess it's an explanation for portion of the question asked her whether they were independent peer reviewers, and she clarified. So I'll allow that answer to stand.
Now, when that second peer review of your 2021 and 2022 articles occurred, those peer reviewers identified fundamental problems with your study design and methodology, unjustified or incorrect factual assumptions, material errors, and misleading presentations of data, right? That was their conclusion.
That was the conclusion of the pro-abortion researchers who reviewed our study.
My object is to hearsay, Your Honor. I believe Dr. Skop's testimony was not that they did not provide any reason, but it was they did not provide any valid reason or good reason or something to that effect, which this definitely would not impeach that.
You can respond, Ms.
Your Honor, they've opened the door, and the testimony was they didn't give us a reason for the retractions. This was front and center and direct, and it's appropriate for me to probe.
Overruled.
So, Dr. Skop, you agree that the justification for retraction given by those peer reviewers were fundamental problems with the study design and methodology, unjustified or incorrect factual assumptions, material errors, and misleading presentations of data. That was their position.
That is what they said, but I have never seen any documentation of why our research met any of those criteria.
And they also said that based on their independent review, the work of the Studnicki Research Group demonstrated a lack of scientific rigor, and they invalidated your conclusions in whole or in part, right?
That's what the Guttmacher Institute researchers said about it. I think we all realize this is a highly politicized issue.
Dr. Skop, you've got to just sort of try to answer my questions, okay?
Genuinely does not help. When the witness goes outside the bounds of the question, it just doesn't help. It is a matter better left to Mr. Craig on redirect to seek any clarifying information he wants to seek. All right, continue, Ms. Godesky.
And then with regard to your 2019 article, Sage, their independent reviewers identified unsupported assumptions and misleading presentations of finding that, in their opinion, demonstrated a lack of scientific rigor. And that was the justification for the retraction of the 2019 piece, right?
That's what they said.
Your Honor, plaintiffs offer PX 582 into evidence, not for its truth, but for the non-hearsay purpose of Sage's position on the retractions.
I object relevance, and that's absolutely why they're offering it, is for the truth of the matter asserted. It is hearsay, and it should not be allowed.
All right. Well, we might have concerns in the context of a jury with whether a jury would follow a limitation on the subject, on the purpose for which evidence might be considered. But we don't have that concern here, so the matter has been offered for a purpose other than its truth. The purpose seems to be proper, all things considered, given Dr. Skop's testimony at this point. I'll admit Exhibit 582 for the limited purpose identified by Ms. Godesky.
Okay, Dr. Skop, going back to your corrected CV, marked for identification as PX 575, I just want to briefly touch on a couple other publications. 2 lines under the second retracted but disputed entry is a publication listed Linacre Quarterly, right?
Yes.
And that's the journal published by the Catholic Medical Association?
Yes.
And then there's an entry for a publication in the American Association of Physicians and Surgeons Journal, right?
Yes.
And that's a conservative medical journal?
Yes.
Okay, I think we can put your CV away, and I want to switch gears and talk about your methodology for writing your report in this case. You described your methodology as a process of going through plaintiff's complaint, identifying statements you wanted to respond to, and then you drafted your report, right?
Correct.
And there are portions of your report that are verbatim reproductions of reports that you've done in other litigations involving abortion restrictions, right?
That is probably correct.
And when you relied on sources that you had previously cited in other litigations, you didn't go back and reread all the literature before finalizing your report.
No, I did not.
And you did go on the internet and see if you could find anything new that you wanted to cite, right?
That's correct.
And for that, you looked in 3 places. You looked at ACOG's website, Charlotte Lozier's website, and the website of the American Association of Pro-Life Obstetricians and Gynecologists, correct?
I also just did a general Google search for other peer-reviewed literature.
So let's talk for a minute about ACOG, the American College of Obstetricians and Gynecologists. We talked about how AAPLOG has about 4,000 members, right?
Yes.
ACOG has about 70,000 members. Is that right?
That's what they say, yes.
Open direct.
Overruled.
I'm sorry, I didn't hear your answer.
Yes.
Yes.
Thank you. And you are one of them. You've been an ACOG member for 30 years, right?
Yes.
And you acknowledge that ACOG's practice bulletins and clinical guidance are written by experts in the field and can be very helpful, right?
That's correct.
ACOG's clinical guidance is drawn from peer-reviewed literature and put together by experts, so you consider it to be reflective of the standard of care.
It is reflective of good quality obstetric care from the literature, yes.
And that's why it was one of the 3 places you went when you were writing your report.
That's correct.
And Obstetrics and Gynecology is a journal published by ACOG, right?
That is correct.
And it's fair to say Obstetrics and Gynecology is a widely read journal in your field, sometimes referred to as the Green Journal, right?
That is correct.
And you rely on and generally view that journal as reliable.
Generally, but if I could make a point about one of the papers that I wrote about data deficiencies.
So Dr. Skop, I think just your general agreement that you view it as reliable is sufficient for my question, okay?
There's a significant problem with obstetrics and gynecology.
Okay. Mr. Craig may have some questions for you when he comes up. And I think you were talking during your direct examination, and you shared the statistic that I think it was 86% of OBGYNs do not provide abortion care. Do you remember saying that?
Yes.
Did I hear that right, 86%?
That was one survey. Another survey said 93%.
But the fact that an OBGYN does not provide abortion care does not necessarily mean that the OBGYN does not support access to abortion care, right?
That's correct.
Now, one of the topics you covered in your report for this case, in your examination with Mr. Craig, is that how you view the risks of abortion access, right?
Yes, I talked about the risk of abortion.
And just so we're clear, you are an OBGYN, you are not a maternal fetal medicine specialist, right?
That is correct.
And you've never taught a college or graduate level course on reproductive health care, right?
No, I have not.
You've never taught any graduate or college level course, right?
No, I have not.
And to be clear, your baseline view is that every successful abortion ends the life of an unborn baby, so abortion is not safe at all.
For the baby, certainly not.
And you understand that plaintiff has called witnesses in this case who have said abortion is 14 times safer than childbirth, and you suggested on your direct examination that that may not be accurate, right?
That's based on very poor quality data.
Now, the data about 14 times safer than childbirth, that statistic comes from an article published by the Obstetrics and Gynecology Journal, right?
Yes.
The ACOG journal, right? And the author of that piece is David Grimes, right?
And Elizabeth Raymond, yes.
And David Grimes is a medical doctor who used to be the head of the Center for Disease Control's Abortion Mortality Surveillance Division, right?
That is correct, and an outspoken abortion advocate.
And I think you told me in your deposition that everyone in your field is familiar with Dr. Grimes' publication and his work in this area, right? It's widely cited.
That's correct.
But in opining that abortion is less safe than the Grimes research suggests, you just view his work as not reliable because it's based on CDC data that you don't believe is reliable, right? That's kind of the crux of your criticism of that piece.
It's based on known incomplete data, yes.
But the Grimes piece is based on CDC data, right?
Which is known to be incomplete.
Okay, you do recognize as a threshold matter that when the CDC analyzes its data, it does analyze all deaths that come to its attention.
That is correct.
And for the deaths that are brought to the CDC's attention, the CDC then engages in a very distinct step where they analyze, did the woman die because of pregnancy or because of an abortion, right?
Generally, it's a complex process, but in general, that's what they're
doing.
Yes, there's a couple of different methods to be used.
And to do that, the Center for Disease Control obtains medical records and autopsy reports, right?
Through the pregnancy mortality surveillance system they do, they have an alternate system that merely looks at a death certificate coding.
And they also conduct an in-depth investigation into each death, doing things like LexisNexis searches for information, right?
What they say is that they try to identify deaths through LexisNexis, but it appears that primarily the deaths that they identify are the ones that come through the death certificates. It's not clear that they are able to detect additional deaths through LexisNexis.
But the CDC says they do it.
Well, they say that they consult LexisNexis, yes.
And then after that, they have two epidemiologists separately review and analyze the information to characterize the deaths as abortion-related or pregnancy-related or however else, right?
Right.
And you acknowledge that during this process, the folks at the CDC are not intentionally suppressing data that would show a higher rate of abortion-related deaths in the United States, right?
Yes, they're just not detecting it in the first place.
Right, so you believe that Mr. Grimes' study and similar literature is wrong because, in your view, the CDC just isn't looking very hard to find abortion-related deaths.
Objection misstates the testimony.
Is that your view?
Objection misstates the testimony.
All right. Why don't you restate the question, please, Ms. Godesky?
Is it fair to say in your mind that the CDC is not working very hard to detect abortion-related deaths?
I think the basic problem, it is very, very, very hard to detect these deaths. I'm not making a judgment about how hard I think the CDC is working, but I think that anybody who spends some time thinking about the issue can recognize that there's almost no way to detect a mental health-related death that may have occurred because of an abortion. And that is just not really being acknowledged or discussed in the conversation.
Okay, Dr. Skop, in front of you in your binder, the very front of the binder, there's a side tab that says it's the transcript for your first July deposition in this case. And if you could turn to that transcript and go to page 224, just let me know when you're there.
While the witness is looking, we'll need to take a break within the next few minutes. So
Sure, I think after this would be a great time.
All right.
Are you at page 224, line 1, Dr. Skop?
Yes.
I asked you, question, do you think the CDC epidemiologists are suppressing data that would show a higher rate of abortion-related mortality Answer: I think the CDC is not working very hard to detect abortion-related deaths. That was the answer you gave in July, right?
That's correct.
Okay, I think now's a good time.
All right, sounds good. We'll take a 15-minute recess, resume at that
May I continue?
Please wait a moment for Mr. Craig.
Sorry.
He is not in the room.
Apologize, Your Honor. I thought we were
Where is
still
Mr.
within
Craig?
15 minutes.
All right. It's probably be better if I said things instead of 15 minutes if I gave a time. It would be more universally understood. All right. Go ahead and continue, Ms. Gadeski.
Thank you. Dr. Scott, before the break, we were talking about data on the safety of abortion care, right?
Yes, ma'am.
And your criticism of Dr. Grimes' research in obstetrics and gynecology, right?
Yes.
And in the course of writing your expert report and testifying on direct examination today, you talked about alternative citations and literature that you believe support your view that abortion is actually not as safe as Dr. Grimes' statistics suggests, right?
Yes.
And when you wrote your expert report in this case, you understood the court might see it, right?
Correct.
You certainly understood that the plaintiffs would see it, right?
Yes.
And you endeavored to find the best citations that you could find to support your opinions before you finalized your report.
That's correct.
Now, when we met for the first time in July, I pointed out a few errors in your first report, right?
Yeah, we discussed some transpositions and things like that.
And then in October, before your second deposition in this case, you served an updated report with some corrections, right?
That's correct.
Okay, so I want to talk now about something you decided not to change. So let's look. I've marked for identification PX 574. That's your corrected expert report in this case. Take a look and tell me if that appears to be the case.
Yes.
And if you turn to the end of the document, page 31, you see a list of your identified changes, right?
Yes.
Okay. So I want to take a look at paragraph 63 of your report, which appears at page 18.
Yes.
And there you wrote in bold, Dr. Corrigan's claim that abortion is safer than childbirth is not supported by complete and reliable data, right?
Correct.
And that's the issue we were just talking about, your view that it's problematic to rely on data from the Center for Disease Control because they're not looking hard enough to find deaths, right?
Yes.
Actor misstates the testimony.
Overruled.
And then if we continue to paragraph 65 of your report, that's on page 19, you have another sentence in bold. Do you see that?
Yes.
And you write, better quality data demonstrates that a woman is more likely to die following abortion than following childbirth, right?
Yes.
That's something you wrote in bold for emphasis, correct?
That's correct.
And you did not change that sentence when you revised your report.
No, I did not.
And that sentence sounds like exactly the opposite of what the plaintiffs' experts have told the court and what the CDC data shows, right? It sounds like a statement that a woman is actually more likely to die after an abortion procedure than they are after childbirth, right?
Following abortion, yes.
But you're not actually making that claim, right? You're not here to tell the court that a woman is more likely to die from an abortion procedure than she is from undergoing childbirth, correct?
I did not make that claim. As we discussed earlier, she's more likely to not be alive a year following an abortion. But as I discussed earlier today, no one is really doing the in-depth research that is needed to know whether she died from the abortion. So it's a subtle difference. I tried to make that nuance in this report.
Right, and you told me, yeah, you know, this first sentence might be a little misleading, but then the reader can go on and read the data that follows in the paragraph to get the gist of the data I'm relying on. Do you remember telling me that at your deposition?
This, I remember that we discussed this. I don't remember the specific discussion, but this sentence as written is accurate. I don't think it's misleading.
Is your expert testimony for the court in this case that a woman is more likely to die from abortion than childbirth?
That is not my expert testimony.
Okay. All right, so let's take a look at the safety data that you cited during your direct examination and you cited in your report as an alternative to Dr. Grimes' data from the CDC. And first up is your citation to a study of Medicaid recipients in California, right? That's one of the first things you cite in this paragraph?
That is correct.
And it had been years since you last read this article when you were working on your report and you decided to cite it without rereading it, correct?
That is correct. However, I did go back and review the article, and it did have data that demonstrated increased death within a year. I don't think that I updated the statistics, but that table was in the article.
But when you sat down to write your report, and then when you met me at deposition, you hadn't read this article for a year or two, right?
That's correct at that time, yes.
Okay. And you originally wrote in the third sentence of paragraph 65, because what we're seeing on the page is your original language, not the corrected language, right? What you originally wrote was, quote, a records linkage study of California Medicaid recipients found that a woman was 62% more likely to die from any cause in the year following abortion compared to childbirth, 82% more likely to die in an accident, and 154% more likely to commit suicide, right? That was your original text of your report.
That's correct.
And those would be some pretty startling statistics, right? The idea that a woman is 154% more likely to commit suicide in a year after an abortion, right?
That is a startling statistic, yes.
And the same for the idea that a woman is 62% more likely to die in the year after an abortion than childbirth, right?
That's correct.
And this was something you had to correct in your corrected report because it was pointed out to you in July that you had erroneously interpreted the data from this study, right?
As I just stated, I did not correct these statistics, but I did go back to the study and verify that the study also had data in there demonstrating an increased risk of death in the first, I believe it was 6 months, as well as you pointed out to me, the study followed women out for a full 8 years and found that for each year, there was still a higher risk of death in the women that had had an abortion compared to those who gave birth to a child.
Dr. Skop, let's look at page 31 of your corrected report. That's where you list your corrections, right?
Correct.
Okay. And may we put this up on the screen, Your Honor?
That's fine.
Okay. So this is Exhibit PX 574, Pam, page 31. And we can see in red, you corrected, Dr. Skop, you revised that sentence to note that the study conclusion that someone was 62% more likely to die from any cause following abortion was in an 8-year period, right? You added that qualifier in red font.
Yes, can I just clarify? Because I think I may have misunderstood what you said initially. This report, the entire report has not been corrected. This is still my initial report from May, but the corrections that I made are these here. So
Understood.
Okay.
Understood.
So I did address
Right.
what we had discussed in the deposition.
Right, and so it was pointed out to you in your original report, you said these were statistics for what happens in the year following an abortion, and then you realized, oh, this is actually 8 years following an abortion, and that's why we see it in red text in your list of corrections, right?
That's correct, but as I mentioned, there was a table in the article that did demonstrate increase in deaths as well in that first 6 months, and I added that in the red.
And this study, this Medicaid study, the California Medicaid study you're citing as an alternative to Dr. Grimes, that's studying women who obtained an abortion or delivered a baby back in 1989, right?
That's when that data was from, but again, I've given additional data from European studies, which is even more compelling. So there's quite a bit of data here in addition just to that one study.
We'll get to the other data, but the California Medicaid piece, more than 35 years old, right?
And you will find that that is the case with a lot of abortion studies, that they're quite old.
Dr. Skop, you just have to answer my question so we can keep moving through the process. I'm going to ask the court to direct the witness to do so.
All right. It would be beneficial, not only to getting through what we need to get through, but also just simply to the way you present as a witness, to confine your answer to the question that's asked. All right. Go ahead.
Thank you. So the California Medicaid piece, the first thing you're citing as an alternative to Grimes, more than 30 years ago, right?
Yes.
And that study was limited to the pretty narrow group of low-income women who were on California Medicaid back in 1989, right?
Yes.
And the lead author of that piece is David Reardon, right?
Yes.
That is the gentleman who founded the Elliott Institute that we talked about earlier, correct?
Yes.
Not a physician.
No.
And then, as you just gestured towards a minute ago, the second thing you've offered the court and plaintiffs in questioning the CDC's data on abortion safety is a series of studies from Finland, right?
Yes.
But the Finnish studies do not assess a causal relationship between a history of abortion and any particular outcome, correct?
That's correct.
And you have acknowledged that those studies were intentionally over-inclusive, correct?
That's correct, limited by the data.
And then I want to talk about the third thing you've relied on in opining that Dr. Grimes' data gets it wrong, and that is a piece by Mr. Reardon and a John Thorpe, which we have in your binder marked for identification as PX 410. May we put this up on the screen, Your Honor?
That's fine.
Thank you. And Dr. Skop, PX 410 is a piece of literature you cite in your expert report to support your opinions, right?
That's correct.
And the lead author is Mr. Reardon from Elliott Institute, right?
That's correct.
And this is another piece that you did not reread in the process of drafting your expert report. Again, at the time of your deposition, it had been a couple of years since you read it, right?
If that's what we discussed.
You don't have a recollection of rereading it before you drafted your report, right?
I reread this one frequently, but I do not have a recollection of when I most recently did.
Okay. And if you look at the results section on the first page of this article in the abstract, it's saying that of 989 studies, 11 studies from 3 countries reported mortality rates associated with termination of pregnancy, miscarriage, or failed pregnancy, right?
Yes.
And those 11 studies are the studies that Mr. Reardon and his co-author are relying on for their conclusions about the safety of abortion, right?
Those were all the available studies. Yeah.
So those are the ones they're relying on for their conclusions, right?
That was it, yes.
And those 11 articles did not just examine abortion, as it says, they also were looking at mortality associated with miscarriages and failed pregnancies, correct?
That's correct.
And when you dig into the 11 studies that Mr. Reardon and his co-author were highlighting, 7 of the 11 are from Finland, right?
Yes.
We talked about those a minute ago.
Yes.
2 more are from Denmark,
Yes.
and then there are 2 from the United States, right?
Yes.
And when it comes to the 2 from the United States, we're back to the 1989 California Medicaid piece we talked about earlier, right? That's one of the 2.
That's correct.
And then the second study is a study from 1978 that's more than 40 years old, correct?
That is correct.
Okay. Thank you, Pam. We can take that down. So in addition to opining that Dr. Grimes gets it wrong and abortion is less safe, you in particular highlighted in your direct examination the idea that D&E procedures in particular are dangerous or risky, right?
Yes.
And when people talk about a D&E abortion, D&E stands for dilation and evacuation.
Yes.
And you showed a slide deck during your direct examination with images of a D&E procedure, or at least what you would say is a fair depiction of a D&E procedure, right?
Correct.
And all of those images were of a pregnant patient who was not in the midst of a pregnancy complication or a medical emergency, right?
Those images were specific to the procedure. Since it was a cartoon, we don't know what the woman's situation might have been.
Right, so you showed removal of amniotic fluid, but if you have a patient who's suffering from PPROM, most or all of their amniotic fluid is going to be gone, right?
That could be the case.
And you didn't attempt to show what it would look like in a situation where you have the separation of a placenta in a patient undergoing placenta abruption, right?
No, this was just a standard depiction of a standard D&E.
Right, standard D&E, not a D&E in a patient undergoing a medical emergency, correct?
That's correct.
And you haven't cited any research about whether patients are more likely to die after a medically necessary abortion in a high-risk pregnancy, right? There's not data specific to that.
I believe that there was some data from the CDC, which I don't recall if I put it in my report, that did indicate that a substantial proportion of abortion-related deaths that they were aware of did follow a medical emergency or a complication. But I may not have put that in my report, so.
Now, in offering the court opinions on the safety of D&Es, you have personally never served as the primary physician performing a D&E on a patient carrying a living fetus, right?
That's correct.
You have provided as a primary physician what you would characterize as a D&E on patients carrying a deceased fetus, right?
That's correct.
And you've done that only approximately 5 times over the course of your 30-year career, correct?
That's correct.
Now, you spoke on direct examination about your views on when a fetus can feel pain. Do you remember that?
Yes.
And again, we talked earlier about you are not a maternal fetal medicine specialist, right?
That's correct.
And you've never published a peer-reviewed article on fetal pain.
That's correct.
You've never taught on the subject, right?
No.
And you've never done any work with the International Association for the Study of Pain, right?
No.
And as I think you said on direct, any knowledge you have about fetal pain comes from reading some literature and observing things in your clinical practice that you would observe, that you would characterize as a fetus feeling pain, right?
That's correct. And also just knowing standard care in a NICU of 22-week babies where they treat pain.
But other than performing an amniocentesis, you've never performed an intrauterine fetal surgery, correct?
That's correct.
And you do not consider yourself an expert on fetal pain, right?
I've reviewed the literature. Yeah, you're right. I don't write on it, but I have studied it extensively.
And you do not consider yourself an expert in that area?
I guess it depends on your definition of expert.
Okay. Dr. Skop, let's look at your deposition transcript this time at page 285. Just let me know when you're there.
This is the first deposition?
Yes.
Okay.
I may have said 285. I meant 286. Do you see 286?
Yes, I do.
At page 286, line 15, you were asked, question, do you consider yourself to be an expert on fetal pain? Answer, no, but I've researched it. That was your testimony back in July, right?
That's correct.
Okay, so let's talk about some of the information you identified to support your opinion about D&Es being unsafe. And if I can, I'd like to go back to page 10 of your report, which is PX 574. And Pam, if we could display that. paragraph 35 of your report is an area where you're discussing risks and mortality rates associated with D&E procedures, right?
That's correct.
And then you offer a citation at footnote 39. Do you see that?
Yes.
And that's a citation to an article, excuse me, from 1981, right?
Correct.
And that's more than 40 years old.
That's correct.
And the way that D&Es are provided today is different than how they were provided in 1981, right?
There are some subtle differences, and yes.
Now, you opined on direct examination that it may be better to induce labor than perform a D&E in certain medical emergencies, right?
That's correct.
But there are risks associated with inducing labor, right?
Yes.
When you induce labor, it's impossible to say how long it will take, correct?
That can be the case, yes.
And the longer an induction takes, the more there's a risk of infection.
Not necessarily. It can depend on the situation, but
Sometimes that's true, right?
that can be true, yes.
And sometimes the treating physician may be dealing with an unfavorable cervix that can increase the risks associated with induction, right?
Yeah, an unfavorable cervix would also need pre-treatment, as I discussed earlier, because it would still be unfavorable for dilation for a D&E.
And in certain cases, it's possible the treating physician might need to switch to a C-section, correct?
On a rare occasion, that can happen.
And you would agree that it's more risky to induce labor at something like 20 weeks into a pregnancy than it is at full term, right?
The rate of placental retention is higher
Earlier in the pregnancy.
earlier. Yeah.
Okay. Switching topics a bit, you have a general understanding that this case was filed to challenge statutes in Idaho that prohibit terminating a pregnancy unless certain exceptions are met, right? You have that general understanding?
Yes.
And you understand that the patient and physician plaintiffs I represent in this case believe that those statutes put women's lives and health at risk, right?
I believe that's your concern.
And you emphasized in your direct examination that it's very rare for a pregnant patient to have a life or health-threatening diagnosis that requires abortion care, correct?
That is the case.
But it does happen, right?
Yes.
And for the women and families to whom it happens, it's a very significant event in their lives, right?
Absolutely.
Now, one of the points you were making on direct examination is that enforcement of the abortion ban doesn't actually change the standard of care in Idaho, right?
State's testimony.
Is that a fair characterization?
I think the exception allows the standard of care to continue.
And I understood your testimony to be the statute is clear, physicians should not be fearful about providing abortion care consistent with these exceptions. Is that fair?
That is true.
And you've based your opinions in this case, at least in part, on the clinical experience you have practicing medicine in Texas, right?
Yes.
When Mr. Craig asked you what are the basis for your opinions, at one point you said, I practice under similar laws, right?
That's correct.
And you would characterize Texas as a similar state with a situation similar to Idaho's, correct?
That is correct.
You've said that the Texas legal regime around reproductive health care is similar in many ways to Idaho's.
I don't know that I use that wording, but specifically, we have an exception for the life of, or to prevent the death of the mother. Ours is a reasonable medical judgment, which is actually a higher bar than Idaho's good faith medical judgment, which is a subjective standard.
And you believe that there are some similar demographics between the two states, and you've observed that Texas has some maternity care deserts like Idaho does.
Yes, there's many similarities.
Now, Roe v. Wade was overturned by the United States Supreme Court in a legal case referred to as Dobbs. I think you mentioned it in direct, right?
Yes.
And that happened in June 2022, correct?
Yes.
And I think you mentioned on direct that it was only after Roe v. Wade was overturned that Texas enacted those abortion restrictions you're describing as somewhat similar to Idaho's, right?
Yes, that's true.
And you retired from full-time medical practice in March of 2022, or just before those statutes took effect.
I do still continue to give obstetric care. And also, just to clarify, Texas began implementing its Heartbeat Act in September of 2021, which had the same life of the mother exception. So I did practice under that as well for a time in private practice, and now I'm in as a hospitalist.
Since the Dobbs decision, though, you have not been in full-time medical practice.
That's correct.
And you've been covering 3 24-hour shifts a month as an obstetrician at San Antonio Baptist Medical System, right?
The Mission Trail, yes.
And since you've retired in 2022, you have not had to induce labor in circumstances where you thought there was little to no possibility the fetus would survive, right?
That is correct, because it's rare.
And it's also been more than 2 years since you proceeded with a C-section involving a fetus that was on the edge of viability, right?
Yes, that's correct.
And you've never, either before or after Dobbs, been the primary physician providing a D&E to a pregnant patient carrying a living fetus. We talked about that a minute ago, right?
That's correct.
So you've never personally found yourself in a position where you had to provide abortion care in the wake of Dobbs and justify the circumstances of that procedure to the state of Texas, right? You haven't. That has not happened.
That has not happened, but I would be willing to provide that care if the situation arose.
Now, you do have a recollection of assisting on one D&E procedure on a living fetus over the course of your 30-year career, right?
That's correct.
You weren't able to give a time period for when this happened, but it would have been back when you were working full-time before Dobbs, right?
Yes.
And you recall that in that situation, you found yourself assisting Dr. Lauren Parente, a physician that you practice with in Texas, right?
Lynn, yes.
And you knew her, you'd practiced medicine with her, and you generally respected her judgment, right?
That's correct.
And she determined that she needed to perform the abortion to prevent the death of the pregnant patient, and so you assisted her, right?
That's correct.
You held the ultrasound for Dr. Parente while she did the D&E.
Yes.
You understood that Dr. Parente's clinical judgment in that moment was she needed to perform a D&E, and it was the best procedure for the pregnant woman in those circumstances.
That's correct.
Now, even though you lived through that experience with Dr. Parente, you say now that you can't say one way or another whether it would be an example of a doctor determining in their good faith medical judgment that a D&E was the best option in that moment, right?
I don't recall that statement that you just made. Are you saying that I feel differently now than I would have felt at that time when I assisted her?
Can you say with certainty, Dr. Skop, that provision of care with Dr. Parente was an example of a doctor determining in their good faith medical judgment that a D&E was necessary?
I'm going to object. I'm not sure how this is relevant. My recollection is that was years before any of these laws went into effect.
I guess you can articulate how you think it's relevant, Ms.
Well,
Gibbs.
Dr. Skop is suggesting that physicians should have no fear about practicing under these standards, and I think what I'm eliciting is testimony about that exact issue as it has arisen at times in Dr. Skop's practice, which is the basis for her expert opinions.
All right. Now, the legal regime wasn't in place at the time, and I guess that's the nature of the objection. Is that right?
Yes, Your Honor.
Well, I'm going to permit you to answer the question. Go ahead, please.
If I understand the question, I think I would like to emphasize that at that time, I trusted Dr. Parente in her good faith medical judgment to, based on the facts known to her, to perform that D&E. I trusted that she was doing it based on those reasons to prevent the woman's death. And that is exactly the same standard that is applied today. And just as I did not second guess Lynn, I would not second guess a doctor in Idaho who chose to perform the same procedure for the same reason. And fortunately, as we discussed earlier, it has never happened. No doctor has been prosecuted.
But you told me at your deposition that you wouldn't be able to go in front of a hypothetical medical board and say, I do not second guess Dr. Parente unless you had the benefit of reviewing the patient's entire chart, right? You would need that.
Well,
It calls for facts, not in evidence, and calls for speculation.
She's asserting that this was the witness's deposition testimony. I don't know whether it was or not, but
Which itself called for speculation. My recollection is there was an objection at the time on speculation.
all right. Well, I think we're testing the veracity of the answer just given the previous question. I'll permit the answer. Go ahead.
I think the point that I was trying to make, maybe I was misunderstood, is that
So Dr. Skop, let me just re-ask my question. You told me at your deposition that you would not be able to go in front of a hypothetical medical board and say, I do not second guess Dr. Parente's decision unless you had the opportunity to review her complete chart. Do you remember that?
is this theoretical medical board asking me my opinion about her care?
Yes.
Then I would need to see the records because I cannot answer a hypothetical like that. But I don't think that we're seeing medical boards do this in any of the states.
But when Dr. Parente asked you in the middle of a medical emergency to assist with the ultrasound to protect the life of the mother, you didn't ask to see the complete chart, right?
I trusted her good faith medical judgment.
Isn't it reasonable, Dr. Skop, for clinicians in Idaho to be fearful that if they take action like Dr. Parente did in that moment and provide D&Es in medical emergencies? Sure. Isn't it reasonable, Dr. Skop, for clinicians in Idaho to be fearful that if they take action like Dr. Parente and provide a D&E in a medical emergency, other physicians might similarly hesitate to stand by their decision-making and instead say, well, I got to review the whole chart. I got to comb through everything.
It's not reasonable for doctors to fear that because to my knowledge, that is not happening anywhere in any of the pro-life states in this country.
Now, similar to what you're doing here today, you provided expert testimony last year in a case challenging the Texas abortion restrictions that you've characterized as similar to Idaho's, right?
That's correct.
And in that case, you were an expert for the state of Texas in a litigation filed by Ms. Amanda Zarowski.
Yes, that's correct.
Would it have been a fair characterization if at the time the San Antonio Express was describing you as part of a small but vocal group of doctors helping states like Texas back up new abortion restrictions, even as the medical community at large criticizes them?
Objection, hearsay.
You're asking me if that's what the San Antonio Express News said?
No, I'm asking you if that would have been accurate.
The objection is hearsay. I think the portion that I understand to be objected to as hearsay is what the medical community at large has to say on the topic, and I don't really think that that's really germane at this point. So if you want to rephrase the question to omit that portion, then I'll permit it.
I'll move on, Your Honor. So Ms. Zarowski, the plaintiff in that case, Dr. Skop, was a Texas citizen who was denied abortion care in Texas, even though she was experiencing pre-prom or premature preterm rupture of membranes, right?
Yeah, she had pre-viable rupture of membranes.
And pre-prom is a condition that, in your experience, obstetricians generally understand to be a life-threatening diagnosis, correct?
It can certainly lead to a woman's death, and if the doctor feels in his reasonable medical judgment that it needs intervention, he's enabled to do so.
And when you took the stand at a hearing in the Zurkowski case last year, in support of the enforcement of these laws, you said nothing has changed since these 2 Texas laws took effect, right, in terms of practice on the ground.
I'm going to object beyond the scope of direct.
Overruled. You can answer.
What I said was nothing should change in the practice of a doctor who does not perform elective abortions in general, because the laws allow us to continue to intervene when needed to protect a woman's life.
When you took the stand at a hearing in July 2023, you said nothing has changed since these 2 new Texas laws took effect, right?
Yeah, that was what I was referring to, because nothing has changed seems quite broad, so I wanted to focus in on the fact that our obstetric practice has not changed.
And the gist of some of your testimony here is basically the same. You're saying, Judge, citizens of Idaho, nothing is the standard of care that's available to Idaho obstetrics patients, right?
That is correct.
But yet you acknowledge that Ms. Zarowski's physicians in Texas should have offered her the option to terminate her pregnancy after she was diagnosed with PPROM if they're operating under the standard of care, right?
That is correct.
And even though you were saying nothing's changed on the ground in Texas, you can't identify any times before 2022 where a patient in Texas was diagnosed with PPROM and denied the option of abortion care, right?
So to clarify, nothing has changed in the law that would prohibit a doctor from performing that intervention, but I did not say that doctors have not become confused and fearful, which is the reason that Amanda was not treated appropriately.
Okay, we'll get to that in a minute. I just want to focus on my question. My question is, you are not aware of any examples before 2022 where a patient in Texas was denied abortion care after a PPROM diagnosis, right?
I'm not aware of examples. It may have happened.
And yet your view is that what happened with Ms. Zarowski in Texas should not be understood as an example of the Texas abortion law not working, right?
That is correct. And the Texas Supreme Court agreed with me.
And that's your position even though you're aware that it hasn't been just Ms. Zarowski who's had problems accessing abortion care after diagnosis of PPROM in Texas, right? There's others.
That has happened, but it is not the law's fault.
And I think you mentioned a minute ago that you did observe on the ground in Texas physician confusion and some suboptimal care for women, right?
Yes, and I educated my peers and helped them to understand the law.
After Texas's abortion restrictions were enforced, you observed physicians changing the way they practiced, right?
A few.
And you understood that doctors were frightened and generally reporting that they didn't want to risk a felony charge or losing their board certifications, right?
They were frightened because the law had not been explained to them and had been misrepresented to them.
At the time, you, Dr. Skop, thought there was a big enough problem on the ground that you contacted the medical executive board of the Baptist hospital system begging for some clarification.
I did ask for clarification, yes.
And they told you that lawyers were looking into the problem and you were disappointed in that response, right?
That's correct.
Is it possible or even likely that the Baptist hospital system in Texas is reluctant to provide guidance because of the specter of severe penalties from the state?
No, I don't think so. They did not change their rules and regulations at all on their therapeutic abortion policy. So in other words, they left the standard of care that they previously followed in place for the doctors. They had never done elective abortions. I do not know the reason that there has not been better guidance forthcoming, because I think this is a real liability concern for hospitals who may be allowing medical malpractice to occur.
Now, ultimately, Ms. Zarowski's case led to a ruling from the Texas Supreme Court that provided some clarification that you would characterize as helpful for physicians, right?
That is correct.
Now, despite having witnessed confusion on the ground in Texas last year, you conveyed during your direct examination with Mr. Craig that your expert opinion in this case is the language of the abortion ban is clear and there's no cause for confusion, right?
The language is clear. The cause for confusion has been intentionally stirred up amongst the doctors.
When you say amongst the doctors, are you referring to IAFP and ACOG?
Well, it appears that good guidance has not been given to doctors, particularly about the Supreme Court Planned Parenthood of Greater Northwest versus Idaho decision. Better guidance should have been given. There'd be less confusion.
By who?
You know, in the practice of medicine, it's not unusual for laws to intersect with our practice. And in every other topic other than abortion, our professional societies have given us, in many cases, mandatory continuing medical education requirements to make sure we understood the laws. HIPAA, the Affordable Care Act, EMTALA, there's opioid prescribing, there's numerous examples. This is the first time in my 30-year career that I have not seen guidance on a new law from the professional organizations.
And when you say professional organizations, you're talking about ACOG, among others.
The ACOG could have given guidance. The Texas Medical Board eventually did. That has helped the confusion quite a bit, but that did not happen until June of this year.
Okay, so your view, your understanding as a clinician is that the abortion restrictions in Idaho permit physicians to offer to terminate a pregnancy at a time when a potentially life-threatening pregnancy complication is diagnosed, right?
Specifically, this needs to be a complication that may lead to death, and they're doing this procedure to protect a woman from death, but they do not need to know with certainty that she is going to die.
Do you view the abortion restrictions in Idaho as permitting physicians to offer to terminate a pregnancy at the time a potentially life-threatening pregnancy complication is diagnosed?
Yes, I do.
And that's the standard you're applying when you walk through on direct examination certain scenarios where you say abortion care would be permitted, right?
That's correct.
And it's also your view as a clinician that Idaho law permits intervention to terminate a pregnancy for maternal life-threatening conditions without a requirement that the threat be immediate, right? It's enough that the threat be foreseeable.
That is correct.
You've never spoken to the Idaho Attorney General, right?
No.
And you've never seen any written guidance from the Attorney General or his office on the topic of these laws, correct?
No, I have not. The laws are clear.
And you've never seen any written guidance from any state agency in Idaho on these laws, right?
No.
And you didn't speak to any Idaho County prosecutors before offering opinions in this case about the meaning of statutes, right?
No.
If we could pull up Plaintiffs Exhibit 581 as a demonstrative, it is the text of the abortion ban that's being challenged in this case. It's in your binder, Dr. Skop, as PX 581, and Pam is also putting it up on the screen. Pam, if we could blow up the first sentence of Section 2A1. Okay, so I want to look at the exception in 2A1. It says, the physician determined in his good faith medical judgment and based on the facts known to the physician at the time that the abortion was necessary to prevent the death of the pregnant woman, right?
Yes.
And you said earlier your interpretation of this language as a clinician is that the threat of death doesn't need to be immediate. It's enough if it's foreseeable, right?
That is correct.
Neither of those two words are in the statute, correct?
The word immediate is not in the statute, and that's why we know that it does not need to be immediate, because the wording is not there.
The phrase good faith medical judgment does appear in the statute, right?
Yes.
And your opinion is the phrase good faith medical judgment means, what do I think, based on my own clinical judgment, should be done, right?
That's not just my opinion, that's the legal definition.
It's your opinion that the standard of good faith medical judgment is a subjective standard that affords physicians great deference, right?
That's what I've been told by attorneys, so more than an opinion.
And so your view that there's a subjective standard clinicians in Idaho can apply when operating under these statutes, that's based solely on discussions with attorneys for the state of Texas and subsequent discussions with other attorneys, right?
No, my view is that understanding what good faith medical judgment means allows me to know that that means those things I discussed. My expertise, my clinical skills, my training, and the relevant literature. That's how we practice medicine.
Okay, Dr. Skop, if you could turn to page 265 at your first deposition. Let me know when you're there.
Okay, I'm there.
Okay, we're going to play a video clip of your testimony at your deposition on this point. Who told you that good faith medical judgment is subjective?
This was discussed at length in the Zarowski versus Texas lawsuit.
Who told you that, though?
The attorneys for Texas discussed it with me, but he was there. I believe that there was discussion in the courtroom on this as well.
So you're pointing to another lawyer for the plaintiffs in this case when you say he was there, just for the benefit of the record, right?
Yes, ma'am.
Okay. So your understanding that good faith medical judgment is a subjective standard comes from discussions with folks in Texas and testimony that went into the record during the Zarowski hearing?
Yes, that's when I first discussed it. And,
anything else provide the basis for your understanding?
just subsequent conversations with other attorneys.
What other attorneys?
Objection. To the extent she's probing privileged communications with attorneys that you've had that in which you have not provided expert testimony, but in which you have a privileged relationship, that privilege is yours, and it should not be disclosed. So to the extent that you have anything more to add that's not privileged, you are welcome to do that.
No, I have nothing more.
That was your testimony.
I'm going to object to them playing that. It's not impeachment at all. It's asking about something totally irrelevant. A Texas standard, she's ignoring the Planned Parenthood case in Idaho that directly holds that good faith medical judgment is a subjective standard. I think this whole line of question is improper, and I'd move to strike that last line of questioning and playing of the deposition.
Your Honor, that was square impeachment.
I understood the answers given in court today to not be limited to attorneys in Texas as the source of the information on what good faith medical judgment meant. So I understood that to be the way in which the testimony was alleged to be impeaching. Do I have it wrong? Is there some other way in which it was you're asserting the deposition testimony is impeaching?
Well, I think that's true, but I also think the question I asked Dr. Skop right before I played the video was, your opinion that there is a subjective standard embedded in this abortion ban is based solely on discussions with attorneys, and she denied that. So it's impeaching that testimony that immediately preceded the video.
All right, understood. I'll allow the testimony to stand. You may continue.
Dr. Skop, when clinicians are on the ground in hospitals and other medical environments in Idaho, they can't pick up the phone and call lawyers in the Attorney General's office for guidance on how to interpret these statutes, right?
That's why it would be very helpful for the hospitals to have protocols in place, which most of them used to and probably still do.
Now, you have also opined that in your view, how you interpret these statutes, the reference to good faith medical judgment implies that the standard is whether the physician is acting according to the standard of care, right?
I hesitate to use the word standard of care. I understand in Idaho that's a local standard, but I would go back to what I've said before. It's based on their training, it's based on their experience, it's based on what they know of the literature. So we do know what is the recommended treatment in situations like this.
Dr. Skop, can you look at the second volume of your deposition testimony at page 396?
Yes, I'm there.
And at page 396 of your deposition, we were talking about the statute, and I asked you at line 5, question, standard of care does not appear in the statute that we've marked Exhibit 15, right? Answer, no, but it's implied by good faith medical judgment. That was your testimony just last month when we met for your second deposition, right?
That's correct.
Now, the abortion statute also uses the phrase, quote, necessary to prevent the death of the pregnant woman, right?
Correct.
We talked about that when we met last month, and you told me that in your opinion, that means the doctor has diagnosed a condition that is known to result in death, right?
That is correct.
If we're dealing with a diagnosis that can result in death, but death is unlikely, can the physician intervene?
Right. There's no anywhere in any of these laws that says there needs to be a 50% or a 90%. In fact, doctors can't really predict with that degree of accuracy whether a woman will die, but these conditions that we've been discussing today, pre-viable rupture of membranes, some of these other things, it's well known to every obstetrician that this can result in a woman's death, and so they are empowered to intervene at the time of diagnosis.
And in terms of identifying conditions that are known to result in death, you would rely on ACOG guidance and guidance from the Society for Maternal Fetal Medicine, right?
Among other sources, yes.
And your view is if someone is practicing medicine according to the standard of care by pointing to ACOG or the Society for Fetal Medicine, Maternal Fetal Medicine, Idaho physicians should rest assured that no one's going to come along and second guess their decisions, right?
Yes, that's how the practice of medicine is. We have malpractice litigation hanging over our heads constantly, and we know how to practice if we can point to a source like that to say this is why we did it, then we feel encouraged and empowered that we are practicing correctly. The same thing applies here. If we can show that other reasonable physicians recommend this, it is an intervention we can offer.
Now, there's no reference to ACOG guidance in the statute, right?
Right. The statute gives broad deference to doctors to understand that they can use the knowledge that they may have gained from various sources, but as long as they can document that
Dr. Skop, there's no reference to ACOG guidance in the text of the statute, correct?
No.
And the same is true for guidance from the Society of Maternal Fetal Medicine?
That's correct.
In terms of the standard of care, do you agree that it is clearly the standard of care for any physician to intervene in a pregnancy that presents a risk to the mother's life?
If he believes it would lead to her death, absolutely.
I want to have you turn in your binder to a document that we can mark for identification as PX 599. And that is an expert report that you wrote in 2019 in another litigation before Roe v. Wade was overturned, right?
Yes.
And the landscape of abortion access was very different back then, right?
Yes.
If you go to page 7 of your report, paragraph 37, the second sentence says, it is clearly the standard of care for any physician to intervene in a pregnancy that presents a risk to the mother's life. That was what you wrote in your 2019 expert report, correct, Dr. Skop?
That is correct.
Now, you also acknowledge that it is a moral imperative, regardless of the law, for a physician to intervene in a pregnancy that poses a threat to the life of the mother, right?
That is correct.
In terms of your testimony about what's happening here in Idaho, you are not licensed to practice medicine here, correct?
That's correct.
You've never practiced medicine in this state, right?
No, I have not.
And at the time you wrote your expert report earlier this year, you had been to Idaho only once before, about 10 to 15 years ago on vacation, right?
That is correct.
And before offering all of your expert opinions on how things are working here in Idaho, you didn't speak to any practicing Idaho physicians, correct?
That is correct.
And you didn't speak to any Idaho hospital administrators, right?
That is correct.
And you didn't make any effort to speak with representatives of the Idaho Medical Board, right?
No, I did not.
You did not speak to any pregnant women in Idaho, correct?
That's true.
And you haven't spoken to anyone in Idaho who gave birth in the last 5 years, correct?
That is correct.
And before offering your opinions in this case, you didn't do anything to examine what protocols at Idaho hospitals and birthing centers looked like before Dobbs in terms of how they were handling life-threatening emergencies, right?
That's correct.
And you didn't do anything to review maternal mortality review committee documents from Idaho either, right?
No, I did not.
Now, you agree that when you're on the ground practicing obstetrics day to day as a clinician, you can't say with certainty whether a condition has a 10% chance of leading to death, a 50% chance, or a 90% chance, right?
That's correct.
Every patient is different, and there are a lot of factors that will drive the health outcome for any particular patient.
That's correct.
And pregnancy will often exacerbate, I think you talked about this with Mr. Craig, conditions or symptoms that might be stable in non-pregnant patients, right?
Yes.
And different patients' conditions do not progress at the same rate, right?
Yes.
And sometimes a patient will experience a combination of medical conditions or symptoms that all come together to be life-threatening.
Yes.
And there is no uniform sign or symptoms of a medical emergency.
That's correct.
For example, patients can appear to be stable and then demonstrate deteriorating health.
Yes.
Now, we talked about PPROM in the context of the Zarowski case, and you also addressed it a little bit with Mr. Craig, right?
Yes.
If you have a pregnant patient with ruptured previable membranes, but no infection, you agree that because she's been diagnosed with ruptured membranes, that's a condition that can lead to death,
Yes.
she can legally be offered abortion care in Idaho.
Yes.
And that's your view, even though the risk of death may be relatively low, since there's currently no infection in that hypothetical patient.
As you just stated, things can go bad quickly, and we recognize that in medicine. So she could be offered care at the time of diagnosis.
And you would say that offering abortion care to a woman diagnosed with previable ruptured membranes but no infection is consistent with reasonable medical judgment and the standard of care.
Yes, it's in all of the literature.
Now, there's also a high likelihood, though, that patients with ruptured membranes will spontaneously go into labor, right?
That is true.
And if you're going spontaneously into labor, you don't need an abortion, right?
That's correct. That's why the law says, based on the facts known to the doctor at the time, he doesn't know if she's going to go into labor. He needs to make his decision without that knowledge.
Isn't it possible that the state could take the position that a clinician shouldn't have proceeded with abortion care on a patient experiencing pre-prom because odds are they would have gone into spontaneous labor? That was the most likely outcome?
I don't think there's any evidence that any state, particularly Idaho, is attempting to second-guess doctors' clinical judgment. I haven't seen any evidence of that anywhere.
Dr. Skop, in your binder, there's a document stamped PX 597. Can you take a look at that?
Yes.
And this is a letter dated March 27th, 2023 from the Attorney General of Idaho, Mr. Labrador, to a member of the Idaho House of Representatives, right?
Objection beyond scope of directive says no relevance to any of her testimony.
Your Honor, I think the relevance is quite clear given what she's been testifying about on direct.
All right, which portion of the letter are you going to refer the witness to?
I'd like to understand if the witness has seen this letter before. That's my first question.
No, I have not.
Get her to answer that question. She has. Go ahead. What portion of the letter do you intend to refer the witness to?
And then I wanted to take a look at the third paragraph of the letter. And my question is just simply whether Dr. Skop would acknowledge that correspondence like this from the State Attorney General could contribute to fear among Idaho providers about providing care under these statutes.
All right. If
Your Honor, this is beyond the scope of direct. This letter has been withdrawn by the Attorney General, and it has no relevance to her opinion. She testified she hasn't seen it at all.
all right. So it's not beyond the scope of direct simply because it's a letter that was not discussed on direct. It relates to a concept that was discussed on direct. I'm going to permit the question concerning the third paragraph.
Can you re-ask the question?
Is it possible for the court reporter to read it back? I'll re-ask the question.
I think the question is whether Dr. Skop would acknowledge that correspondence like this from the State Attorney General could contribute to fear among Idaho providers about providing care under these statutes. If you can answer that question.
I don't think this should contribute to any fear related to performing an abortion for life of the mother. This appears to be related to an entirely different abortion limitation, which is on medication abortion pills. It's not related to what we're discussing.
Your Honor, plaintiffs do offer Exhibit 597 into evidence as a party admission.
Your Honor, it's irrelevant to anything that we're talking about. It's been withdrawn. And the Attorney General is not a current defendant in this case.
All right. This came up, of course, earlier in the course of the proceedings, and there isn't, I think, any more substantial basis for admitting it now that has been shown. I will again decline to admit the exhibit.
You discussed triploidy on your direct examination with Mr. Craig?
Objection. I don't think we did discuss triploidy.
Did you discuss triploidy during your direct examination with Mr. Craig?
As rephrased, you can answer the question.
I don't believe we discussed that.
Fair enough. You discussed fetal conditions during your direct examination, right?
Yes, some.
And triploidy is a condition associated with a non-viable pregnancy, right?
Yes, specifically, it's a type of a molar pregnancy as well.
And triploidy is linked not only to a type of a molar pregnancy, but also a maternal condition called gestational trophoblastic disease, or GTD, right?
Yes, that GTD is another word for molar pregnancy, and these are molar pregnancies are listed as exceptions in this law.
And the law references molar pregnancies. There's no specific reference to partial molar pregnancies, right?
Right. I think it was meant to be inclusive of different types of molar pregnancies.
And so it's your expert opinion that if a patient is diagnosed with GTD or a partial molar pregnancy in Idaho, the pregnancy can lawfully be terminated.
I believe so.
And you acknowledge that the immediate removal of the abnormal tissue and the fetus is the standard treatment for GTD, right?
That is correct.
Every obstetrician you know would intervene to evacuate the uterus on diagnosis of GTD and triploidy, right?
That is correct.
You have an understanding that one of the patient plaintiffs in this case was diagnosed had a fetus that was diagnosed with Turner syndrome affected by high drops, right?
Object beyond the scope of direct. She's not testified about that, and the court has specifically prohibited plaintiffs from presenting testimony on their specific conditions from a medical source.
All right, where does this go?
I just have questions for Dr. Skop about the opinions she's offered about Ms. Adkins' medical history.
Offer them at trial.
She has not offered them at trial, Your Honor. I believe it falls in the bucket of things that we could ask in our rebuttal case if we were to recall Dr. Skop. And
I don't think it does because we've not had any evidence on cross-examination or on.
Sustain that objection.
you talked about preeclampsia on your direct examination, right?
Yes, ma'am.
And you've had patients in your clinical practice develop severe preeclampsia before their fetus was viable.
I don't recall that I have. I've seen it at very early gestational ages, but I believe in all of those situations, I've been able to deliver the baby and hand the baby to the neonatologist for care.
So your testimony is you've never had a patient develop severe preeclampsia at a pre-viable age?
I don't believe I have. It's extraordinarily rare for it to happen before 22 weeks, which was the gestational age where my NICU would try to resuscitate a baby.
Dr. Skop, let's look at the first transcript of your deposition at page 292. At page 292, line 1, you were asked, question, have you ever had a patient develop severe preeclampsia at a pre-viable age? Answer, yes. Question, have other practitioners in your practice? Answer, yes. That was your testimony when we met in July, correct?
That appears to be the case. I had forgotten. Either I missed.
Skop, that's just my question.
Okay.
Preeclampsia is a medical condition that can progress quickly.
Yes.
And you can have a patient with normal blood pressure who then a couple of hours later you're diagnosing higher blood pressure, right?
Yes.
And a woman who's at risk of preeclampsia or who has been diagnosed with preeclampsia can go from a normal blood pressure reading to severe preeclampsia in a very short amount of time, right?
That can happen. It's unusual that fast, but yes, it can happen.
And in your expert opinion, a diagnosis of preeclampsia with severe features is sufficient to offer a patient abortion care in Idaho, right?
That is correct.
And that's true even though the risk of dying of severe preeclampsia is ultimately pretty low.
Yes, but it is known to cause maternal deaths.
And in your opinion, there may be scenarios where the existence of a significant risk of developing preeclampsia, the risk of development may be sufficient to warrant offering abortion care in Idaho, right?
You're saying just we think she's high risk, but she does not have the disease yet?
Correct.
That seems unlikely to me, but again, the law allows the doctor who's on the ground to use his own clinical medical judgment to determine if that intervention is needed. Again, based on some of the plaintiffs, the doctor on the ground could have made that determination, but it's hard for me to make that without all of the data in front of me.
There may be scenarios where the existence of a significant risk of developing preeclampsia would be sufficient to warrant offering abortion care in Idaho, correct?
Just the possibility of developing a pregnancy complication to me seems like quite a stretch to say that we should offer abortion care in that situation.
Dr. Skop, can you look at the transcript of your second deposition, this time at page 451?
Yes.
At page 451, line 15, you were asked, question, there may be scenarios where the existence of a significant risk of developing offering abortion care in Idaho. Answer, yes, I would say that there may be scenarios. That was your testimony just last month, correct?
This was specific as we were
Dr.
discussing
Scott, was that your testimony last month?
regarding that specific patient.
Okay. On your direct examination, you talked a little bit about mental health outcomes in women who have abortions, right?
Yes.
And you are not a psychiatrist or a psychologist, correct?
No.
And you would never be the primary treating physician in circumstances where a pregnant woman suffering a mental health crisis needs to be hospitalized.
That's correct.
You cited your husband's practice in mental health, but of course conversations over dinner are not the basis for expertise, right?
Yes, based on your definition.
And you would never sit down in a courtroom and say to a judge, I am a mental health expert, right?
That's correct.
You are aware that there is seminal literature out there concluding that there is no causal connection between abortion care and mental health outcomes, right?
Yes.
And the National Academy of Sciences, Engineering, and Medicine, for example, has concluded there's no causal connection between abortion and mental health, right?
Yes, they've also concluded that there is no therapeutic benefit.
Thank you. And you acknowledge that the National Academy has accurately reported the data from the studies that they rely on to support their conclusions, right?
The limited studies, yes.
The American Psychiatric Association has also concluded that there's no credible evidence that a single elective abortion of an unwanted pregnancy will in and of itself cause mental health problems for adult women, right? That's their conclusion.
That was their very nuanced conclusion.
And a study known as the Turnaway Study concludes that women who obtain abortions fared better than women who were turned away from abortion access and carried their pregnancies to term, right?
Yeah, this small group of 500 women found that.
And you acknowledge that the conclusions of the National Academies and the APA and the Turnaway Study were accurate. Your criticism is that you believe those involved in those publications should have called for more studies rather than offering conclusions, right?
The NAS based their conclusion on 5 studies out of about 160.
So it's a volume issue.
If all of the 155 studies were poor quality, they should have called for more studies.
Now, in rendering your opinions about what you say are negative mental health outcomes associated with abortion, you offered a few sources that you cited on your testimony and you put in your report, right?
Yes.
I want to go back to your report, which is marked for identification as PX 579. And if we go to page 21, I want to look at paragraph 68.
Is it 579? Because that's
I'm sorry,
induced
574.
abortion. Okay. Sorry, what page?
574, page 21.
Okay.
Paragraph 68, towards the bottom of the page, you have a sentence supported by footnote 90. Do you see that?
Yes.
You say 75 peer-reviewed studies exist in the literature from the past 25 years, 49 showing statistically significant increased risks of mental health disorders after abortion, right?
Correct.
And then your citation at footnote 90 is a bulletin from the American Association of Pro-Life Obstetricians and Gynecologists. That's one of your sources, right?
Yeah, that was a summary bulletin referencing quite a bit of peer-reviewed literature.
and opinions on abortion and mental health, work by a researcher with the last name Ferguson, right?
That's correct.
You cite his work from 2008, correct?
Let's see, which reference was that?
I'm sorry, 2018. No, 2008.
Yeah, he had a number of studies, 2006, 2008, 2013, so yeah, he had quite a bit of research on that.
Right. And if you look at footnote 74 to your report, tell me when you're there.
I'm there.
There's a citation to Ferguson from 2008, right?
That is correct. Let's see. Also, there is a 2013 citation. Yes.
Where's the 2013 citation?
Immediately above that. It's the second citation under that footnote. Does abortion reduce the mental health risk of unwanted or unintended pregnancy? A reappraisal of the evidence.
And you're aware that when Ferguson reanalyzed his data in 2013, he concluded that the data did not support an increased risk of mental health disorders in women having abortions as compared to women giving birth, right?
I'm not aware of that. I believe that reanalysis did continue to support the evidence that there were some women who had increased, I believe, anxiety and substance and alcohol use.
Dr. Skop, can you turn to your first deposition transcript at page 280, please? Page 280, line 21, question. You're aware, Dr. Skop, that in 2013, when Ferguson reanalyzed the data from his prior study, he concluded that the data did not support an increased risk of mental health disorders in women having abortions compared to women giving birth. Do you see that?
Yes, I do.
And you answered yes, right?
Yeah, at the time, I didn't remember. I was just
Dr.
agreeing
Skop,
with
that
you,
was your
but I went back.
testimony,
I went
right?
back and reread it.
Dr. Skop, my question is just whether that was your testimony at your first deposition. It was, right?
And I've changed it because I've reread it.
Okay, and Mr. Craig can ask you about that.
Okay.
And none of the literature you're relying on covers the mental health of women who are required to continue pregnancies involving non-viable fetuses, right?
Yeah, sadly, as I mentioned earlier, no one has ever done the comparison between the women who aborted and those who carried their children with life-limiting fetal conditions, except for that one small study at Duke University, and it was solely limited to anencephalic infants. So definitely there's a need for that type of research.
Okay, and then I want to hopefully wrap things up here by addressing what you referred to in your direct examination as palliative care, right?
Okay.
And that's a concept where a pregnant patient who's faced with a fetal diagnosis that's incompatible with life carries the fetus for as long as possible and then delivers so that the family can have time with the baby, right?
Yeah, I would take exception with incompatible with life for the reasons that we discussed earlier. So these are children with disabilities who are anticipated to have a shortened life.
Does palliative care in your mind also apply to situations where you have a fatal fetal diagnosis?
So palliative care in general is helping a human being who has a diagnosis that's going to limit his life. There's not really built into the definition how long that life is going to be.
And you spoke about some benefits of benefits for families who affirmatively choose palliative care, right?
Yes.
And those are studies, though, of families who are choosing affirmatively choosing palliative care. They were given the option, right? And they decide to go that route. The studies aren't studying families who are forced to go that route, right?
No, that research has not been done.
And as a physician, you have been involved in terrible situations where a very much wanted baby is delivered and dies shortly after childbirth, right?
Yes, I have.
And so you know firsthand that that can be very distressing and traumatic for parents to witness, right?
I think the diagnosis in and of itself is very stressful. The answer that we don't know is what is the best method of managing that situation, because we have not studied it.
But also the process of delivering and then watching your baby die can be distressing and traumatic for the family,
Of course.
of course. And the process of death can also cause pain to the baby.
Presumably, again, we don't know exactly what a baby experiences, but perinatal palliative care does work very, very hard to minimize the pain that that baby might experience.
You do recognize, though, Dr. Skop, that certain families may consider both palliative care and abortion care and decide that they are most comfortable terminating a pregnancy, right?
Of course, people do choose that.
And when a woman finds herself in a situation where she's deciding between palliative care and abortion care, the pregnant woman and her family are, of course, best positioned to decide between those two options, right?
Currently, that is not an option in Idaho law. The appropriate recourse would be with the legislature if there were desires to make a change in that.
Move to strike Dr. Skop's reference to the legislature.
Denied.
Your Honor, at this point, plaintiffs renew our objection to Dr. Skop's testimony on medical ethics, fetal pain, and mental health on the grounds that we don't think she's qualified as an expert in those areas. So we renew our objection, but subject to that, I think I have no further questions at this time.
All right, understood. Unless a reason presents itself not to, my intention at the moment is to consider those issues further through post-trial submissions. All right, redirect, Mr. Craig.
Yes, Your Honor, thank you.
Thank you, Dr. Skop.
Thank you.
May I have the standard to the witness?
Thank you.
Dr. Skop, do you recognize the document's been handed to you?
Yes, I do.
What is that?
This is, I'm not sure its legal name, but this is a letter from the attorneys that are representing our research group to the SAGE journals.
This is the petition to compel arbitration that your attorneys filed on your behalf and on behalf of the other people in the case that you were asked about on cross-examination. Is that correct?
That's correct.
Your Honor, at this point, I'd ask a copy of this be admitted into evidence to show context for the document that they had admitted.
All right, and do you have an exhibit number?
I apologize, we do not have this marked, so it will need to be a new marking.
All right, we'll have it marked. I'm not sure where your exhibit list left off in terms of what was the last numbered exhibit on your exhibit list.
1058 is the next one, Alexis said.
It'd need to be 1058, is my understanding.
58 would be the number you'd apply to this exhibit.
Yes, Your Honor.
Understood. So 1058 is being offered for the limited purpose of context for understanding Plaintiffs Exhibit 582 admitted during the course of Dr. Skop's examination. Any objection to it for that purpose only?
I think it's fine as long as it's clear that it's also not offered for its truth. Yeah.
That's agreed.
Yes, Your Honor.
All right. Exhibit 1058 is admitted not for truth, but for context that helps in understand Plaintiffs Exhibit 582.
And Dr. Skop, you've testified that there were 3 reasons that were given by the journal for retracting your articles. Is that correct?
That seems to be the case, yes.
And one of those reasons was they said that you failed to disclose a conflict of interest. Is that correct?
That is correct.
And could you please describe why you do not believe that is a good reason?
So again, I'll refer to the Committee on Publication Ethics because this is the body that governs the very serious action of retracting a peer-reviewed paper. As we can imagine, that is very damaging to the reputation, as has been assumed today. And they say that that you should check the box conflict of interest if you obtain outside financial reimbursement, essentially, for the research. So, for example, if I was a consultant for an abortion manufacturer, like Daniel Crennan is, then I should check conflict of interest, because if I publish a study beneficial to that product, that's going to make me money. So that's been the traditional understanding of conflict of interest. They specifically say if your employer pays for the study and you don't make any additional money from it, this is not a conflict of interest. So accordingly, we have never checked conflicts of interest because that is the guideline given us. I do want to point out, since I didn't get a chance to earlier, one of our studies that was also published in Health Research's Managerial Epidemiology, the paper that retracted 3 of our papers, was not retracted, and we also had the same non-conflict of interest disclosure. So they were not consistent within their own organization. They targeted these studies for retraction.
Can you please also discuss the double-blind peer review process that was involved in those articles?
Yeah, so as its name implies, double-blinded, the person doing the peer review does not know the identity of the authors, and the authors do not know who is reviewing their studies. And that is the protocol for SAGE journals. As I mentioned earlier, the pro-life research community is relatively small. And so, of course, it could be the case that we know each other, but we still don't know who reviewed it. And that person presumably did not know that was our study. But that was one of the reasons that the journal gave justifying retraction. If there was any malfeasance done, it was on the part of the journal, because we never knew who that reviewer was and still don't to this day. So obviously the conflict of interest and the double-blind peer reviewer excuse are just that. They're excuses. And as I mentioned earlier, they have not demonstrated falsification, fabrication, misrepresentation on any of our studies. The allegations that have been made by researchers from pro-abortion organizations like the Guttmacher Institute.
You turn to Exhibit 575. This is your copy of your curriculum vitae or your resume, is that correct?
Yes, I'm there.
See the article. I believe there's some questions asked of you on direct cross-examination about your misleading statements about life of mother exceptions and pro-life laws require correction. Do you see that?
Yes, I do.
And what was the purpose of writing that article and getting it published?
Yeah, thanks for giving me the opportunity to discuss that, because this was very concerning. The Obstetrics and Gynecology, the Green Journal that we discussed earlier that is published by ACOG, published an article by an EMTALA expert, and it specifically discussed Idaho's law, pro-life law and Texas pro-life law in relationship to EMTALA. And there were many erroneous statements made, including the statement, as we've discussed, that the woman had to be dying, that the doctors had to wait until her life was, essentially ending, which is incorrect. And so when I saw that, I was upset because I recognized that doctors in both Idaho and Texas read this journal, believe what they're told to be correct, and this was blatantly false. So I wrote, along with an attorney who is very knowledgeable in the laws, a response to this, correcting the misstatements that they'd made. I submitted that to the Obstetrics and Gynecology Green Journal, and it was rejected within 24 hours without explanation. So then I submitted it to Issues in Law and Medicine, where it was published. But that's very concerning that the ideology of that journal would refuse to correct something that had been demonstrated to them as incorrect and has such potential for causing harm to women and their children as that.
And the attorney that you mentioned working with on that article, is that your co-author listed here, M. Harned?
Yeah, that Mary Harned. Mm-hmm.
Can you turn to Exhibit 410 that plaintiffs had you look at?
Is this the original?
Okay.
And you were asked some questions about this on cross-examination, correct?
Yes.
And could you read you see the paragraph that starts with results on the first page?
Yes, I do.
Could you read from that paragraph starting, it looks like it's the second sentence, within a pregnancy outcomes. Can you read from there to the end of that paragraph, please?
Within a year of their pregnancy outcomes, women experiencing a pregnancy loss are over twice as likely to die compared to women giving birth. The heightened risk is apparent within 180 days and remains elevated for many years. There is a dose effect with exposure to each pregnancy loss associated with increasing risk of death. Higher rates of death from suicide, accidents, homicide, and some natural causes such as circulatory diseases may be from elevated stress and risk-taking behaviors.
If you could go to the second page. See, there's a definition section there.
Yes.
See, there's a definition of pregnancy loss.
Yes.
And pregnancy loss, can you read that, please?
Pregnancy loss as used herein includes all pregnancy outcomes that do not end in a live birth.
So that would include abortions in addition to other pregnancy losses?
That is correct.
You were asked questions about, since the Dobbs decision went into effect, if you have ever had to perform an abortion and justify that abortion. I want to explore that a little bit. Can you describe your experience as a hospitalist that you've been doing for the last several years?
When I am working there, I'm available for any obstetric gynecology needs within the hospital. That can include covering for the private doctors, seeing their patients, evaluating their patients, delivering them, covering for women whose doctors don't go to that hospital, or very frequently women who have no prenatal care, and doing the obstetric care for them. As well as going to the emergency room for emergencies like ectopic pregnancies, miscarriages, other gynecologic problems.
And how often are you working in the hospital there?
I generally do about 3 24-hour shifts a month.
You've been doing that for the last several years?
Yes, for 2 years, 2.5 years.
And during your time there, have you had to treat women with pregnancy complications?
Yes, I have.
Have you had to treat women with high-risk pregnancies during your time period there?
Yes, I have.
And you testified earlier that the need to provide abortions is exceedingly rare. Is that correct?
It is very rare, yes.
Is that why you've not had to provide any abortions in your time there, because of the rarity of the need to provide abortions?
That is the case because I am just working part-time. I've seen a patient that I thought I might need to provide an abortion. She did come in with ruptured membranes at 17 weeks. And I was, preparing to talk to her about the options. I obtained a sonogram and discovered that the baby had already passed away. And so at that point, I gave her standard obstetric miscarriage care. But had the baby been alive, based on her clinical presentation, I would have offered her that option.
There's some discussions about good faith medical judgment. You're familiar with the Planned Parenthood case. We've talked about that several times.
Yes.
And you're aware the Idaho Supreme Court in that case says that good faith medical judgment is a subjective standard?
Yes.
And who is the best person to make the decision based on the good faith medical judgment whether an abortion is necessary to prevent the death of the woman?
That would be the treating physician who knows the patient.
And the treating physician would have all of the facts available at the time?
They would gather the facts that they needed to make a decision, yes.
You were asked questions about preeclampsia, and you're specifically referred to a portion in your deposition testimony about whether you've ever had a patient develop severe preeclampsia at a previable age. You said yes, but then you're starting to say that you were wanting to explain that answer. Can you please explain that answer?
Well, one statement that I want to make is that according to ACOG's practice bulletin on preeclampsia, they don't even consider the diagnosis of preeclampsia to be fitting unless the blood pressure elevations have occurred after 20 weeks gestation. And, as I mentioned, generally we consider a baby to be around viability at about 22 weeks gestation. So that at that very, very early gestational age, the disparity in my testimony may be that I didn't recall really whether I've taken care of patients at that very, very early gestational age. But because it is so exceedingly rare to see preeclampsia with severe features that requires delivery so early.
You were asked a series of questions on cross-examination about studies relating to mental health and their connection to abortion. Is there anything about those studies you would like to explain?
Well, I've kind of alluded to this throughout the day, but it's very, very difficult to study many things related to abortion. A gold standard study in medicine is what's called a randomized clinical trial, where one arm of patients gets one intervention, the other gets another intervention. And of course, that would be unethical to do that with women seeking abortion. And of course, many times we don't even know who's had abortions. So many of the studies are limited by factors such as that, particularly mental health, because again, it is so common in the reproductive age population of women. Additionally, women who are in crisis and seek abortion may have some mental health concerns already. So sometimes the question becomes, was it cause or effect, or, but what is undeniable, and I think the APA's statement that I mentioned was so nuanced, really alludes to this, is that there are subgroups of women who are widely known to be at risk for mental health complications after abortion. That is women who have multiple abortions. That is women who have later abortions after the first trimester. That is women who abort a wanted pregnancy, because many times for various reasons, maybe because of the fetal anomalies or because of coercion, women end pregnancies that they strongly desired. And of course, women with prior mental health conditions are known to be at risk as well. So all of those things are well known. We do know there are women at much higher risk. That's why the APA, trying to make it look safe, said there is no evidence that a single elective abortion in an adult woman early in pregnancy, because they knew they were excluding all of those categories of women that were known to be at higher risk.
So it's your opinion that causing an abortion can have a risk of mental health issues for the women?
It's more than my opinion, because I've had patients tell me that they developed anxiety, depression, substance abuse because of their reaction to the abortion. So I think the clinical evidence shows us that some of the research, again, the research is a little bit cloudy, but I believe those women when they tell me that they are suffering what they're suffering because of their abortion.
You're asked questions about Ferguson studies and Ferguson's retracting some of his earlier conclusions. But then you stated you're starting to say that you went back and you reread that study. So can you explain that?
So he had 4 studies, and one of the studies was criticized. Many times a criticism of these studies is appropriate control groups. Like, should we be comparing the women who have abortion to women who carry an unintended pregnancy, or, various study groups? So he did make some modifications in his study designs based on earlier criticisms, but ultimately, when he had the last 3 studies that he published were considered to be quite high quality, and his conclusions were that there is approximately 30% increased risk in mental health complications following abortion after he controlled for many factors. And another thing that made him unique, we discussed how almost everybody doing research in abortion has a bias. That doesn't mean that the research can't be good research, but acknowledging that, everybody has an opinion, I think, about this very controversial issue. But David Ferguson was pro-choice, and yet he was still willing to go forward and publish his research despite that, because he felt the public needed to know what he had found, and that some women did suffer mental health complications after abortion.
So as relevant here, including the most recent one where he went back and looked at the data, what were the conclusions as relevant to your opinion?
He found that approximately 30% increase in the risk of anxiety and in substance abuse and alcohol abuse in the women who had abortions.
So Dr. Skop, you've been a practicing obstetrician for 30 plus years, is that correct? Or approximately 30
That's
years?
correct.
And you've delivered over 5,000 babies?
I believe so.
Treated tens of thousands of pregnant women?
Yes.
And you've practiced in Texas that has a law very similar to Idaho's law?
Objection, Your Honor. We're retreading ground that's been tread. This is feeling like a summation.
That's correct.
Overall, you can answer. All right.
That is correct.
In fact, you testified that Texas's law is actually a reasonable medical judgment standard, which is higher than Idaho's good faith medical judgment standard.
Yes.
And it's your opinion that Idaho's Defense of Life Act does not
Objection,
prohibit.
leading.
I suppose you're going somewhere you've already gone, which may be making Ms. Godesky's past point. Otherwise, you wouldn't be phrasing it in a leading way. But you ask the question you want. If you can finish your question.
Thank you. And it's your opinion that Idaho's law does not prohibit or does not prevent Idaho doctors providing necessary care for women to save their lives?
That is correct.
Leading.
Overruled. I'll consider the answer.
Thank you. I don't have any other questions.
All right. Thank you, Mr. Craig. Any recross? Ms.
Nothing
Godesky?
further from me. Thank you.
All right. Thank you for being here, Dr. Skop.
Thank
You
you.
can step down.
Pleasure.
Defense rests, Mr. Craig?
Likely, if we could do like the plaintiffs, if we could have the evening and then make the final decision tomorrow morning.
All right, well, I'm certainly not necessarily adverse to that, but what it does cause me to want to ask whether there is expected to be any kind of rebuttal case at this point.
Well, so yes, and what our rebuttal case looks like may depend upon what the state does tomorrow, but given our anticipation that they may rest, we believe we can complete that rebuttal case in a half a day. Maybe it would lapse into early afternoon, but we're quite confident we can complete this trial tomorrow.
All right. So, well, given that the choice I'm likely put to is not between closing the evidentiary record entirely and not, but just forcing the state to rest. Or not forcing the state to rest when there's going to be some evidence presentation tomorrow anyway, it would seem that the same sort of approach as was taken during the plaintiff's case ought to be taken now. So we'll just simply recess, and the state can inform us in the morning whether there will be a rebuttal case or whether there will be any further witness presentation. If there is going to be something, please notify opposing counsel as soon as possible. All right. Anything else before we break?
A couple very brief matters, Your Honor. I think at the pretrial conference, the court indicated that you did not necessarily believe that closing arguments would be helpful in light of the fact that the parties would be submitting proposed findings of fact and conclusions of law. I think you also said you'd indulge us if we wanted to do them. I would say we've come around to your way of thinking. Unless the court believes closing arguments would be helpful, or if the state plans to present a closing argument, we would do the same, but otherwise we're content to make those proposed findings and conclusions of fact and not present closing argument tomorrow.
All right. Well, you tell me, Mr. Craig, if that's agreeable to you, it's certainly agreeable to me. I think the utility is highly limited, for sure.
I'm agreeable to that, Your Honor. Thank you.
All right. So there will be no closing arguments after all. When the evidence closes, we'll discuss what the protocol will be for post-trial presentation of proposed findings and conclusions, and go from there. So it's been. I don't remember if we've discussed it before, but my guess would be that you all would want to order the trial transcript and have it for some period of time before you are expected to come forward with proposed findings and conclusions. That approach, assuming that's what you want to do, is certainly fine with me. So there's some lead time for obtaining the transcript. I don't really know exactly what that would be, but what we'd probably do is confirm that y'all do want to go in that route, and if so, set some period of time for you to have the trial transcript before you are expected to come forward with proposed findings and conclusions. And then, I don't know, perhaps this is a case where it's normal. What I've normally done is just had simultaneous submission of proposed findings and conclusions, and that's it. But maybe this is the type of case where circumstances suggest that there should be something beyond that, some opportunity to respond to one of those proposed findings and conclusions. I'm open to the idea. So those are just my, I guess, basic thoughts about how things might proceed. So
a mechanical issue tomorrow. We potentially may call two of our experts who testified in person in our case in chief. They're out of state, and I think we discussed with the court having them appear remotely, and we would be prepared to do that tomorrow, and we'd work with your staff on having that set up. So just wanted to alert the court to that issue.
Okay, understood. I'm not against that in concept. We did discuss it before, and staff will be headed out not long after we recess, but you're welcome to have a quick conversation to try to make sure that all is squared away along those lines.
And then lastly, Your Honor, and I know we talked a lot about Doctors Hughes and Story, and there were many objections made during their testimony, but I just want to make sure we have a clear record here. And so on behalf of plaintiffs, we moved to strike both of their testimony in full. We submit that the testimony that they offered was not impeachment testimony. It was not offered to undermine the credibility of specific plaintiffs' witnesses. The definition I think that Your Honor used for impeachment testimony, and on that basis, we now move to strike both of their testimony.
Let me ask you this. Does it have anything to do with the shape of any rebuttal case that you would present, whether it's struck or whether it's dealt with as a post-trial issue in terms of findings and conclusions?
It could.
All right. Well, I'm not sure what to say. I think that I've been clear that what its limiting effect is. And if I could also, I guess, be clear in saying that I don't think that that testimony was significant by either witness, and that's not any slight intended to either witness. The ground rules were impeaching effect of the testimony, and that was the only effect for which any of that testimony could be considered. Now, I don't know if Mr. Craig can convince me that there was some particular way in which it was genuinely impeaching versus some form of rebuttal, but it's, I think, an issue that is so vanishingly small in relation to the overall body of evidence that has been presented. It's just I just don't see much to commend further discussion of the issue or pursuing it further. That said, I guess I'm not prepared to say that there's not some small portion of it somewhere that was offered for impeachment purposes legitimately, and that may be argued to have impeaching effect. I don't view it, whatever it was, as having had any significant tendency to undermine the credibility of the plaintiff's witnesses. So that's my take on that particular that particular evidence. I'm not. That said, I'm not inclined to just simply strike it. So, all right. Anything else?
No, sir.
We'll see you tomorrow, 9 o'clock.
All right.